And Mr. Sokushati Chaudhuri, I'm a senior advocate and special officer, Milord.
Yes.
The fact is, Milord, firstly, Milord, he refused to accept the assignment yesterday when we went to him, and there are two technical mistakes, Milord, in the order, which should be rectified by your lordship. So let it appear as and non Yes, Mr. Chaudhuri is here. Yes.
Milord, I am extremely grateful. Milord, Lordship had appointed me as a special officer to conduct an election. Milord, there may be a conflict of interest. I had indicated to them because, Milord, I am involved in the Apartment Ownership Act in Milord, some of the major things, and Milord, these people have on and off come and taken advice.
Okay.
So there may be a conflict of interest. Lordship will kindly, Milord, consider.
Okay.
I am deeply.
Monday to be mentioned. Monday to be mentioned.
Grateful. Monday, Milord.
May I be permitted to mention item number 551 on today's list? 551. Malad, the urgency of this, Malad, this matter relates to Malad settlement of government ferry guard. Malad, initially this matter, after taking leave from the Honorable Justice sitting in court number 24, Malad, I filed this application before court number 24. That was released into want of determination. Thereafter, my lord, this matter regarding my lord settlement of ferry guard, my lord, in spite of having all requisite qualifications, my lord, I was not allowed to participate in the my lord said my lord tender process, my lord. So,
When the tender was floated?
My lord, tender, my lord, 3rd November. 3rd November.
The process is over.
Over.
Then what?
No, my lord, what my lord, I made representation to the authority concerned.
After the tender, what representation? If you
My lord, I was not allowed. I was not allowed to participate. Thereafter, my lord, I made representation. They, my lord, thereafter, they, my lord, completed the tender proceeding, my lord.
Correct. So what remains in the writ petition? What your challenge?
My lord, the allegation, my lord. Allegation is
already the work order is issued.
No, work order not issued. Work order not issued.
So what do you want now? At least
I want at least, my lord, let my representation be considered.
Representation in the tender process.
My lord, because my lord, on the same footing, I am on the same footing. I was not allowed, whereas my lord, the other parties are, my lord, allowed to participate in the tender process. Lord, there is nexus between the
when is the last date of the opening of the tender? Tender is open or not?
No, it is not open.
What is the last date of the opening
of the auction held on 3rd November. So, let it be, lordship, kindly, it is up to your lordship, kindly.
Let it be in the remain list. We'll see.
I will notice.
What?
Kindly, any date, any date,
If all the things has been taken as all the matter will taken as urgent matter, when this court will take the hearing matters and adjourn motion matters?
No, my lord, not the adjourn on the.
You try your luck on 551 when the matter reach. I will take the matter. Nothing. Yes.
Must kindly.
Extremely urgent matter, Milord. I tried to put this matter unlisted before your lordship. Your lordship directed me to file before the bench, Milord. Now the matter is running as item number 555, Milord. The fact is this, Milord, the petitioner before lordship is a student, Milord. Petitioner before lordship is a student, Milord. Student of class 12, Milord. Milord, due to Milord mistake in the Aadhaar card, Milord, petitioner are unable to Milord fill up his form, Milord. Milord, that's why the petitioner filed an online application to the Aadhaar authority, Milord, in the month of August 2025, Milord. But as of date, Milord, that has not been Milord rectified by the Aadhaar authority, Milord. I made several representations before the authority, Milord. As of date, it is pending, Milord. Now, Milord, the medical examination is approaching, Milord, in the month of December, 3rd week of December, Milord.
So what is the difficulty in the Aadhaar card?
My lord, at the time of filling up form, my lord, my birth certificate name is Obirup Kundu. And my lord, in Aadhaar card, my lord, it is written as my lord.
So it takes some maximum, it says 60 days for correction in the Aadhaar
that
card.
Has not been done, my lord.
Where you submitted?
August 2025, 18th August.
You have taken any help of the CSC centers?
Yes. Yes, Milord. Thereafter, I went to the office of the Milord, regional office at Salt Lake, Milord. They said, since you have already applied through online mode, it will be done automatically.
That's what I'm telling. You have applied directly through the online mode, it will take time. If you go to the office of the recognized agent,
it has not accepted, Milord.
That's why they have appointed the recognized agent.
No, Milord. I went to the office, Milord, regional office at Salt Lake, Milord. they requested me to submit, kindly, very short matter.
My lord, may I follow kindly to mention item number 5.
Urgent motion 18 तारीख.
592 for upgradation as urgent motion. Very short point. MSME declared as NPA without following the mandatory Reserve Bank of India guidelines. Your judgment is also there, and my lord, Pronit's judgment of the Honorable Supreme Court that MSME declaration of MSME's account as NPA, RBI circulars have to be, my lord, followed, and it's mandatory. Very short matter, just 2 judgments. Your lordship also has the judgment in, my lord, Duar's Jute, where your lordship, my lord, restrained the order. It's not challenging a surface action. 592, my lord.
19.
I'm great.
Pilot may that is item number 470 in the daily list. We are praying for upgradation of the matter. This matter concerns a Merlin Group, a real estate developer, who is selling off the residential units prior obtaining the RERA certification. So this poses a great risk to the honest home buyers who are there. So we are honest court's intervention is required vehemently at this point of juncture. We are one of those home buyers whose interests have been.
Yes.
My lord, may I be permitted to mention 2 matters, my lord, 476 and 489, my lord. My lord, for remission, life convicts are 22 years, 6 months in the custody, my lord. Same placed matter, my lord. Another convict was granted remission by the State Sentence Review Board, my lord.
So already some matters are fixed when it is fixed. Earlier remission matters and all this who are stay.
My lord, these are running in the daily list, my lord, but not fixed.
Okay, that some wait. I will take the matter.
110.
What is the urgency, sir?
110.
What is
The petitioners has completed what as per tender, 100% what has been completed. But in spite of the same, the authority concerned did not take any step to release the rest balance.
urgency? Yes.
But they have not released the.
No urgency. Release of payment is there is no urgency.
I'm suffering since for.
Maybe urgency. You go to the civil court to obtain the order.
Decide this matter. Your Lordship, can you take this matter?
Yes.
They have not issued the.
No.
Completion side.
Go to the civil court. If you are the urgency, go to the civil court. You want to wait. You wait. When the court will take up the matter, it will be decided. Yes.
Item number 552 of today's options have been punished under Section 42 of the Ordinance Act, and upcoming punishment have not yet been pushed back. Still, I am suffering unnecessary.
The matter is pending for let wait. Other matter is going.
My lord.
Unnecessary.
No, nothing. Yes.
Item number 275 of daily list. Matter is against CSC authority. I have applied for domestic electric connection. Quotation have been paid. Verification have been done. The matter has been lastly appeared before his lordship, the Honorable Mr. Kaushik Chandra, whereby his lordship asked for a report before from the CSC authority. Thereafter, the matter was rejected after 3 weeks thereafter. But that doesn't happen.
My lord, may I be. My lord.
23rd urgent motion.
It's an injunction of my bank guarantees by the DBC. Here there is an order passed by the coordinate bench stating the DBC from beginning towards instead. After that, we furnish a bank guarantee security as directed by the coordinate bench. That security is already in cash and that has already been accepted. After that, other bank guarantees lying with the DBC, they've been invoked. 8 December invocation and coming to the.
Why it is invocation?
Invocation on the basis of delayed payment surcharge. That is excessive stayed by the action. There are orders covering us. There's also the order of the coordinate bench.
There is an appeal is pending.
Inactive.
No.
Here, the invocation is already made. 8 December 2025, invocation. We prepare the writ. We want to move it at 2 p.m. Here, excessive quantity the orders of the coordinate bench as well. It was covered also with the order of the coordinate bench. The same prayer was made by DBC.
Maybe, but this court is not having such.
My lord.
Or else, my bank guarantees the money has already.
Go to the civil court. Get an order of the injunction.
First round of litigation, we got an order in our favor.
Why all matters coming? Money shoot also coming. All the things, revocation also coming in the civil writ jurisdiction. How the writ court decide all the matters?
XCC arbitrary, my lord, will grant us only 2 minutes if my lord can be satisfied, my lord, or else we'll be pushed to the civil court. My lord, it's a short matter. We will only place 5 documents if we succeed. Or else, my lord, my bank will be debited, my lord, by today or tomorrow, my lord.
Leave granted.
Deeply obliged.
Leave granted. List the matter on
Tomorrow kindly can.
tomorrow, not tomorrow. On 16th.
My lord, may I have my lord's kind leave to
Yes.
My lord, the petitioner is in custody for more than 17 years. Life conviction, we traveled to the Supreme Court. Supreme Court for early, my lord, release of the petitioner because he has
Where is
become
the Supreme Court order?
with the petition, my lord, it's daily list item number 389. My lord,
What the Supreme Court says?
Supreme Court said, my lord, to apply before this honorable court, before your lordship, my lord, to agitate this point, since, my lord, we are praying for early remission.
Okay, let us see. When let the matter come, I will say yes.
My lord, may I be permitted? My lord, my lord, may I be permitted to mention one matter for upgradation, my lord? Item number 130 of the daily list. My lord, the bank authority has withheld the petitioner's FD amount even after maturity.
Huh?
My lord, the bank authority has withheld the FD amount of the petitioner long after the maturity, my lord.
Why?
My lord, they are saying one criminal case is pending before our name.
Criminal case pending, what the bank will do?
Ah.
What the bank will do with the criminal case?
My lord,
When your fixed deposit will be
my lord, 2020.
2022, so no urgency.
My lord, I need to mention item number 43 of this. My lord, this matter relates to securitization.
Huh?
This matter.
Securitization go to side court. Yes.
But may I be permitted to mention, well, this matter,
This not,
Malad,
this
may I
court
be-
is not having
Malad, may I be permitted to mention this matter, Malad, this urgency, Malad?
Appearing in the list.
Which matter?
43. It's a RBC matter.
Push for the other side.
My lord, Mr. Akka Rao,
43.
43.
What is the writ number? WPA number?
12935, 2023.
Record a note. You are for the petitioner?
I am for the
Learned counsel for the petitioner. Item number 43. WPA 12935 2023. Learned counsel for the petitioner submitted the matter is connected with the SURFACE Act. Accordingly, WPA number so released from the list of this court, with the liberty to the parties to mention before the applicable court having
Malad, may I be permitted to mention one matter, Malad?
Yes.
Malad, this matter was scheduled to appear today in the list, Malad. This matter pertains to life and liberty of a person, Malad, whose passport has not been renewed because of the fact, Malad, a criminal case is pending. Now, Malad, the petitioner was working in Kuwait as a cook, but his passport was scheduled to, Malad, expire on 3rd.
Is there any criminal cases pending?
Yes, Malad, he is pending.
Apply before the learned trial judge?
Yes, Malad, that is pending.
Got the order from
No,
the
Malad,
judge?
that is pending, Malad. Malad, I am only beseeching the Lordship, Malad, kindly directs them to consideration. But I'm covered by.
What is the lower,
But
lower
kindly appreciate,
sorry,
Malad.
sorry.
But 14
Yes.
orders have been passed by this court, Malad.
I
on this.
know, I also passed, but go to the trial court. Why you are coming to the writ court?
But that is pending only a direction. I am only
sorry.
seeking for a direction, Malad.
This court cannot.
My lord, I want to mention
Great.
for inclusion in the cost list, already informed the opposite side.
Why? What is the inclusion? Why you
It
want
is
to
a group
include
9 residuary matter, RTI matter.
With regard to item.
Lordship has been pleased to hear a matter, my lord, for personal information, withholding personal information. Lordship has virtually heard the matter. Only for my reply it was due. Item number 163. Any day I'll take 5 minutes to conclude my submission.
matter?
But they are in the personal disclosure of personal information in RTI. They said that personal information cannot be disclosed. I say it can be disclosed. My own personal information they are withholding. So that writ petition, Lordship has heard it for twice. Only for my reply it was due. That day they took adjournment and matter item number 163. So kindly,
On the which heading the
it's
matter was
appearing in now. It is appearing in the adjourn motion without any affidavits.
when the matter was taken up in that
New motion. So 163. Any day I'll take 5 minutes to conclude my hearing argument.
22 तारीख को रखकर जाना।
22nd.
With regard to item number
I'm on notice.
579, my lord. But due to extreme urgency, I mentioned, my lord, petitioner has left with 4% deposited on a gold with the state bank in 1972 under the emergency gold scheme. My lord, 4% died. We got a decompromised decree from the competent court. We submitted all papers. My lord, petitioner is more than 80 years old. My lord, 80
What decree you obtained?
not releasing.
What is the decree you obtained?
Compromise as per their shares. My lord,
No,
everything-
what is the decree?
decree all Malad claimants will get their share, and share has already been decided by the civil court. We deposited all to the State Bank of India. They are not releasing, Malad.
Go to the execution. Why the
No, Malad, everything has
Writ
been
court
done.
court का execute the
No,
civil
they
decree.
have directed me to deposit all documents. We have deposited. They are keeping pending.
Okay, go to the civil court.
Malad,
for the
there-
execution. Yes, yes.
There
Mr.
is no civil
Malad,
court proceeding is
may I
there.
have your lordship?
Only direction is necessary. Otherwise,
Go to the civil
80
court.
years of old.
Go and file the execution case. Yes.
My lord, upon notice I'm mentioning, my lord, termination of a agency by the life insurance corporation. My, this is the third round. In the first two rounds, we were successful. Now, my lord, the writ petition was filed prior to the puja vacation, but it has not been taken up. Now, my lord, LIC is taking further coercive steps. My lord, so it needs to be. I am not saying that it has to be heard today or tomorrow.
What is the course you still?
No, my lord, now what they are doing is based on the termination. Now, termination has been set aside earlier twice. So further directions were given. Again, considers identical order in verbatim that same proceeding. So, my lord, it is becoming vindictive. The whole idea is that the order which has earlier been set aside, my lord, so my lord, the only difficulty is that now LIC is taking further. I am without a profession on my business for the last quite some time now. Now, difficulty is that, my lord, now they are taking further steps after protection is required.
22nd.
22nd, deeply obliged.
It's a criminal revision matter of 2025. The matter will be coming up in trial court
25 revision here, there is no.
2015 criminal revision matter. And that matter will be coming up in trial court in 22 December 2025.
Correct.
So kindly.
So what do you want? When the criminal revision was filed?
15.
15, what you have done till 15 to 25, 10 years? What is the urgency now? Now the trial court has started the proceeding. Now you woke up and filing, coming before this court for mentioning the matter of 2015. What you have done 2015 to 2025? Let the trial court. I will take this matter and I will direct the trial court to expedite the matter within 4 weeks. The matter can be disposed of. You are ready? I will take this matter.
Order was passed by this.
Maybe.
My lord, may I be permitted to mention a matter? My lord, I am mentioning for upgradation of this matter. It is appearing in today's daily list as item number 424. Your lordship, the petitioner had executed one sale deed, but first page of the deed is.
Yes.
My lord, may I be permitted to mention one matter? My lord, the salary account of the petitioner has been, my lord, attached arbitrarily without, my lord, due process of law. My lord, the bank, my lord, State Bank, my lord. My lord, my lord, it was attached on, my lord, 27th of October. My lord, the matter was filed on 29th of October. My lord, till date the matter was not been taken up by your lordship. My lord, kindly fix the matter with the urgent motion. My lord, the 501 of your
lordship's kind. May I have your lordship's kind leave to mention? Lord, this is item number mentioning upon notice item number 521 of your lordship's daily list. The urgency, my lord, is that the electricity authorities are not providing me with electricity despite me completing all the formalities, my lord. This I am 56.
In the house now.
Yes, I am. It is my own residence.
When you entered into the house. When you taken possession of the house.
I have taken possession of the house around a month ago. My lord, I am 56-year-old. My mother is around 80 years old. My lord, kindly, my lord, fixes a day. My lord, kindly fixes a.
Yes.
Mention the matter. Petitioner has applied a commercial meter, but the licensing authority denied to give the meter on a flimsy reason, my lord. And it is a business.
It is in the list. Matter is in the list. Matter is in the list or not?
With your lordship, kindly may I be permitted to mention a matter for updation, your lordship, upon notice. Item number 539.
What is the urgency?
Urgency is that, your lordship, the petitioner is the unfortunate mother. Petitioner is the unfortunate mother, your lordship. She is a senior citizen.
You cannot say the unfortunate mother.
No, your lordship, the difficulty is that, your lordship, the son and daughter-in-law, they are physically and mentally torturing the said petitioner.
Who torture?
And they are
who has tortured?
The son and daughter-in-law of the
son and
daughter-in-law of the petitioner. Your lordship. And the petitioner has made an application before the SDO Chandan Nagar under the Maintenance and Welfare Act of 2007. Your lordship. And presently that application is still pending. It is not being taken up by the SDO. So
when you filed?
I have filed this matter.
Now, when you filed the application before the SDO?
SDO in the month of August, your lordship, 2020.
Till that it has not been taken up for hearing.
It has been received, but it has been received, but
not yet heard. Usko 22 ko rakho.
My lord, in a complaint circumstance, I am mentioned only one matter because you also have great pressure, my lord. This is a matter regarding, my lord, I am a Hindu citizen, my lord, coming India for medical treatment. But what happened, my lord, in the meantime, my lord, my life was threatened by someone, my lord, Bangladeshi, my lord, just like a Sheikh Hasina, my lord. And then, my lord, I made application before the, my lord, competent authority for extension of visa, my lord. That is not considered. 17th is the last date, my lord. Can you take it up Monday, my lord? I have
For what?
for extension of visa, my lord.
Oh, you go to the authority. How the
Authority, I have already made application, including all the documents, but that is not considered still pending, my lord. I made application before, my lord, 2 weeks before, my lord.
have you been booked under 14 Foreigners Act?
Yes, my lord.
Have you?
No, for not for this.
Then
I am a citizen of Bangladeshi, but I am a minority Hindu, my lord. My life was threatened because of, my lord, some. You should know that what Bangladesh now happened, my lord. So I made application before the competent authority, FRDA,
for what?
for extension of visa, my lord.
Extension of visa and stay in India.
Yes, my lord. And then that is still pending. So 17 is the last date.
What the court will do? It is the
Court will do, my lord, for considering my application, my lord. Read court has absolute power. You should kindly can take it up any day.
23 ko rakho.
23 maybe infrastructure, my lord.
Lordship, kindly to mention item number 575 of the daily list, my lord. My lord, the urgency in the matter is the company is a pharmaceutical company. The petitioner is a pharmaceutical company and has been blacklisted without giving any show cause notice, my lord. The company has been blacklisted without giving any show cause notice, my lord.
How you have? There is any tender notice. You have been awarded the tender work. You have completed the tender work.
Yes.
Then the blacklisted.
We have completed the tender work.
And when the blacklisting was issued?
Because
when you have been blacklisted?
It was blacklisted in the month of September, my lord.
September, okay. Wait for that.
I want to mention one matter, lordship. Petitioner is a CA, lordship, purchased the office space. For that applied for connection, they are not giving the connection, lordship.
Okay,
Cannot
CA,
start.
he will arrange the other substituted. Yes.
Lordship, only one.
I beg to mention, my lord, second round of this petition, a HDFC bank without any contractual relation to me, I never took any loan from the bank, has given some wrongful entry in my civil. My lord, Justice Amrita Sinha directed the union to consider my representation before 1 year, my lord, to delete these entries. Till that nothing happened. Now, my lord, the recovery agents are coming, basing upon these wrong entries, my lord. My representation only maybe.
Which bank?
My lord, the HDFC bank out of nowhere put some wrong entries. I submitted representation to the ministry, my lord.
23 crore.
May I be permitted to mention 5 matters, Your Lordship, for extension of interim order, which will expire on 19th.
Interim order, when it is going to expire?
19th of December, Your Lordship.
18th crore sub to be mentioned for
5 matters. Great.
My lord, may I mention one electricity matter? Earlier, order was passed on 2nd May 2025 by Justice Honorable Justice Khurshid Chandra. My lord, after that matter is pending.
Yes.
No, may I have your lordship kindly to mention one new motion, my lord, for inclusion. Well, it has been filed on Friday for inclusion, my lord. And there is some urgency also.
I have mentioned one matter, my lord. Item number 32 days lease, my lord. My lord, it is very urgent matter. As because, my lord, Jila Parishad floated tender. I am the highest bidder, but they are trying to hand over to some other person, my lord. So the lordship kindly take up this matter, my lord.
When the tender was open?
It is on last November.
Okay.
My lord, kindly, my lord, to mention this matter for inclusion in the list. My lord, district judiciary floated one tender for cars. I was
which district?
My lord, Alipur district judiciary. I got that tender, my lord. My cards were plying as on date, my lord. A bill of almost 40 lakhs is due and pending. My lord, the bills are not being cleared. My lord, kindly includes it in the list.
The civil court.
My lord, the jurisdictional civil court is Alipur in itself.
So what? So what?
My lord, kindly includes it in the list.
Money suit, nothing. Yes, call the list.
My lord, may I be permitted to mention a matter upon notice for upgradation, my lord? My lord, item number 470.
What is the urgency?
Urgency is this, my lord. Forest authorities are coming and they are not permitting the petitioners not to construct the boundary wall, my lord.
Yes.
My lord, the matter has been filed in month
Not
of
necessary. Yes,
September, my lord.
I appear for the respondent number 1 and
From adjourn motion.
What is the urgency?
Your Lordship, the employees' gratuity has been pending for last 20 years. Earlier on 30.
20 years, you wait for 1 month, then it will come.
on last 13 November, you have heard this matter. Then the other side prayed for time. You November.
Not listed.
Then not heard. Kindly.
22 तारीख को. Yes, call the list.
My lord, item number 1, I appear for the petitioner. My lord, for your lordship passes the judgment, my lord, may I make one submission? My lord, I have challenged a DIR filed by my learned friend. My learned friend is agreed with the DIR that I have filed, which is not under challenge before your lordships. But I am ready and willing to give my consent that let both DIRs be quashed. Then if that is the case, then the dispute goes back to square one before it had arisen at all. It's settled. I can give the DIR number, my lord, it's on record. My DIR, which I have filed, which he's agreed with, that can also be set aside. And his DIR can also be set aside. So both directors are restored 2-2 prior to they go back to the situation before the dispute had at all arisen. No, I don't admit. I want to put an end to the dispute.
But they are not challenged. How their prayer can be allowed here, setting aside your
yesterday they
challenge.
They haven't.
That's why I pass an order. Their representation, your representation be considered by the register of companies and the competent authority in accordance with law. Till that time, your DIR 12 of censorship will not be given effect.
Very well.
That is the order I have passed. So I have passed an order for the representation with regard to your induction of your directors, and with regard to this will be taken of consideration by the ROC or the competent authority in accordance with law till that time, because the DIR 12 of so be kept will not given any effect.
Very well, well. I was making a suggestion. Had my learned friend consented, we could have ended the dispute. That's about it.
The matter was called up.
Correct.
I sought for instructions. The instruction has not yet come.
Now that's why I can't because you are not challenged that. So I cannot set aside.
I also without instruction cannot give.
And I cannot set aside.
Very well, Malon. Very well. I'm grateful, Malon. Grateful.
Yes, next.
Appearing for extension of interim order. The interim order was granted on 2nd of April 2024. A peculiar situation has arisen. If my lord kindly just have a look at the order passed by my lord Justice Bhattacharya on 2nd April 2024.
2nd April?
Yes, my lord, of 2024.
Yes.
The honorable coordinate benches desire was that either of the parties should go to the honorable division bench for clarification of a previous order in a public interest litigation.
Yes.
Till such time the clarification comes, the impugned order which I have challenged was stayed. Now, my learned friend has gone for clarification, but the matter has not yet been taken up. That's why, my lord Justice Sheena was pleased to extend the interim order, lastly on 26th of June. Situation is still same. We need a clarification.
Well, I think, Lordship, if my lord can go through, my lord, the order dated 27th of September.
Yes.
27th September. There it has been mentioned that one of the parties, they have.
Yes, God, everything is the same things.
However,
same thing.
The matter is there pending, so.
So kindly, extend the interim order. We'll come back once we'll have the clarification. But in the public interest litigation, the Honorable Division Bench directed District Magistrate to take a decision in accordance with law. Millard, on the strength of that order passed by the Honorable Division Bench, what District Magistrate did, District Magistrate quashed registered deed of sale. Directed rectification of record of rights.
So that is pending. Your approach.
Yes, that's
for the division bench. My lord, the private respondent.
Pending.
File an application.
Yes.
Interim, as per the matter is listed as to be mentioned on the prayer made by the counsel for the mentioner. Police stop. Counsel for the raised for extension of interim order. Accordingly, record is extended till 28th of January 2026 or until further order, whichever is earlier.
Bench
liberty to mention.
My lord has been kind enough to indicate a returnable date as well.
Liberty to mention because it is pending in the.
Correct.
So I have extended till 28th January.
Okay.
28th January.
30th.
Great.
Appear for CAC Limited, madam.
Your Lordship, appearing for the petitioner. Your Lordship, the matter was listed on 9th of December. On that date, Your Lordship asked the CSC to kindly deposit a inspection report.
This is the inspection report, my lord.
Your Lordship, the petitioner is a tenant in regards to the property situated at P233 Open Banerjee Road. The electricity has been disconnected in the year 2015 and he has been staying without electricity for the last 10 years with his minor children. He has been paying all the rent without any demur.
My lord. My lord.
Yes.
Yes, Your Lord.
On to the report.
Yes, Your Lordship.
Yes.
Yes, Your Lordship, we are ready to pay whatever charges is required to install the block meter. We just need assistance from the police officer during the installation of the block meter as well as on the day the electricity is being restored. Your Lordship, I just have one more prayer. If you could make the charges minimal for the police assistance at least, because he is a vegetable seller, he won't be able to pay because there is a similar order to a similar situation where the police charge almost rupees 14,000 for the restoration of electricity for their assistance.
No, this is not restoration of electricity, my lord. This is a new service connection with a block meter.
New service.
Yes, Your Lordship.
No
We are ready
connection.
to pay for whatever charges the CSC is asking to install the block meter. We are understanding that. But in regards to the police assistance, if the police ask for a high amount, the petitioner will not be able to pay.
So there will be a notified amount with regards
Yes.
to the if they send the constable, this will be amount. If they send the head constable, this will be amount. They will send the sergeant, this will be amount. How many person? That is
Yes, Your
as per
Lordship.
the notification.
Yes, Your
as per
Lordship,
the
but
prescribed.
it's just a prayer that if you can kindly mention a certain amount beneath which they
I
cannot.
am passing on, madam.
My
I am
lord.
directing you to
Now
supply
we provide a new service connection with one block meter, but the police is not a
on
party, my
compliance
lord.
of
Compliance of all formalities, madam.
the petitioner has filed the presented application praying for the access upon the respondent number 1 CESC Limited for providing electric connection in the premises. The petition situated at 3233, Open Banerjee Road, Parnasri Pali, PS Parnasri, Kolkata. The Senior Engineer Southwest District CESC Limited has submitted the report wherein it is found that during the inspection of the premises in question, it was found that there is no electric connection in the premises of the petitioner. The CSC authorities are ready and willing to provide a new service connection with a block meter in favor of the two petitioners.
Your Lordship, in this, there is only one petition, item number
Next
4,
item
same
is
matter.
The petitioner.
Where
of the petitioner.
Affidavit of service charge, item 4.
Petitioner subject to compliance with all formalities by the petitioner along with payment of the charges required for grant of electricity, new electricity connection. Also, counsel for the petition submitted, petition is ready and willing to pay the, will comply with all the provisions and will pay the required charges to the concerned author to the CSC Limited for obtaining electricity connection. In view of the above, the CSC Limited is directed to provide electric connection, to provide a new service connection with a block meter in the premises of the petitioner, subject to compliance with all formalities by the petitioner, including the payment of all necessary charges, within a period of 4 weeks from the date of payment, compliance of all formalities.
Grateful, Your Lordship.
police department. It is made clear that if the CSC authority find that there is any obstruction by any local people or the adjacent owner for providing electricity,
By the private respondent, my lord, who is a landlord.
if there is an objection from from any of the parties, including the private respondents, comma, the concerned police authority, who is the police station? The
Corner Street.
in charge. The officer in charge, PS Parnasri, Kolkata, shall provide appropriate police assistance to the CSC authorities for providing electric connection in the premises of the petition. Next.
Next is similar, my lord.
Next is similar.
Yes, your lordship.
But he is appearing for CSC, my lord. Leave
Much obliged, your lordship.
Grateful, my lord. Wait.
Same order.
Leave it, your lord.
Next.
Item number 5, my lord.
Five,
come
my
for
lord.
the
I appear for the petition.
respondents, my lord.
My lord, this is an application for extension of interim order, which was granted, my lord, during the honorable.
Application can for extension.
My lord, the writ,
Can is for extension, my
my lord, the writ petition is not maintainable. Writ petition is not maintainable.
Correct.
On the two grounds, my lord, that is the entire cause of action is the outside the jurisdiction of this honorable court, point of territorial jurisdiction. My lord, the tender was floated outside, that is from Bhubaneswar, accepted Bhubaneswar. That was, my lord, the work order was issued Bhubaneswar, and my lord, that was the material is the rail clips. My lord, that is this attaching the rail track with the, my lord, the sleeper.
What is the prayer in the writ petition?
My lord,
That
your
is the
lordship
writ
would-
petition
that
that
is
they have, my lord, the temporarily, my lord, delisted from their, my lord, enlistment.
Okay,
Because
there is already an existing interim order.
no, my lord, that interim order was passed, my lord, without serving to the appropriate authority.
Correct.
And my lord, another is, my lord, that on the similar circumstances matter, my lord, the identical matter, my lord, the judgment was come. And my lord, admittedly, there is an provision of appeal. At para 26, they have admitted. And my lord, admittedly, my lord, the entire cause of action outside the jurisdiction of this honorable court. My lord, kindly see for a moment the
What is the prayer in the writ petition?
yes, my lord,
Prayer, my lord, your lordship will find at page 22. My lord, the impugned order of temporary delisting being annexed to P10 to the petition, my lord,
Where is
be
P10?
set aside.
Where is P10?
P10, my lord, page 282, my lord. My lord, I'm led by Mr. Majumdar, if your lordship kindly, my lord.
my lord, in identical matter at the issue, my lord, this honorable court, my lord, that rejected the writ petition on the ground of there is an ground of appeal. And in my case also, apart from the appeal ground, my lord, there was a point of, my lord, the territorial jurisdiction.
Reply was received by the respondent. Reply was already received by the respondent. No reply to the show call has been received in the reference. It's total non-application. This is the point where the application mentioned granted an interim order on paragraph 5.
The director tract of RDSO, there is no such office within the jurisdiction of the West Bengal, my lord.
Yes.
And my lord, kindly see the judgment, my lord. That was passed on 7th October 2024. My lord, similar matter. My lord, kindly see the page 3, my lord. Page 3. Under such circumstances, the factual aspects which have been decided cannot be subject matter of challenge in an application under Article 226 of the Constitution of India. The authority reserves the right to test a sample. The provision of ISO documents which permits the authority to take such decision have been discussed in order. A show cause notice was issued The inspection was also held in the presence of the petitioner. The petitioner's answer to the show cause notice was considered point-wise. It is not a case which falls under one of the
Yes, Manjunath.
exception which permits judicial review of decision making. Decision
The
making
order
process,
impugned is
there
passed in
an
violation of.
alternative remedy by way of appeal. The order
Okay,
does
okay, I have
not.
gone through, I have gone
My
through.
lord,
Yes.
there is an provision. My lord,
Yes, Mr.
that point of
You do
territory.
one thing, you solve the copy, what the judgment you relied upon. So, okay, already here, there is an interim order, I am extending and I am fixing, okay, you will not file any affidavit, I will record that.
My lord, there is no such direction to file the
So
affidavit.
that's why if you not file affidavit, I will record your submission. You want to argue the matter on the mentality, I will fix the matter for hearing. Because today is the to be mentioned, I cannot take the matter for hearing.
My only humble and
I
respectful.
will record your submission. You are raising the point of maintainability, but the matter is fixed today to be mentioned for extension of interim order. Petitioner is enjoying the interim order, so I am extending the for the time being, and I will fix a date for hearing of the matter. Nothing else.
My lord, that
To
is.
be mentioned, you have not filed any application for vacating the interim order. Now they have mentioned the matter for extension, and this is matter as a to be mentioned. You show me any law on the date of to be mentioned. The matter can be disposed of after on merit.
My lord, my only humble and respectful submission, my lord, when the writ petition is not maintainable. So there is, my lord.
I will fix the matter for regarding the maintainability of the writ petition one day. I cannot take the matter today.
Because, my lord, this is a very, my lord, the safety item, my lord.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for extension of the interim order, which is subsisting till today. Learned counsel for the respondent raised objection and submits that interim order cannot be extended as the writ petition filed by the petitioner is not maintainable, and he has relied upon the unreported judgment passed by the coordinate bench in the case of JK International Track Private Limited and another versus Research Design and Standards Organization and others, dated 7th of October 2024. Consider the submission made by the counsel for the respective parties. This court finds that the petition is already enjoying the interim order and the matter is listed today as to be mentioned only on the prayer made by the petitioner. Accordingly, for the time being, the interim order is extended. With regard to point of maintainability is kept open. List the matter on extended till 8th of January 2026 or until further order, whichever is earlier. 7th को देखो डेट फिक्स है 10th you want
10th February
January 7 January देखो 2 बजे 8 9 खाली है 9 January 2026. The interim order is extended till 14 January 2026 or until further order, whichever is earlier. Come on that day, if it's specially fixed, it will be taken.
But we understand my learned friends are not using an opposition to the application.
We will not use, your raising.
When the maintainability point is there, that point might be decided.
Really?
Okay.
Sir, this is at the affidavit in service in terms of the earlier order.
Affidavit of service be kept with the record. Yes, next.
But item number 6, I'm appearing on behalf of the
Yes.
My lord, I am for the state.
Intends to withdraw the instant application.
Instant to withdraw. Can
I have the written instruction, madam. The respondent number 2 had already provided the minutes of the meeting as prayed for that in the instant application.
Record. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. The petitioner has handed over a communication dated 10th of November 2025, wherein the petitioner has informed the learned advocate that the petitioner is not intended to proceed with the matter and plead for withdrawal of the case. Police officer. Counsel for the petition on the basis of the communication dated 10/11/2025, plead for withdrawal of the instant date application. At the land council for the parties peruse the communication dated 10th/11/2025 and the submission made by the council for the petitioner WPA 25283 of 2025 is dismissed as withdrawn. Communication be kept with the record. Interim order, if any, stand vacated. Yes, next.
I appear for the respondent, my lord.
I'm for the petitioner.
My lord, directed the investigation officer present, my lord.
Yes. Have you taken instruction? Well, has he examined the earlier?
My lord, he has informed that he has examined some of the employees who were there.
Not employees. I am asking one question: whether he has recorded the statement of the manager who has sanctioned the loan in favor of the person who is the fake one.
Yes,
Yes, my
I
lord.
am coming to that. He has examined some of the employees who were there at the time of sanctioning of the loan. He has recorded their statements and it has transpired that one Tushar Mahato, who was the branch manager at that time, he is now posted in Orissa. From his office, the document had come and the other employees, my lord, in a system-generated manner had given the approval.
System generated?
The system-generated manner. They had given the approvals. They have not personally seen or met the complainant.
Who?
The bank employees who were examined.
So how we identify? How he has identified the person? So I will apply for the 7 crore rupees, giving all the documents online, and you will apply.
It has transpired, my lord, that person.
So why you are not arrested the manager who has sanctioned the loan online without identifying the person? Why you are not arrested? Why you not gone to the Orissa? When you will arrest the person? Tell me. You being the investigating officer, you allow the bank manager to sanction the loan without identification of the person online, that to crores. And you come, once it has come to knowledge, what step you have taken? Till that you are not recorded the statement of the earlier manager and you are not arrested. Whether 41 notice has been issued?
Yes.
Whether 41 notice has been issued to the earlier manager?
Section 94.
No. What is your name? Give the total, I will suspend him. Herein now. He is not fit person to be investigating officer and remain in the force. The whole public of the India is suffering from the cyber crime. And this is the attitude of the investigation. How you are defending this type of the persons?
My lord, I was led by a senior in the matter, my lord. No longer in the panel right now. I am having bail without.
Senior will not change the CD.
Cannot change, my lord.
Senior will not change the
Cannot
CD.
change the circumstance. Cannot change the
When the FIR was lodged, when the FIR was lodged,
My lord, kindly grant some more time.
when the FIR was lodged, he should be investigated. A case will be initiated against him also.
19th February 2025.
25.
19th February. And today we are 10th month has been passed. You are not able to examine the person who has sanctioned the loan. And you are telling that the manager stated that this loan has been sanctioned through online without identifying the person. Where is that? Where is the statement? You show me. Where is the statement that the bank manager has sanctioned the loan online without identifying the person? The Bangla language, what the court will do?
No, approach the bench and read it. Approach the bench and read it. You can do it for the state. Approach the bench.
I cannot hear that. None of us can.
Tell me, I am giving the option to you what you want. Otherwise, if I will pass an order, your total department will be in trouble.
My lord, kindly give some more time, my lord. Let him go to Orissa and record a
The
statement and
court will direct what is to be done
my lord.
in the writ jurisdiction and the investigation due by the direction of the writ court. When he was appointed investigating officer?
কবে অ্যাপয়েন্টমেন্ট হয়েছিলেন ইনভেস্টিগেটিং অফিসার অফ দিস কেস? ইনভেস্টিগেটিং অফিসার এই কেসে আপনি কবে অ্যাপয়েন্ট হয়েছিলেন?
ওই 19
on 19th February.
Then 10 months nothing he has done. Who is the senior? Who is the SP?
SP নয়, DC South. DC স্যার, DC তো বলো না।
না না ওনা
No, no, DC কোন রোল? DC কি ওনাকে তো বলো না। DC কোন DC কোন জোন? SCD স্পেশাল ডিভিশন, SCD সাউথ ইস্ট ডিভিশন, সাউথ ইস্ট, ডেপুটি কমিশনার সাউথ ইস্ট ডিভিশন।
In terms of the order passed by this court dated 4th of December 2025, the investigating officer is present along with the original CD, case diary. Learned counsel appearing for the state submits that he has inquired from the investigating officer, and investigating officer submitted informed the learned advocate that the earlier bank manager who was posted when the said incident was occurred. क्या बोला? Was occurred. He is now posted at Orissa. The other bank officers have informed the investigating officer that the loan has been sanctioned through online papers without identifying the person. This court also, after perusing the case diary, this court also found that the case was registered in the month of February 2025. But till date, the investigating officer has neither issued notice under section 41A of the Code of Criminal Procedure for calling the earlier manager who was posted at the time of sanction of the loan, nor he has been interrogated by the investigating officer. Considering the above, this court finds that the present investigating officer is not fit to be investigating officer of the instant case. Accordingly, the Commissioner of Police is directed to immediately remove this person as investigating officer of this case and to appoint a competent officer for investigating officer and to submit the report before this court on 8th of January 2025. This is the matter on 8th January 2025 under the same heading.
Lord,
26.
I'm grateful.
Grateful, Your Lord.
Grateful, Lordship.
Much obliged.
Take that.
My lord, I am
I
appearing
appear
for
for
the
the petition.
State Fisheries Development Corporation Limited, my lord. I am told the SFDCL is a party to this.
Where?
My lord, in this matter, your lordship. But your lordship, we have not received the copy of the writ petition, and neither
You are appearing for?
I am appearing for the State Fisheries Development Corporation Limited.
Yes, copy not served.
The copy not served, my lord, and it is also not available online in Sharthak portal.
I beg to appear for the Punjab National Bank. Also told us copy has not been served of the bank. Punjab Bank is not a party.
No, Punjab National Bank is not a party. Punjab National Bank is not a party. Blood, the main party is blood State Fisheries Blood Development Corporation. Blood, they are the main blood lessor.
Yes.
She is appearing. Some blood.
Give the copy.
Yes, copy. Just give a copy. Just give a copy.
Have you prayed for any interim order?
But I tell you, Lordship Lord, we have come against that.
I have to come back, my lord.
Respondent 156. Now, my lord, the preliminary objection to this is that, my lord, the cause of action arising out of termination of a lease deed. Whatever be the ground, but the ground, it has been mentioned therein that the default clause. Non-payment of lease premium, the monthly premium for a huge amount consecutive so many months. Now, my lord, termination in terms of the, my lord, the terms of the lease deed. And the writ petition filed, whether the writ petition is maintainable or not. Whatever, my lord, the other averments, my lord, letters, my lord, would not go through right now. But the thing is this, that the main thing is that the termination has been challenged. And the termination is not, it is such a matter that arising of a contract, work contract and written lease deed. And they have accepted that, yes, and according to their averment, they have paid subsequently the amount which was, my lord, they, my lord, defaulted. Whatever be the ground, but once a defaulter is always defaulted, the terms they have violated. My lord, my learned friend would, my lord, answer all these things on the next day. I think
Yes.
after, my lord, obtaining the
Necessary instruction.
I thought I would seek leave of my lord to progress with the matter. My learned friend is directing me not to proceed with the matter.
No, the state has already put the pinch and telling that the other authority cannot.
I thought, Lord, if my learned friend is raising the point of maintainability, he should argue first. I don't stand in the way, but I should get a chance of reply. May I just, in 2 minutes, tell your lordship what the facts are? Lord, termination notice is at page 43.
My
Lord, your lordship.
charges, if it could be taken, my lord, a day after, because I have received the copy just now.
to Sunday ho jai, Saturday ho jai.
Monday, sir. Because
Kindly make it Tuesday.
Lordship.
Tuesday.
And will we also be able to apprise the court, your lordship?
Only thing, Lord, since the matter is pending before the court, I expect, Lord, no coercive action would be taken by
That I can. Yes.
I am running a resort. I am running a resort.
Well, I'll come back with all the necessary instructions, your lordship.
As per the prayer made by the
Also the instruction whether you are withdrawing the termination notice.
Raise the point of maintainability.
Our नाम देते हो?
Learned counsel appearing for the respondent number 2 to praise for time as only today she has received the copy of the writ application. Continue of the above, the case adjourned, let the matter appear on 16th.
My lord.
16th
May it be recorded.
Tuesday
Copy has been served today, my lord.
under the same heading.
আমার নামটা দিতে হবে
Next.
আগে পিএনপি কোটে দিলাম পর্ণা রায় চৌধুরী দেবো পর্ণা রায় চৌধুরী আগের ম্যাটারে ব্যাংকে রয়েছিলাম হ্যাঁ
My lord, may I? I'm appearing for the petitioner in this matter.
Yes.
May I submit?
Point, my lord, the writ is not maintainable against a bar association of Bindapur district. My lord has experience in bar association. So bar association are coming under the zone of 226. Not an Article 12 authority, no public function decision, and apart from that, it is election dispute. This is my preliminary point on demerit, letting.
Yes.
My lord, my lord, may I hand over the affidavit of service?
Which court?
My lord,
Midnapur court.
Midnapur Bar Association.
Purba.
Purva Mednipur Bar Association. My lord. Paschim Mednipur. My lord, I am.
Paschim Mednipur.
So there's only one bar association.
So my lord is now accustomed with Purbo, Paschim, Bindapur, these are everything. Good.
My lord, I am aware of that. I have a big hurdle to cross.
So you are giving the chance to roaming around this. Yes.
I have a big hurdle to cross regarding the maintainability. My lord, if I may address the issue in a nutshell, my lord. My lord, the Bar Association.
So in support of my point, may I cite judgment of your lordship's court, a division bench? That will be better. Say.
My lord, in that event, my lord, I'll take my lord, being led by a senior in this matter. I know my lord replicates this kind of practice, my lord. Then if it is only a point of law, my lord, I'm being led by Mr. Dolopati in this matter.
Huh? Yes, yes. On that day when you mention the matter, this court has taken the objection, maintainability, but you are telling that we are satisfied.
In respect of Alipur Bar Association, can it turn the
No, when they have taken the leave, I have objected for that. It's not, but they are telling that we are satisfied.
Page 29 can come. This is respect of Alipur Bar Association. Election dispute. Paragraph 21 and 22. This is division bench judgment of your lordship. Paragraph 22, opening word is clear. Having held that the deed petition under Article 226 against the Bar Association is not maintainable.
Yes.
Bombay was it.
But Karnataka is saying.
My lord, I am trying to rely on a judgment of Honorable Supreme Court and passed by Honorable Division Bench of Honorable High Court at Karnataka. My lord, I am slightly handicapped, my lord. My clerk is not. And I am praying for a short passover, my lord.
Dangerous. It's dangerous.
Dangerous.
Not today, no problem.
My lord, the election is supposed to be take place on tomorrow. Supposed to take place on tomorrow.
What is your grievance?
My lord, I am a member of the Bar Association. My lord, I have been paying my membership fees every year.
Correct.
Without any delay, without any fail, and I have paid my membership till 2026, and they have collected it.
Correct.
Now, Bar Association wishes to hold an election. They have published a provisional list wherein my name was not there.
Correct.
Challenging, and then thereafter on Monday, they have published the final list.
Correct.
For those who can, final list of electoral roll who can participate in the who can vote. The vote is scheduled to be held tomorrow. My lord, my name is not appearing.
Correct.
I just want to cast my vote for the election. My lord, that is my sole grievance, my lord.
How many persons you are?
My lord, it's filed by 3 petitioners, my lord.
Huh?
3 petitioners, my lord.
3 petitioners.
My lord, I can establish from, if my lord takes up page number 31, my lord will find out that I have paid fees. And they are collecting fees from me, membership fee. While preparing the electoral roll, my name is
Go and agitate there. District court in the doorstep.
My lord, I know I have a big hurdle to cross in that line. My lord, I kindly grants me a short passover. Given that I also need.
It's a district bar association. They are district bar association.
Bar association. My
so in the doorstep.
My lord,
in the first floor there is a court of the district judge. Go.
My lord, they are collecting. They are absolutely bowed down, my lord. They are collecting the fees at the time of at the time of collecting fees, but they are not allowing me to cast vote without citing any reason. Immediately, when the provisional list was published, I had immediately informed the Bar Association that my name is not appearing. But despite which they have not taken any step, and I simply want to cast vote in the upcoming election.
But simply this court can't.
My lord, I wish to rely on the judgment of my lord. I have a soft copy, my lord. Kindly grant sir.
Give. No problem. What does Supreme Court say?
My lord,
Bar Association can be filed a writ application.
My lord, it's in paragraph number 2, paragraph number 13, paragraph number 15, and the penultimate paragraph. Karnataka. ওখানে ওই সুপ্রিম কোর্টের 2011 এর জাজমেন্টটা আছে। আরে জাজমেন্ট ভোট দেবে স্যার, ভোট দিতে দিচ্ছি, ভোট দেবে। এরকম না, আমি ইলেকশনে পার্টিসিপেট করতে পেরেছি।
আমার দলপতি কাজটা
বলা হয়ে গেছে, বলা হয়ে গেছে।
ব্যাগটা ভুলে দিয়েছি।
স্যার কি আমার বিরুদ্ধে? স্যার বিরুদ্ধে?
আমি বলেছি কর্ণাটকা সফট কপি
দিয়েছে?
সফট কপিটা দিতে ওরা একটা কপি
কর্ণাটকার
আপাতত নিজেদেরই সবাই বেঞ্জি আমি আমারও পূর্ব আমার ওখানে বাবার
আপনি কি মেদিনীপুর পারেন? সিঙ্গেল ব্যাংক দাস এই নেন তো প্যারাগ্রাফ 16 থেকে 37
13তে ইস্যুটা স্যার 15 থেকে পুরো
স্যার 13 থেকে পুরো
নামটা দেখ চন্দ্রকান্ত
চন্দ্রকান্ত ভার্সেস কর্ণাটক স্টেট বার কাউন্সিল স্যার 13 থেকে স্টার্ট ইস্যু আপনি যে ইস্যুটা এখন তুলেছেন বারে সেটাই দেয়া আছে তেরো থেকে হ্যাঁ সেম স্ট্রেংথের বেঞ্চের জাজমেন্ট আবার তাই করা না করা দেখে
মামলা করছিস
Yes, Mr. Basu, you go through that.
Yes, I'm going through it. But this has been relied upon, but and distinguished by our division bench that I have handed over to my. That will not will get page 17.
আমাকে সাইটেশনটা দে
Unreported tell. আমাদের division.
আসো আসো
Cannot be, no element of holding is there. Neither financial nor no public law element, no public duty is being discharged. If your lordships look to my lord, BCCI matter, telefilm, the points raised there, not a single is my lord coming.
You are the private body discharging the public functions.
Which public
Who is
function?
the Supreme Court said? এটা কার In this writ petition, my lord, my prayer is only very short. Kindly allow us to cast our vote according as per the rules of Midnapur Bar Association. And the issue to be decided by the larger bench because both the division bench, my lord, Article 142, your lordship knows very well better than me, equal strength of bench, which judgment to be prevailed. That is why, my lord, that issue to be referred.
Yes.
Yes.
Yes, what is the matter?
Lord, we are the member, the petitioners are the member of Medinapur Bar Association. Regularly, they are paying their subscription up to date. And Lord, as per the BCI practice rules 2015, Lord, all they are eligible to cast their vote. But Lord, they are restrained to cast their vote because the only reason, not written, the reason is we are not regularly practicing in that court.
Where is that?
Although they are collecting fees. Lord, kindly come to the kindly come to page 30, Lord.
30.
30. Lord, kindly have a look into the date 22nd of September 2025.
Why Mr. Vasu, they have not been allowed?
My lord is entertaining the writ petition. Before that, kindly see the 7 judges bench. 2005 4 Supreme Court cases. 649.
Sir, 2011.
649 बोल kindly come to paragraphs 154, 155, 156.
Sir, 2011.
11. The 7 judges bench. 5 4 SCC.
Paragraph
154, 5 and 56. 154, 155, 156. This is Malor departure from Pradeep Biswas. This is also Malor constitutional bench.
Yes.
After departure, this is the situation.
There are 4 SCC page. Oh, acha. 49.
Physics is crystallizing. Go ahead.
Yes.
So this is the now the public. This is the club. Advocates forming a club and practice procedure for the purpose of the advocates who are the member of that club. No statutory flavor, no statutory function discharge, no public law element. Public has nothing to do here. Whether Malad the taste of G Telefilm or even Pradeep Biswas also satisfying. Relying those, your lordship's court passed a judgment against the bar association. Against the bar association, it is not maintainable. Now, my lord, I must satisfy my on the merits also. But in 2015, there is a statute. It says exactly the minutes of the Minutes General Council of Bar Council of India held on such and such date. This is a Bar Council of India minutes. But kindly turn to chapter 4, page 18, chapter 4.
Yes.
There is a form A. A declaration has to be given. A declaration has to be given. And it is only 8, not more than that. Up to 8 feet.
Every application is verified the certificate. Practice shall be
Form A.
Form A.
This
Column
form
1,
A.
column 2.
What is the contents of the form A? Kindly turn page 4 of that form A. Pardon me, I have marked one portion. This format of the Bar Council of India. He has to say where he want to cast his vote. He has cast his vote. Said that he will not cast here.
He has submitted.
He has submitted. He has to everybody. I also submit.
No, he has submitted the Form A.
Before the Bar Council. of India.
Correct.
There we came to learn that they have said that they will not cast his vote here.
Where is that?
That is the Bar Council of India. Bar Council of India will produce.
Bar Council of India's party?
Yes. He should have placed before my lord. Why is I?
And my lord, in reply to my learned senior
Whether
friend,
you have given the form, whether he will not cast vote in said association.
Everybody has to
Yes.
fill in.
If he has given the, then nothing remains. If he has given, he has submitted the bar that he will not cast the vote in the said bar association, then what will happen?
No.
Then what will happen?
কি বলছেন করেছি না তো
You have to file. You also file, Mr. Dholapati. You have filed.
when
He only filed the nomination.
No, that is before nomination he has to file.
My lord, in
For
reply,
certificate of plastics, this Bar Council of India makes the rules. On the basis of rules, everybody has to file it. Because, my lord, what happened, my lord? Your lordship will find we have 10,000 members.
my lord,
My lord will find practicing advocate in Calcutta High Court is 1,000.
my lord, I am requesting my learned senior friend to produce before your lordship
I will
whether the others whose name is appearing in the voter
When
list,
when
they
when
are
is
submitted
the
on-
election?
Tomorrow.
Tomorrow is the election. So you lost in the 19th hours.
And therefore, my lord, on Monday, the final list was published. I rushed to this court. And my lord, the point of maintainability, my lord, in reply to my learned senior friend placed
Mr. Basu, subject to I will keep the maintainability open and you also bring all the documents.
Yes.
Let the cast vote, but they be kept separate till the disposal of the writ application. And I am keeping the maintainability open.
Yes.
What are symptoms?
Correct.
No problem.
Yes.
Obligation.
The petitioner has filed the present writ application
আপনি দিয়েছেন
সবাইকে দিতে হবে।
with
ও একবার
the allegation that
দিয়েছে তো
the names of the petitioners has not been included in the electoral roll of the Bar Association of Medinipur for the election which is scheduled to be held on 12th of December 2025. 2020. Petitioners Learned Counsel appearing for the Mr. Basu, you are appearing for?
Bar Association.
Appearing for the Rasuna 4 and 5. 4 and 5.
4 and 5.
Rasuna 4 and 5 raise the point of maintainability of the present writ application. Full stop. He further relied upon the guidelines issued by notification issued by the Bar Council of India and submit that as per the said guidelines, the petitioner has submitted a form wherein he has declared that he will not cast vote in the said association. Full stop. This could find that the Bar Association is in the schedule of the election of Bar Association is on 12th of November 2025. And the matter is to be heard on merit, whether it is to be heard on merit, whether the is to be heard on the point of maintainability. As such, and thus for the time being, the petitioners may be allowed to cast vote, but their petitioners, namely petitioners, namely Sheikh Azizul Haq, as Sheikh Rajab Ali, and Somnath Goin are allowed to cast their vote, but their vote shall be kept in a separate sealed cover, sealed box till the disposal of the present writ application. List the matter when?
Bar Council is where?
Who is appearing for the Bar Council? Bar Council is not there.
Yes.
The petition is directed, though the Bar Council of though the notice has been served upon the Bar Council, but none appears on Bar Council. The petition is directed to inform the next date of hearing to the Bar Council. List the matter on 22nd.
After vacation.
After vacation, my lord.
Matter on 12th January.
Yes.
12th January at 2 p.m. At 2 p.m.
12th January may be holiday.
Maybe holiday, my lord.
Okay, 13th
Now
January.
I can add,
Yes.
my lord has not finalized the list of holidays.
No, today.
No,
Today.
not today. Today is there.
Up till now, my lord has not finalized the list of holidays.
My lord,
I can
today.
add it now. Because they
Today-
could not allege.
Today the meeting is fixed by the judges, the calendar committee.
So 13th at 2 p.m.
30. Obliged.
এই বলছি, আমি 2 নম্বরে গিয়ে বলছি।
May it please your lordship. Beg to appear on behalf of the petitioner. Huh? No, 10 though.
13.
It's
Yeah,
about,
but the state respondent didn't.
I'm 11.
Haven't got the instruction, your lordship.
but I'll run very briefly, my lord, through the facts, my lord, once.
My lord, I haven't got the instruction, my lord. Your lordship kindly accounted for this week. For this week.
My lord, I'll tell your lordship.
In
my
the
lord, what is
meantime, I'll
happening.
have my.
This is situated in one of the property is situated in the remote district of Purulia. This is an ashram. It's an ashram established by my lord, a Paramhansa. The name of the ashram is known as Multiversity. Well, there were civil suits. The local villagers, my lord, who belong to the minority community, they have been, my lord, time and again trying to encroach upon the property of the ashram by devising, my lord, this conspiracy of burying a dead body in the property of the ashram. So, my lord, we intimated the police authorities that there are several threats, etc. They're trying to bury a body, and in fact, they buried a body. But despite subsistence of orders passed under section 144 and our several representations to the police, but a deaf ear was lent. So we finally knocked the doors of justice, my lord, by moving the honorable bench, my lord, taking up matters under group 9, my lord, police in action matters. There was a direction upon the concerned officer in charge to cause an inquiry, and in the event it is found that there is a dead body, to exhume the same. Now, instead of complying with the order passed by the honorable court, the OC served a notice issued by the SDO, my lord. Our grievance here is against the SDO. The SDO said that I am calling an all-party coordination meeting. So you have to attend. We immediately, my lord, submitted our protest that this is not in terms of the solemn order, where the OC was directed to cause an inquiry. And upon protest, we attended that meeting. We have pleaded specifically, my lord, pressure was exerted upon us, the ashramites, to settle it amicably. Because according to them, there will be an issue which can result into hurting religious sentiments of a particular religion. My lord, we immediately, my lord, protested against it. There was a second round of writ petition, my lord, approaching the honorable bench, taking up police in action matters. Her ladyship returned to the finding that definitely there has been a deliberate non-compliance with the order passed by her ladyship in the first round of litigation. A special officer was appointed and a direction was given to undertake, my lord, the inquiry as directed in the first litigation. Now, the special officer visited the area, the police personnel were there. Upon inquiry, it was detected that yes, a dead body, they have buried a dead body. The dead body was accordingly exhumed by the police authority. There, my lord, we have also prayed for, my lord, in the second writ petition for a direction for seeking initiation of departmental action against the errant SDO. That report, my lord, is yet to be submitted. That matter is running in the list. I mean, in the meantime, what happened, my lord? Now, there is a matter of PD judgment and order dated, my lord, 19/11/2022. Right title and interest has been, my lord, declared by the civil court
of the
petitioner ashram. It has been also, my lord, recorded in the judgment and order that the ashram is in possession. My lord, what we did was, my lord, we were now, my lord, fencing the property, my lord. So it started, my lord, from the 1st of December. The moment, my lord, a little bit of work, my lord, we proceeded with a little bit of, my lord, fencing. Immediately, my lord, the villagers, my lord, despite our intimation to the police authorities, my lord, and the SDO, started creating a ruckus. So there was this is one despite subsistence of a 144 order. So we once again, my lord, approached, my lord, the magisterial court seeking for issuance of orders, my lord, under section 144. Now there is another order, my lord, passed under section 144, but my lord, it is just there on pen and paper, my lord. In letter and spirit, my lord, there is no implementation. Now, in terms of section 4 of the Police Act, now the district magistrate, and this is an order passed by the SDO, my lord. This, I will say, my lord, this is not an action coatimate, my lord. It's not a coatimate action. But they are duty bound to ensure, my lord, the law and order situation in the district, my lord, as well as to, my lord, ensure implementation of the order. My lord, I am here before your lordship, my lord, seeking a direction upon the SDO and the district magistrate to ensure that the order passed are implemented, and my lord, the general law and order, my lord, is not disturbed. Because here, my lord, the mischief of, my lord, getting civil rights adjudicated by way of filing writ petition, my lord, that is not there. Because PR Muralidharan, that amply states, my lord, I'll be relying on that, my lord. It amply states, my lord, that where rights have been prima facie, my lord, declared, or when rights have been finally declared by a competent civil court, it is the bounden duty to ensure that there is a logical conclusion. Then, my lord, the honorable writ courts, my lord, can exercise jurisdiction under Article 226. But thereafter, my lord, series of judgments, my lord, which says, my lord, that whenever there is injustice, the honorable writ courts are duty bound, my lord, to intervene. Because not only, my lord, other legal rights, it also concerns fundamental rights, 32 and 226. So, my lord, this is the fact situation in a nutshell, my lord, and coatimate action, my lord, knows it very well, my lord. Lastly, coatimate, my lord, was also, my lord, in the judgment of Keshav Meghachandra Singh, my lord, the speaker of Northeast, my lord. It was stated that yes, it is a coatimate action because the apprehension is very reasonable. Because it is happening, it is a continuing wrong. So, my lord,
So what you have prayed for?
My lord, I have prayed for my prayers, my lord, we find at page 30.
31.
Page 30.
Enforce the solemn order.
Mandamus commanding district magistrate and SDO, Purulia Shodor, to forthwith implement and enforce the solemn orders in miscase number such and such by ensuring maintenance of peace and tranquility at the petitioner's property, so that petitioners duly engaged masons, laborers, and workmen may safely carry out and complete construction of boundary wall without obstruction, intimidation, or interference from miscreants or antisocial elements. But here, the state cannot say, my lord, that I'll come back with instruction, because the instructions, everything is on record. There have been two previous writ petitions. The first one seeking, my lord, activation of the police authorities. The second one seeking, my lord, compliance by the police authorities, my lord, of the order passed in the first writ petition, my lord. And despite, my lord, several orders, my lord, under section 144, but this is the fact situation, my lord. I'll just refer to, my lord, a few, my lord, pages, my lord. My lord, kindly take pen to come to, my lord, page 122. 122 is the legible copy. I am here with a more legible copy of the judgment passed by the learned civil court.
Where is the order of the magistrate?
Yes, my lord, will find the magisterial order at page 213. This is the second 144 order. OC has been directed to mention peace and tranquility.
Yes.
Yes. But my petition is at page 214. There, my lord, whatever, my lord, I have submitted, my lord, those sequels are, my lord, recited, my lord, in the several amendments. It belongs to, my lord, Srimad Swami Swarupananda Paramahansa. That is the ashram, my lord.
Okay, in that case, let me file the report.
Lord, before that, your lordship kindly, though Lord, just now it has been handed over, I have not even gone browsed over the lines of this report. Your lordship kindly come to page 38. Page 38 of the first volume, my lord, annexure P1. From where it appears that is a civil suit is pending. Your lordship kindly say, your lordship, let me see. Once you have said, I have not talked even.
The judgment. I was indicating.
Maybe.
I am carrying a more legible copy, my lord.
It is
annexed to
there. The
actual
legible.
petition. The judgment, my lord, we have annexed it at page 122, my lord. I am here with a more legible copy.
Reported? না
না না লোয়ার কোর্টে যাবেন রিপোর্টার হবে
না না আমি জানি না তুমি লোয়ার কোর্ট দিচ্ছ কি
না না অ্যানেক্স করেছি তো দেখুন
কত পাতায়
122 দেখো সেকেন্ড ভলিউম So this is my title suit number 276 of 2012. My lord comes straight way to but page 21 of the judgment.
Yes.
The last paragraph.
Yes.
We all know that a man may lie, but the documents do not. Thus, it appears from the documents submitted by both the parties that the plaintiff has his right, title, interest, and possession over the suit property. Thereafter, it my lord kindly turns over to my lord the ordering portion, page 24.
রিটের কত পাতা এটাতে?
Page 146.
রিটের পাতাটা বল।
24 corresponds to 146 of the writ petition. The suit be and the same is hereby partly decreed on contest without any order as to cause that the prayers of the plaintiff are partly allowed to the effect that the plaintiff is hereby held to be entitled to the declaration of permanent right with right of occupancy of the plaintiff over the suit property and for permanent injunction restraining the principal dependent number 1 to 7 as well as the villages belonging to the Mohammedan community of villages Chagda and Belguma from converting any portion of the same into burial grounds for Mohammedan community and or disturbing and or interfering in any manner with the possession and enjoyment of the plaintiff over the suit property.
Yes.
So, my lord, challenging that, asserting that order, my lord, but they filed an appeal, the defendants therein. But I have also affirmed a supplementary affidavit. This is the latest information slip, my lord, indicating there is no order of stay. An information slip as latest as 9th of December 2025.
No, it's clear. Yes. Yes.
Well, this is the situation, my lord. The degree is there. On the basis thereof, my lord, as was being pointed out by my learned friend,
Yes.
the order passed in the first writ petition that records briefly, my lord, the facts of the case. And recording the facts, my lord, the Honorable Writ Court directed the police to conduct an inquiry, my lord. Now, my lord, this is the situation at present, my lord. I have annexed photographs, page 196 and onwards, my lord. We have geotagged it also, my lord. After this, my lord, we are not being able to, my lord.
So you are making the boundary wall.
My lord.
So it has not been allowed.
Yes.
Yes.
না মানে your lordship kindly can see. তোমার বলা হয়ে গেছে?
But only 3 judgments, my lord, that I will be referring to. First is, my lord, PR Muralidharan.
Lake.
It is reported in 2006, volume 4, Supreme Court cases, page 501. The relevant paragraphs, my lord, will be paragraph number 17 and 19.
লিখেছিস? একবার বলে দাও একটুখানি। লিখে দিই।
6-4 Supreme Court cases, page 501.
না 2006.
হ্যাঁ।
4 SCC.
Yes.
আর page?
Page 501.
501. আর para?
Kindly marks para 17.
Para 17.
A writ petition under the guise of seeking a writ of mandamus directing the police authorities to give protection to the writ petitioner cannot be made a forum for adjudicating on civil rights. It is one thing to approach the High Court for issuance of such a writ on a plea that a particular party has not obeyed a decree or an order of injunction passed in favor of the writ petitioner, was deliberately flouting the decree or order, and in spite of the petitioner applying for it, or that the police authorities are not giving him the needed protection in terms of the decree or order passed by a court with jurisdiction. So, my lord, I am relying on this portion, my lord, and thereafter, my lord, para 19.
19 late.
This tells about the scope, my lord. A writ for police protection, so called, has only a limited scope as when the court is approached for protection of rights declared by a degree or by an order passed by a civil court. It cannot be extended to cases where rights have not been determined either finally by a civil court or at least at an interlocutory stage. Here, my lord, there has been a final adjudication, my lord. An appeal has been filed, my lord. There is no stay, my lord, admittedly. Correct. My lord, this is the practitioner. There are orders under section 144 in vogue. The police and the SDO, by their previous conduct, have shown, my lord, to be, my lord, siding with a particular community despite, my lord, subsistence or declaration of right, title and interest in favor of my client. But the second judgment, my lord, that I will be referring to is by an honorable coordinate bench. It's reported in 2007, volume 2, Calcutta High Court Notes, page 124.
CHN.
Here, my lord, relying on Andi Mukta Sadguru and P.S. Rudani, the Honorable Writ Court states that it is a rare case where the facts are such that despite the prayers of the petition not being approved, the first paragraph, my lord.
Yes.
Yes. I proceed to grant, for this, after my lord, the fourth line, I proceed to grant relief to the petitioner, keeping in mind that Article 226 of the Constitution expressly confers a wide power on high courts to reach injustice wherever it is found. Then, my lord, Andi and Rudani is relied upon, and that if foundation for grant of a particular relief is laid and the party is entitled to relief on merits, and application cannot be thrown out on simply on the ground that proper writ or direction has not been prayed for, and it would be permissible for the writ court to mold the relief for the ends of justice. So even when, my lord, there is injustice, my lord, pleadings will also, my lord, not have much consequence, my lord. Here, my lord, everything is in accordance with, my lord, pleadings and the prayers are properly framed, my lord. The third one, my lord, as I was, my lord, referring to quachimate action, my lord, 2021, my lord, volume 16 Supreme Court cases.
2016, 16 FCC.
Page 503. Paragraphs, my lord, 26 and 29. That speaks about, my lord, a quachimate action. So, para 26, my lord, would find it at page 524. States that a quachimate action has been prescribed in Black's Law Dictionary as follows. Quachimate because he fears or apprehends. In equity practice, the technical name of a bill filed by a party who seeks the aid of a court of equity because he fears some future probable injury to his rights or interests, and the relief granted must depend on circumstances. And thereafter, my lord, paragraph number 29, my lord, will be of relevance. The decision in Fletcher was also referred to by this court in Kuldeep Singh versus Subhash Chandra Jain as follows. A quachimate action is a bill in equity. It is an action preventive in nature and a species of precautionary justice intended to prevent apprehended wrong or anticipated mischief and not to undo a wrong or mischief when it has already been done. In such an action, the court, if convinced, may interfere by appointment of receiver or by directing security to be furnished or by issuing an injunction or any other remedial process. And thereafter, my lord, the relevant portion from Fletcher, my lord. Here I say, my lord, the apprehension is not a mere apprehension. It is already, my lord, the apprehension has made its consequences owing to, my lord, the inaction of the SDO and the district magistrate, who is mandated, my lord, under section 4 of the Police Act, my lord, to maintain the general law and order of the district, my lord. And this is despite, my lord, orders being passed by the competent courts of law. First, my lord, being my lord, the civil court, principal civil court of the district. Second is, my lord, despite, my lord, the honorable high court being approached, my lord, twice, my lord. So here, my lord, despite subsistence of 144 orders, degree of a civil court, orders being passed, my lord, by the honorable high court, only a part has been done, my lord, the body has been exhumed. So admittedly, my lord, it is not an apprehension, it is an admission that what they were doing. My lord, here I am, my lord, knocking the doors of justice, seeking judicial interdiction under Article 226, my lord, for implementing, my lord, the rule of law. These are my humble submissions. Thank you.
My lord, your lordship kindly see. My lord, your lordship kindly come to page 38. Although, my lord, just, my lord, I was just browsing over the lines of my report, which has been handed over to me just now, my lord. I will hand over to page 38.
Yes.
Page 38 of the writ petition, first volume, Lord, Annexure P1.
Yes.
May I read it out? Your Lordship kindly see. It has been passed by Justice Shubhra Ghosh. The petitioner filed a title suit before the learned civil court seeking declaration of their right, title, and interest in respect of the plot in question. By a judgment delivered on 19 November 2022, that learned trial court allowed the prayer of the petitioner partly and granted a decree of declaration that the petitioner have permanent right with the right of occupancy over the property. The learned trial court further granted a decree for permanent injunction restraining the principal defendants in the suit as well as the villagers belonging to the Mohammedan community in Chagda and Benguma from converting any portion of the same into the burial ground for Mohammedan community and or disturbing and or interfering in any manner with the possession of the plaintiff's petitioner in respect of the property. An appeal has been preferred against the judgment, but no stay on or injunction has been granted by the learned appellate court. Then we are coming to the next page, page 39. Learned counsel for the petitioners submits that despite such order, members of the local Muslim community having dug a portion of the land in question and buried a dead body on 12th October 2025. Learned counsel for the state submits that an inquiry is required to be held with regard to whether such act has been done by the Muslim community in the land in question. In view of the above, this court directs the officer in charge, Tamna Police Station, being the seventh respondent herein, so cause an inquiry under the supervision of the Superintendent of Police, Purulia District Police, they being the respondent number 6, to ascertain whether the dead body has been buried in the land in question on 12th October 25. If the result of inquiry is positive, necessary steps have been taken by the authority in terms of the judgment delivered on 19th November 2000. That is a civil court order, Lord. Lord, I have not gone through. Whether the police report that I have not got. Just I was going browsing for the lines of.
Now, with regard to that, not that police report, now already your authority has passed an order with regard to 144. Now, they made a request, but still they have not. What is your report on that?
I have got the report just now. I was browsing over the line of this. Your Lordship, kindly see what it said. It's absolutely perhaps not what it appears from the order of Justice Ghosh that there is a civil suit is landing. Civil suit.
No,
that he said. An appeal regarding the appeal, the status of the appeal said, he said that as per his report, no injunction is there. That is to be argued later, Lord, when I will come for the final hearing, Lord. Your Lordship, kindly see this. The report, Lord, may I read it out?
Yes.
Not
necessary.
Not necessary. On the complaint in the second page also you will find it from the second page itself you see that. It is not that the police is keeping ITable or sitting tight over the complaint lodged by the petitioner and favoring or siding anybody.
Have you served the copy?
No, I'll come. I'll serve. Your Lordship first see this.
It's not in connection with any investigation.
I will give you. It's a report. I will give you a copy. Don't worry. I'll give. My learned junior has already written some judgment. I'll give it.
Take your one.
For দাঁড়া আমাকে জজ সাহেবকে দেখতে দাও না অসুবিধা কি আছে No, it is not that. Having long standing in the bar, it is not a new practice. It's a report. It is the new report of the police.
It arises from an investigation.
No, it is a report. It is a report of the police. Instruction, not a report, is an instruction to me, not to the other parties. I will hand over the instruction to my lord. দাঁড়াও না দিচ্ছি তো দিচ্ছি
The honorable court is saying.
দিচ্ছি
So, okay, you do one thing now. Whether your this boundary work is going or not.
But we have been prevented, my lord.
So, okay, I do because that's why you give the copy.
Lord, I have only one copy. Let him read out.
You get it, Xerox. Kindly see the second page, 1, 2, and 3 paragraph. So, what I propose to do, my lord, either if you are denying this, so I am appointing a special officer and you start your construction, your boundary work.
Or kindly, my lord, appoint a special officer.
Boundary work. If the special officer finds that there is an allegation and he will approach the concerned police authority and SDO. If they will not take it,
special officer, my lord, to approach the SP.
SG.
Lord, let us see whether is there any prayer for special officer or not.
The court can.
Now that your lordship can do it. Your lordship has got the white
Why I
coat
am
on that.
telling, why I am telling, because your report is telling that you are taking already precautions is taken.
My lord, my
Now
lord.
they are making the allegation. So now, if this court also pass an order, tomorrow again they will come with a contempt application. They are not providing. I am going the practically.
Lord, what happened, Lord?
I am going the practically. So
Mine.
that's why for any for future any complications, let a officer, special officer be appointed. Let they continue. If special officer is found that there is any allegation, he will go,
Lord,
and the
Lord.
cost will be bear by the petitioner, not by the state authority.
No, Lord, what me seems, the problem what arose there, it's absolutely basically a communal. Basically, it me seems, it's basically, my lord. I may be wrong, subject to your lordship's correction. So instead of, my lord, it is not that.
But it's not your report not straight so.
That's why, my lord, I will come back with the further report. Your lordship till instead of, अरे भाई আমি তো বলছি তুমি তো বললে তো
Report of 10-12.
I'm not
Report
here.
of 10-12. What for the report?
No, no, Lord,
If
what
you
I say, Lord,
11th, one day nothing will be changed.
nothing, that's not what I say. My humbly beseech my lord.
Yes, yes, yes. No
Humbly beseech my lord, instead of immediately at this juncture appointing as a special officer, let me come back with the further report. Your lordship came in the any day subject to your lordship's complaint on the opening day. That will be better. That will be better. I will have get the further investigation done by the police. I will come back. If your lordship can say so. I will come back with the further report on the reopening any day, subject to your lordship's convenient. After that, if your lordship so does not please us,
sir, what report you will file? Unless and until they will not start the work, so there will be no agitation. Only their contention is that they wanted to keep the premises boundary wall. They wanted to construct the boundary wall. There is apprehension that there will be a agitation. Correct. That's why they made an application. Your officer has passed an order. Now you have also submitted the report. There is no such. But I don't think today there is any work is going or not.
No, we are
They have been applied. That's why I'm telling, because if blanket, I will allow the petitioner to construct the work, and tomorrow any rights or anything will happen, who will be responsible for that?
Right, one,
That's
right.
why I'm telling, for the time being, let the special officer be there. No agitation. If the special officer find that there is an agitation, immediately the work will be stopped and he will approach the authority.
The DM and the SP.
It is not a special officer will allow to continue. If the special officer found that there is any agitation from any corner, he will immediately stop the work of the petitioner and inform the concerned IC of the police as well.
IC and SDO.
As
Lord, in that event, may I humbly beseech your lordship? Your lordship kindly take it up on Monday. I will come back with the before passing this. I'll come back on Monday. I'll come back. Your lordship, instead of in 2 days, sir, I'll come back on Monday with the further instructions from the police. What is the situation prevailing over there? I'll come back. Your lordship can keep the record with the instruction with the record. I'll come back. I'll come back with the latest situation.
So how can he?
I'll come back with the latest
suggestion, subject to appreciation by the honorable court. But since my learned friend wants to come back on Monday, instead of Monday, let him come back on Tuesday or Wednesday. In the meantime, let the special officer visit tomorrow.
No, I join the issue to this, Lord. I'll come back.
Court on Tuesday or Wednesday,
No, no, I'll come back.
Let the
Yes, yes. I appreciate my lord.
Let they take the opportunity. Come on Monday. Come on Monday.
Monday or if he doesn't want to do it on Monday,
Let they come on Monday. What report they will come?
I don't have any objection, Lord, if he wants to do it on the Wednesday or Monday or subject to any day.
Learned counsel for the petitioner has argued the matter, had concluded his argument.
Tuesday, at the top.
Counsel for the petitioner matter at length. The counsel for the state has filed the report. The officer in charge of Amna police station, district Purulia. Let the same be kept with the record. The counsel for the state prays for time to take further instruction. For the interest of justice, the case is adjourned. Let the matter appear on 16 December under the same heading at the top.
16 possibly that election matter will be listed for the Honorable Supreme Court. That SLB ballot. Maybe on the 17th.
Okay, 17.
Lord, I don't have any objection. Lord, my learned junior friend wants it. on 2 p.m. Your Lordship, instead of in the morning, your Lordship can fix it at 2 p.m.
2 p.m. other matters are fixed.
I am always there. My
2 p.m. my till 10th of January my 2 p.m. slot is over.
Look, in the morning, sometimes I do have some my
So what
personal-
देखो ये 17 तारीख को 12 बजे खाली है देखो 12 p.m. yours
Yes, yes.
Let me see.
Because of my personal
No
problems
problem,
in the
no
morning.
problem, sir. This
Sir, I
court,
will not oppose.
this is the last course to not to accommodate
not
lawyer.
I will not oppose.
I don't want to make my learned friend to make anything inconvenient.
हाँ 12 बजे है
No, I reach by 10:25.
আর আমার ড্রাইভার আছে না, কি করা বাড়ি ঝামেলা
at 12 noon.
12 noon. Grateful to Lordship for
As it-
giving me accommodation.
Supplementary affidavit.
Lord, the report may kindly be kept on record.
Just a minute, हाँ 12 noon है 1 बजे 1 p.m.
Lord, the report may kindly be kept on record.
Yes, yes, sir.
I have handed over the copy to him.
Affidavit of service be taken on record. Affidavit of service filed by the petitioner be kept with the record.
Grateful to Lordship.
Thank you.
Extremely grateful. With your lordship.
Thank you. Next.
Affidavit of service. Milord, in this matter, Lordship,
Yes.
pursuant to the last order which was passed by this honorable court, we were supposed to give in a sealed cover the lookout circular and the other ingredients so that it can be perused by your lordships, because this is with regard to a lookout circular which we had issued. They are intending to get permission from this honorable court to travel abroad. Initially, the interim order was refused by this honorable court. We had filed our report, an exception was filed there too. So, my lord, the matter is more or less ready for hearing. But, Lordship, what I'm humbly submitting is that I am in some difficulty with regard to that sealed cover report, which Lordship needs to peruse in order to come to a. So, my lord, can it be taken up tomorrow or any day whenever my lord deems fit and proper? We'll get that sealed cover. And if it is at 2 p.m., it will be.
I don't have problem if Lordship takes it up tomorrow. To that extent, I have no problem. I have just one submission to make. The Lordship knows, my lord, these lookout circulars, my lord, earlier also wherever it has been challenged, because, my lord, if it's my right under Article 21 or Article 19,
To know the reason.
sealed cover adjudication, my lord, we have the Supreme Court judgment. I am to get a copy because, my lord, that's my challenge. You can't, my lord, give a court something. It's all right. You don't want to put it in affidavit because it will be part of record. But whenever my learned friend hands over to court, he should, my lord, a day before, he should give me a copy so that the time is not wasted. Because I am also ready, my lord. I can commence hearing now. I can commence hearing tomorrow whenever Lordship wants.
Yes.
Because, my lord, the point is very simple. The point is this lookout circular is covered under, my lord, there are three notifications of the government of India. The last of them is of 2021. It started from 2016. There are in interregnum, there are 3 or 4 notifications. In 2021, the entire lookout circular, my lord, the entire parameters are consolidated into one. And, my lord, it has been made into an office memorandum of 22nd February 2021. Now, my lord, it is very clear and categorical that you cannot detain a person just like that. And, my lord, there are specific provisions when you can detain it. And, my lord, now it has been fallen under the scope of interpretation of our High Court, Bombay, Delhi, my lord, unanimous. It is, my lord, there are 2 categories of persons, my lord, who intimate to the ministry that you issue a lookout circular. One category is, my lord, the financial creditors, because the banks, my lord, have been incorporated. And, my lord, the second category, which is now Lordship will come across, is what is
We are
called the
too late
serious
for that.
fraud investigation.
Come earlier and inform.
Serious
No,
fraud
I've already
investigation. My
taken.
learned friend is appearing for the SFI. Now, my lord, in this case, my lord, nothing has happened. They are investigating. We have their opposition. Investigation stage, my lord, there are precedents galore. You cannot detain a person. It is, my lord, the only provision of the circular is, my lord, either you say there is a cognizable offense and, my lord, even in that, my lord, if I am appearing, then there is no question of you have to show that I am likely to flee the country. Because, my lord, the authorities are using this as some sort of a coercion in almost every case, my lord. Maybe because of the Vijay Mallya episode, but they are using it as a sort of another handle in that tool of arms to sort of coerce. you are issuing lookout circulars just like that. Here, my lord, the opposition is saying that we are still investigating. And my lord, we have judgments of Delhi, Bombay saying that if you are still investigating in course of investigation, you can't issue this circular. Investigation, report to the government will say initiate proceedings, you initiate proceeding, charge sheet is filed, then only question of I don't attend, I don't respond to the summons.
Then lookout.
Then there is a question of lookout. So this is the short point. Well, Lordship wants, I can come back tomorrow. But if my learned friend can give me even tonight, whatever they are relying on. Because I am covered by the Supreme Court judgment that in Article 21, whatever.
But problem is that the earlier bench has passed an order, lookout circular we placed before.
No, that is in the first instance.
Correct.
This is, my lord, at the ad interim stage. Because, my lord, I have
an order dated 7th July, 10th July.
Yes. And, my lord, then, my lord, now it is well settled, my lord, even earlier other cases also. My lord, they come and put it in a sealed envelope, the court opens it, and, my lord, ask them, you give a copy.
Okay, let they file the seal cover. Let the
Lord, I come back tomorrow.
Well, as far as
and at the recent hearing, it is found that it has to be submitted.
Lord, I come back tomorrow.
what I'm humbly submitting is, first letter, we will come with the cover, my lord, and then if it is deemed fit and proper by your lordship to go through the contents of my lookout circular in the light of whatever report we have filed and whatever we have, then, my lord, the question of giving me a copy of my.
Respect, my lord, that is not.
That's why I'm telling. Let you file the lookup. You comply with the order. File.
I shall.
Because, my fundamental rights cannot be affected by, my lord, a sealed cover, whatever you.
That has been deprecated by the.
It has been strongly deprecated.
So when is keeping it tomorrow or on Monday, lordship?
When you will come?
Tomorrow, my lord, my application had become infructuous. I had international business.
My lord will kindly grant me an amnesty till Monday, my lord. Monday we'll get the seal cover if my lord so deems. What if my lord's diary permits? 10:30, my lord, if my lord deems it.
Learned counsel for the SFIU.
And my lord, we are filing our report.
Raise for time to file report in report in a seal cover. File the lookout circular in a seal cover in terms of the order dated 10th of July 2025. According case is adjourned, let the matter appear on 10th, 15th.
My lord, report on an affidavit may be taken on record. My lord, along with that.
Exception also.
On 15th July 2025, under the same heading. Under the same heading. Police stop. The affidavit, what do you filed? The report and the exception to report filed by the report filed the report number 1 and 2 and the exception. Be careful there.
My lord,
15th.
I'm grateful.
I'm for the CESC, my lord.
After the matter pertains to the petitioner's electricity connection being disconnected unlawfully, your lordship.
Have you inspected? There is a report.
My lord, yes, my lord. The difficulty is inspection was done from outside because we have annexed the pictures also. The meter service position is inaccessible. There is garbage in front of the main entrance. Unless we have two issues, unless those garbages are removed, we cannot access the service position. We cannot hold the inspection inside, number one. And number two, the meter room is in a completely dilapidated position. Unless that is also repaired, we cannot actually install any new meter over there or a service connection, loop meter, whatever.
In regards to that statement, your lordship, after the inspection was conducted, we had approached for the repairs of the meter room, but the private respondent stood in our way and had brutally beaten up the petitioner, your lordship. On that respect, I'm seeking police protection on that.
On the last occasion, my lord, the police was not available because they had not paid the police cost.
Lordship, that is not on our part because it was the prayer of my senior regarding the police protection.
Petitioner has to pay the police cost.
Yes, but that was not known to us. That was not.
Police cost the petitioner has to pay in any case.
The police cost not.
Huh?
Amount was not told, your lordship.
What
We were
amount?
never informed about the amount.
What amount?
The police cost amount.
Okay, police is okay. They have inspected the premises. Have you got the report? Give the copy.
Lordship, we did not.
See the paragraph 2. Paragraph 2 and paragraph 3.
Lordship, in that respect, I am ready and willing to. I am ready and willing to repair the meter loop, Your Lordship. Kindly keeps the matter pending, and in the meantime, kindly grants.
You remove the garbage and renovate the premises in question where the meter board is to be, the place in question where the meter board is to be affixed, and come. How much time? I am recording you. You submit that you will remove the garbage and you will renovate the place where the meter board is to be fixed.
Then we can go inside and ascertain the
Then
feasibility.
thereafter, then
Otherwise,
they
we
will
cannot
inspect the
accept it.
premises and
do the needful.
Or can do they will again inspect. They will instruct what is to be done on their instruction. You complete the work and submit the report.
Provided the garbage is removed. Otherwise, we are
Yes,
not
they
able to
Lord.
enter.
Lordship,
But I am for the private respondent, Lordship.
Yes. So garbage is to remain there, or you will be remain in the garbage.
But I am for the private respondent.
That's why the private respondent will remain in the garbage, or garbage will remain in that place.
No, my lord. The things is that the entire properties belongs to my client. We have giving him the electricity connection and everything. Because of they have done all this, my lord, and it is an inflammable condition. And the CSC told, my lord, if we do not, there is a fire hazard and all, inflammability. Now, my lord, the CSC has disconnected because of that. And they have done everything. And we have not charged anything for this, my lord, electric connection, my lord. We have provided them because they have, the entire properties belongs to us, my lord.
Okay,
And
okay,
that
no
too we have
problem,
filed,
sir. Sir, there is no problem. This court is not deciding the title only
Lordship,
with regard to
I am not on that.
regard,
I am not
with
on
regard
that.
let this court is only with regard to the electric connection, and you know the illegal occupier is also
No, my
entitled to have an electricity connection. He is in possession. If you are telling that you are the owner, you will renovate, you can renovate, or the petitioner, you will allow the petitioner to renovate only for the purpose of getting the electric connection and for removal of the garbage. Let it be done, and with regard to the whatever the dispute, you settle the dispute either outside of the court or go to the civil court.
Civil suit is pending.
Civil suit is pending, it will be decided. So I will record the providing the electricity will not claim any right title interest in favor of
But
the.
kindly record my submission that, my lord, we have never objected. We
Yes,
have never objected. The allegation is that we have objected. That is incorrect, my lord. That kindly recorded, my lord.
Completely false because
In terms of the order dated 29th of July 2025, the district engineer WBSCDCL or CSC?
CSC, my lord.
CSC has filed the report wherein it is found that during the inspection it was found that a very old two-story building exists at the premises where the petitioner is residing along with his family. The entrance of the premises was not easily accessible and almost blocked as it was full of garbage. It is also mentioned that the meter board room is near the entrance, found in very damaged and dilapidated condition. Then a counsel for the petitioner submit that the petitioner will clear the garbage and also renovate the portion where the meter board is to be fixed. Accordingly, full stop. Then a counsel appearing for the private respondent submits that the initially he is the tenant. You are the tenant.
No, Your Lordship. I am one of the sons. My father.
He is our relative. We have allowed him to stay there, my lord.
Counsel for the private respondent submit that he is the owner of the property and the petitioner is a relative, and they have allowed the petitioner to remain in the premises and had provided the electricity connection, but non-payment of the electricity connection, the same was disconnected. He submitted that he has no objection for providing electricity connection, but the petitioner cannot claim any right title interest over the property on the basis of the electricity connection if granted. Full stop. In view of the above,
And Lord, can you also record this entire garbage and all, because at their BS it has been done. We have not done anything. And because of the everything, if anything has happened, my lord, then my lord, my client will be the sufferer.
Put by the, has not been kept by the private respondents. Please, considering submission made by the counsel for the parties, the petitioner is directed to immediate and to clear the garbage and to inform the same to the CSC authority, and on receipt of the information, CSC authority will again inspect the premises in presence of the
To assess the
petitioner
feasibility.
to identify the place where the meter board is to be
Feasibility, yes.
fixed. Full stop. Full stop. Full stop. It is made clear that at the time of inspection, if any police protection is required, the concerned officer in charge of the police station shall provide proper police assistance to the CSC authorities for inspection of the premises in question. The cost of the police protection shall be borne by the petitioner. Let the matter appear on. How soon you will do?
Lordship, within 15 days.
Then after vacation, let the matter appear on 8th of January 2020. At the same heading. The report be
Grateful, my lord. Grateful.
Next.
I am for the respondent authority, my lord, the railway authorities. It is, my lord, may kindly recall, my lord, this is regarding using a drawing, my lord, which is this is, my lord, using a drawing in a tender, which the petitioner has claimed to be the proprietary item. My lord, specific query was on the last occasion was that how this design was used without the permission of the petitioner, my lord. So that was their case as well. Now, my lord, the background is, my lord, they participated in 2 tenders. My lord, in one of the tenders, my lord, the petitioners exclusively participated and it was floated for them only. My lord, in order to, my lord, uphold the fairness, my lord, that was withdrawn and subsequently a fresh tender was floated. Now, my lord, in that tender, this design which has been approved by RDSO has been annexed. Now, my lord, since the authority has approved that design was used as a standard design, not for any other reason. Now, the issue is, my lord, although this name and other things were inadvertently uploaded, and now the authority, in considering the importance of the project, my lord, the Indo-Bangladesh project, my lord, has decided to discharge the tender. My lord, since it's an inadvertent mistake, which has been pointed out, my lord.
So you do one thing, you discharge and file the report.
That's what. That is, my lord. Oh, I have the 1-page instruction. It is not a signed one, my lord.
My lord, I can't stand in the way, but I have a problem with using singular. There are 2 tenders that are assailed here. One, where I have said that you've used my drawing, which was of 9th of May 2025, in respect of which we have an injunction. Then they floated another one on 24th September 2025. If they're discharging both, then I don't have a problem. But if he's using a singular, then I will have a.
You want to do it? Put the tenders. Beat out.
It is genuine.
C and B tech, you get accurate to big.
So one thing, you take report
Very well, man.
with the sign of the concerned authority. Filing the court on the basis of the
Malad, filing a report, Malad, it's a northern frontier railway, Malad, bringing them again for Malad, that may take some time because it is a time issue. Time is the constraint.
If you could say you will get
because he's a friend and we played cricket together, it's strongly advised for him that he gets an email from his client and then
get email from the authority, now the email, and give the copy. When? Monday, Tuesday.
If Malad directs to the authority concerned to come and sign and affirm.
No, I am not. You are telling that the report.
Yes, Malad.
Whatever you made a submission, let come on written instruction from the competent authority, either mail and produce the same here.
Very well, Malad. We'll come back on Monday then.
Monday.
Instead of Monday, Malad, Tuesday.
Interim order to continue.
But the interim order is there till today.
As per the prayer made
and my with the affidavit in reply, Malad, if I may.
Respondents, case is adjourned. Let the matter appear on 16 December 2025 under the same heading. Interim order is extended till 18th of December 16th December. 18th of December 2025 or until further order whichever.
Well, may I file the opposition? And my reply.
What you file?
Well, the affidavit in opposition has my
Opposition and affidavit in reply filed by the parties be kept with the record.
Let's say same position.
Next.
My application.
Lord, I beg to appear on behalf of the respondent number 2. Lordship, would it be my lord's pleasure to take it up any day next week?
Why?
I could not.
Well, next week, then what next week the court will do? I am not giving any day to the other advocates who are mentioning the matter.
Because
The matter is in the list as a.
Lordship, it was an adjourned motion. It has come up today. I could not get time because it is a exhaustive, Lordship, lots
Which
of
matter, that blacklisting?
blacklisting, Lordship.
Why? A surprise?
How, Manoj? Does your lordship remember like that? Then I need to come prepared on Monday.
When?
Then again, my lord, if your lordship is enduring me on Tuesday, then endures me a little more with this on
Then
Tuesday.
come not Tuesday, then.
Oh, Wednesday, my lord. Wednesday, if I can.
Thursday, that matter, Thursday.
Thursday.
18th.
Thursday.
As
I'm
per the
great.
prayer made by the council for the.
My lord, my reply be. My affidavit in reply.
Reply na tomorrow. Exception.
Exception.
The affidavit,
Rejoined.
exception filed by the petitioner be
Be
kept with the record. As per the prayer made by the council for the respondent, case adjourned, let the matter appear on 18th under the same heading.
And look, respondent number 2.
Respondent number 2. Correct.
I'm grateful.
Next.
Grateful.
Please, your lordship.
Here for the respondent number 2.
But initially, we thought that it was a surfacey matter. We filed before the coordinate bench, my lord. But his lordship was pleased to release it on the ground that the real challenge is not a 13-2 notice. It is on declaration of the account as NPA. So there is no surfacey act which is coming. So his lordship said, I only have determination for surfacey matters. It was released, and I had mentioned that matter at 2 p.m. because it was released at 1 because the interim order was expiring, and we're ready to argue. Very short point involved.
Before my learned senior friend starts, my lord, the point of maintainability which I raised in the coordinate bench, my lord, it's still I am raising, my lord. So first the
What
point,
is the maintainability?
my lord, the actions under challenge is this on the very first date the submission was made that since 13-4 action is yet not initiated, so writ petition is maintainable, my lord. I relied upon a judgment of Honorable Apex Court of Phoenix ARC, my lord, of Biswa Bharati, where it says that even 13-4 is not initiated, even in that case also, the writ petition should not be entertained by the honorable courts, my lord. So that judgment I am relying upon, and this point is to be adjudicated first.
What is the prayer?
Yes, ma'am.
What is the prayer of the petition here?
Compel the respondent number 2 and 3 with the act in accordance with the guidelines, and the 19 June 2025, which is a 13-2 notice, cancellation of that notice, primarily that has been sought for, my lord. Now 13-4 actions are, my lord, the subsequent steps.
Now, what is the 19 June notice?
That is 13-2 notice, my lord.
14-2 notice.
13-2 notice.
13-2 notice.
Yes, my lord. 13-4 is a subsequent step of 13-2, my lord. So they cannot be segregated and said that 13-4 cannot stand independently. It has to be followed by 13-2 only, my lord. So this is 13, since 13-4 is a consequential step of 13-2. So this writ petition should not be entertained. And moreover, my lord, the Debt Recovery Tribunal under section 17 is sufficiently has jurisdiction to decide whether declaration of NPA is good or bad, or whether it's as per the RBI guidelines or not, my lord. So if it is, it can be decided, it falls within the jurisdiction of DRT, my lord, then.
The MSME?
No. May I just place this judgment of.
That is a different matter which I mentioned in the morning.
So it's a copy. Here also, my lord. My lord, para 37 onwards are the relevant paragraph. Here also, my lord, prior to 13-4, an intimation was given. Challenging that intimation, the writ petition was preferred, my lord.
Paragraph 37.
Yes, my lord. 37 onwards, my lord. May I read?
No, not.
Okay, number.
Yes, where is the notice?
My lord, it's appearing at page number 13 to
19 June notice?
correct to 13 to page 60. 68.
68.
Yes, my lord. Page 68.
So why it is stated that it is not under surfacing?
I'll indicate to you, Lordship.
Okay, okay. I will come. Yes. Yes.
One more point, my lord. This writ petition is also premature, my lord, because if the petitioner has made a representation to Reserve Bank of India challenging this action, if the petitioner is aggrieved and the Reserve Bank of India has not responded to their representation, they could have approached to Banking Ombudsman, my lord, under the scheme of 2021. There also the petitioner can seek for redressal of their grievance. So this writ petition should not be entertained on these 2 points, my lord. Then on merits, I will make subsequent.
But we were also under the impression in that it would be a surfacey matter. But then, the challenge in the writ petition is a wrong declaration of the account of the petitioner as NPA dehors the RBI guidelines. That is the challenge. So there is no surfacey act which is involved. So that is why it fell from the other. So may I indicate one thing? Declaration of an account as NPA is not within the provisions of the Surfacey Act. It is only as per the guidelines. The petitioner's case is that, kindly notes 2 dates. First is, we were issued an email on 29 January 2025 saying that if you do not deposit 7 lakhs, your account will get stamped as NPA. Will get stamped as NPA.
Date?
29 January 2025 at page 61. Kindly takes a look at page 61, Malud. One line email. As per joint call along with credit, please deposit rupees 7 lakhs into your cash credit account, else account will get stamped NPA.
Yes.
So, Malud, we deposit after that.
Yes.
But I'll not take your lordship to that, my lord. What I'll humbly beseech your lordship to look at is, my lord, the Reserve Bank of India circular. Kindly permits me to file my supplementary affidavit.
No, see, so after that, what you have done? 939, you have deposited the amount.
I have deposited, but I am not on that. What they did was they declare my account as NPA the day before, 28 January. Kindly seize that from the 13-2 notice.
Where is that?
Page 68, which my learned senior friend was showing. Page 68.
Yes.
Kindly takes a look at page 69, paragraph 2, my lord. In fact, at page 70, I'm sorry, paragraph 3, page 70. You as borrowers, I'm not troubling you, the first portion has been classified as NPA on 28/1/2025. So, my lord, we were asked to pay, but the day before they say that it has been classified as NPA. In the meantime, there have been several correspondence. They never intimate
What's the date of this letter?
This letter, 19 June 2025. For the first time, I come to know my account has been declared as NPA on 28 January. Now, my lord, your lordship knows, my lord, as per the master circular of the Reserve Bank of India, and I shall take your lordship to that, where there are certain guidelines which the Reserve Bank of India has formulated, which requires to be mandatorily followed before declaring an account as NPA. Kindly takes a look at my supplementary affidavit, which is filed already, my lord, where we have annexed that guideline. My lord, we'll kindly have a look at page, my lord. It starts from, my lord, page 6, kindly comes to page 10. My lord, will find clause number 2.1 is non-performing assets. Has your lordship got it, my lord? Page 10. Then kindly sees 2.1.2. A non-performing asset is a loan or an advance where in interest and or installment of principal remains overdue for a period of more than 90 days. So, my lord, interest or principal remains due for 90 days. Then 2, the account remains out of order as indicated in paragraph 2.2 below. I shall show that in respect of an overdraft or cash credit account. Then, my lord, 3 we are not following because this is not bill discounting. Kindly turns over and looks at clause 2.2, which is out of order status. This is where the affidavit in opposition has been filed by the bank. 2.2.1, a cash credit or an account or an overdraft account shall be treated as out of order if, kindly sees 1, the outstanding balance in the cash credit or overdraft account remains continuously in excess of the sanction limit or drawing power for a period of 90 days. That's the first condition. Or 2, the outstanding balance in the cash credit or overdraft account is less than the sanction limit, but there are no credits continuously for 90 days. This is the 2, no credits for 90 days. Then 3, or the outstanding balance in the cash credit or overdraft account is less than the sanction limit or drawing limit, but credits are not enough to cover the interest debited during the previous 90-day period. So, my lord, all which I need to satisfy your lordship that their declaration as on 28 January is also bad, because for a period of 90 days before that, I don't fall under any of these. So, if I am satisfied,
So you got the notice on 29.
I got the notice on 29 saying please deposit. Otherwise,
that's why you got the notice on 29. But subsequently they declared as per their letter that June
subsequently they
2025
intimate that it was already
declared. And in between, what has happened?
In between, I have also paid. I shall show your lordship that from February I have paid. Before, and I also need to show that before, for a period of 90 days preceding 28 January, the date of declaration of NPA, I have paid. So either way, I will satisfy your lordship. Kindly now takes a look at their statement, which my lord will find. But one more thing, my lord, kindly takes a look at page 35. Kindly sees Page 35, this is of the writ petition. These are payments made in March after that. They wanted us to pay 7 lakhs. How much we have paid?
35.
35.
Of the writ petition.
Of the writ petition. Now kindly sees 3 payments on that page: 1st March, 6th March, 13th March. At page 35.
Yes.
Your Lordship has seen 3 payments.
Yes.
1st, 6th, 13th March. Kindly takes the next page, my lord.
First, this is 35.
Yes.
Payment made on
1st March, 6th March, 13th March. Your Lordship, the mail is, my lord, 29 January.
Yes.
So these are payments after that.
Yes.
Kindly then turns to page 36. Kindly sees February. 7th February onwards, your Lordship will find several payments. And only in the month of February, there are payments of 9.25 lakhs. Kindly sees page 36 bottom. Total credits, my lord, will find 9 lakh 25.
9 lakh 25.
Yes. They wanted us to pay 7 lakhs.
Yes.
So we have paid that.
Yes.
So they could not have declared my account as NPA. But they say it was already declared as NPA before that mail was issued. Very well. I now need to satisfy your lordship. That is also wrong. Kindly comes to page 37.
Yes.
I'll only point out the payments for the 90-day period preceding 28 January.
Yes.
Kindly sees 2 payments, 9 January, 28 January. 50,000, 1 lakh. Then kindly turns over to page 38. This is December.
Yes.
45,000. Kindly turns to page, my lord, 40. My lord will kindly mark payments from 30th October. 24th October I can't show because that is beyond 90 days. Within 90 days I have to show. 30th October lordship has seen 4 lakhs.
Yes.
Then kindly marks, my lord, 31st October all the other payments: 65,000, 63,000, 64,000, 63,000, 64.
Yes.
So, my lord, these are the credits within that 90-day period.
Yes.
So, my lord, none of the clauses, and also sees what is the opening balance at, my lord, page page 36. No, I'm sorry. I should show what is the opening balance as on
January.
January. Yes. That my lord will find January is opening balance. Yes, page 37. Kindly sees 1 crore 40 lakh.
37.
At the bottom, my lord, opening balance. My loan was 1 crore 50 lakh.
37.
Page 37, bottom, my lord. There is a small table. Opening balance 1 crore 40 lakh, 58,172. My loan was, my lord, 1 crore 50 lakh. So it is lesser than that. So, my lord, they do not come under.
So this is of January.
Yes, as on January, when they declare the NPA. Even if your lordship goes back for 90 days, then also I will show from page 40 that it was 1 crore 43 lakhs.
Yes. 40.
Page 40.
Yes.
Kindly sees as on January, 1 crore 43 lakhs lesser than my limit of 1.5 crore. That is the limit. The sanction limit.
What was your limit?
1.5 crore. This is lesser than that. So, my lord, I I come out of the first two clauses of 2.2.1 that my outstanding balance is not in excess. So 2.2.1 goes out. And the first part of in the supplement, I'm sorry, page 11 of the supplementary affidavit. I'm sorry, I should have.
Yes.
Kindly see page 11, 2.2.1. The first portion is the outstanding balance in the cash credit or overdraft account remains continuously in excess of the sanction limit or drawing power for 90 days. I go out of that. Then 2.2.1, then Roman.
Sanction limit was how much?
1.5 crore.
$1.5 crore.
So 2.2.1, I go out. 2.2.1, small Roman 2, that no credits for continuous 90 days, not there. They are only falling back on the last limb,
Outstanding balance.
which is credits are not enough to cover the interest debited. So I need to satisfy on the quantum of the credits which I have paid. I had shown the entries. Now kindly takes the pleading in my supplementary affidavit. Now paragraph 3.
Yes.
But I had indicated how much I have paid. But on 31st October, 65,000, 63,000, those payments, my lord,
Yes.
I had indicated.
Yes.
So the total amount for October is 3,19,000.
Yes.
But I should have also shown, that's a slip on our part. I should have also shown the payment of 4 lakhs made on 30th October. My lord, 4 lakhs your lordship had marked. So that is 3,19,000 and this is missing in the supplementary. It just struck me. 4 lakhs would also be there. Now, in December, 45,000, I had shown that to your lordship. Paragraph 4. Paragraph 5, in January, 50,000 and 1 lakh. No, my lord. So, as on declaration of NPA, within the preceding 90-day period, I have made payment. That is my averment in paragraph 6. 5 lakh 14, that should be 9 lakh 14. Because that payment, my lord, it had slipped our mind, my lord. That 4 lakh payment on 30th October. It had slipped our mind. That should have also been added. It should have been 9 lakh 14.
4 lakh is paid on?
On, yes, one kindly sees page 40.
Yes.
The declaration of NPA is 28th
28th January.
January. So from 28th October, I can show.
4 lakh is 30.
Yes, 4 lakh is 30. This we have missed, my lord. Now, my lord, the respondent's contention in their affidavit, and I shall show where, is that the total interest
Yes.
is, my lord, more than the amounts credited.
Correct.
Now, my lord, we'll kindly have a look at their affidavit in opposition once. Kindly comes to page 8. There's a table given at page 8 of their affidavit in opposition.
Hey, affidavit. Have you filed the affidavit?
Yes, yes, my lord.
Where is that?
In the last date, my lord, I filed my
opposition.
Affidavit in reply is there. Opposition.
Opposition, I have also filed, my lord. In
Dekho.
the last date only I handed over. Hand over. Last date.
No, you check it. Affidavit in opposition is there or not?
It's
तो सोनी हो जाए बैकशीट में सोनी हो जाए
it's part of it.
Affidavit is not there. Check your file.
My lord, I on the last date it has been also recorded in the. देखिए,
दो, यहाँ दो.
No, no, it was a reaction.
May I hand over my copy, my lord? नहीं?
नहीं copy नहीं.
What did you put over there? Recorded or uploaded?
You have extra copy, give us,
Yes, may, I'm handing
give the
over.
copy. Yes.
Hard copy. Kindly comes to page 8. There's a table your lordship would find at page 8 of the AO.
Yes.
My lord, interest debited. First row is interest debited till 31st October 2024. So they say it's 1,26,585. But amount actually paid by customer, there is 0.
That has not been calculated.
I had paid 3,19,000 plus 4 lakhs.
519.
No, 3,19,000, 719. Then they say interest debited till 30th November, 1,17,000. I have paid 0. Correct. This is correct. Then they say the next two headings, PRPINS, both the headings, PRPINX, these are not unpaid amounts which are liable for, my lord, payment under the RBI guidelines. Some charges they may levy.
The insurance.
Something else. So my lord, these cannot be calculated for saying I have not paid the interest. Then comes December. December, your lordship will find it says 2,11,059.
Yes.
I have paid, my lord, 45,000. That is indicated.
Yes.
But before that, I have already paid in excess. Kindly then comes to January. They do not indicate anything. But in January, we have made payment of 50,000 also, which they don't take into account. They only take into account the 1 lakh. So my lord, in all, I have made a total payment of, my lord, 9,14,000.
5, 8, 7, 8, 9 lakh.
14,000. I had pleaded it's 5,14,000. All of us missed that. We all take the responsibility. We have missed the 4 lakhs. Now, kindly adds up their interest for the months of October, November, and December, 3 months preceding January. That this comes to 4,55,578. I have paid more. Even if your lordship takes these two charges,
What is that? 4,50,000?
455,578, I have deducted 3 amounts from their table.
Yes.
First is that 17,526. Second is 30,131. And third is that 50,000 penal charges. But even if your lordship takes those, that can increase it by at the most 80,000, 1 lakh. So 4,50,000 would be 5,50,000. I have paid 9,14,000. So they don't fall under the third limb as well. That interest is not sufficient for that 90-day period. So, my lord, the declaration of my account as NPA is wrong. This is where, my lord, why this is not a SARFAESI act, my lord, and we had argued up till this. But then it fell from the honorable judge that so you are not challenging the SARFAESI action per se. I said yes. And where is the declaration of NPA? It is only under the RBI circular. So, my lord, the alternative remedy which my learned senior friend pointed out is also, my lord, not attracted.
Yes.
So we are challenging the root. The NPA is bad because it is violative of the Reserve Bank of India guidelines. We have clearly made payments in excess of whatever the interest was. So the declaration is bad. That's all.
Thank you.
Mark kora ache. Mark kora ache.
First of all, my lord, I would place the RBI guidelines that on the third point, my lord, the third part of the 2.2, my lord, that the amount paid is not sufficient to cover the interest, my lord. Now, my lord, kindly come.
If it's taken also, but
Yes.
kindly come to the paragraph 7, page 8, paragraph 7 of your affidavit in opposition.
Yes, my lord.
Paid actually, amount actually paid by the customer, nothing.
Yes, my lord. I'm coming to that, my lord.
Could I get a lordship?
My learned friend has taken a point that 28th January already declared NPA. How come the bank can issue a notice or an email on 29 January, my lord? One point that, second point was that the amount paid, the petitioner can take from 28th January till 28th October till 28th January on the date of declaration, which is not correct, my lord, because if we go back 90 days from 28th January, my lord, the date would come strike to 31st October. So whatever payment made till 30th October will not come in this 90 days period, my lord. And the bank's grievance is also not till 30th October. The default starts from the 31st October period, my lord.
But you have declared the NPA on January 20th January.
Yes, my lord. The 90th day, my lord.
90th day.
Yes, my lord.
Show me when the amount due, when the bank this amount was due, first date.
Yes, my lord. Kindly before that, may I just point
Because
out
you are
one...
telling that the 20th January 90 days is completed.
Yes,
so
ma'am.
if back to the 90 days, so when it will come, November?
My lord, it will 31st October.
31st, that's right, 31st
Yes,
October.
yes,
So
ma'am.
show me the account.
Yes, my lord.
31st of October, what was
My
the
lord,
amount due?
yes, my lord. I have annexed in my opposition itself, my lord.
Yes.
But before that, may I just place the sanction letter, my lord, so that that would be what was the actually interest the petitioner was liable
I
to
will
pay.
come. Let me show on 31st what was the pending due.
Yes, my lord. From 31st, it is evident from their supplementary affidavit itself that, my lord, from 31st October, some payments, my lord, amounting to 65,000, then 63,000, 64,000, these were paid, which were not sufficient to cover the monthly interest of the cascade account, my lord.
Correct.
Now, kindly come to the statement of account which I have annexed in my
Where is
opposition. My lord, page 15, my lord.
Page 15.
Yes.
Yes.
The first entry is of 1st November 2024, my lord.
Correct.
It reflected the interest which was earlier paid in October 31st. So there was no delay payment days mentioned. Thereafter, if my lord takes up, in every month, there was delay of 31 day, 58 day, and the interest which was monthly payable on this amount, the utilized amount, kept on increasing, my lord.
Correct.
Which by 28th January, it was around 6.67 lakhs.
January 25.
28th January, my lord.
28th January. Where
Yes.
is it? Where, which page?
My lord would find 28th January on
Next page, your
next
lordship.
page, my lord.
Page 16.
Yes, 28th January.
Yes, my lord. In
Cash
this,
deposited.
yes, here,
NPA
my lord.
stamp. NPA stamp.
Now, my lord, this 28th January, this was a tentative date where the loan account, upon due to default on 90th day, it could have been classified as NPA.
Then if it will go by this also. So why you issue the email on?
Yes, my lord. I am coming to that, my lord. It was the fixed date on which I have explained in my opposition also that this was the date on which it should have been classified as NPA. But to give a chance, because it was not marked yet on that particular day, to give a final chance to the petitioner to pay so that the account does not slip into NPA, my lord, a 29th January email was issued, my lord, and a rough amount of 7 lakhs were sought for because 6.67 was dealt due that date towards interest. So till they calculated the interest up to 31st and a roughly amount of 7 lakh was called upon to pay so that this can be saved from slipping into NPA, my lord. But that 7 lakh was required to be paid immediately, my lord. They have paid some payments. There's no dispute. But that were not paid on the immediate basis. First of all, 7 lakh was not paid. Second thing, my lord, in some portions, some 50,000, 1 lakh was paid in January.
Then some amounts were paid in February, my lord. So by that time, it was, since had the petitioner paid 7 lakhs on the very same day or by 31st January, my lord, probably the loan account would not have been classified as NPA because it could have been saved. But since that amount remained due, and they continued to make some tricky payments till February, my lord. So that's why this was classified as NPA. And now after once this, it has been tagged, marked as NPA. So whatever amount was paid in February, my lord, that was adjusted.
When the first
towards.
notice was issued for regarding NPA?
My lord, NPA, they are well aware what default they are committing. There is no notice. There is no notice. If I can, there was a reminder which was given to pay, but
When?
well, 29th email they are placing, that could be taken as a reminder, my lord. And there was no specific.
So if you are telling that 29th email, you are admitting that, and you have no document to say that you are failed to pay the interest or whatever the principal, whatever it is, your account will be NPA on so date. Now you have revert back stating that in the month of January, you are stating that your account will be NPA will be declared.
Yes.
29 January. But
yes.
Subsequently, 28 January itself, you have declared the account NPA without issuing any notice. So what would be the effect of that?
My lord, I'm again repeating my submission, my lord, that 28th January was the tentative day fixed, and a last opportunity was given to the petitioner by 29th email. Since they failed to pay the amount,
Correct.
in the subsequent notice, it was mentioned.
That's what I'm telling you, have given the email on 29.
Yes, my lord.
But you have declared the NPA on 28. And that to be, you have declared and intimated to the petitioner in the month of June.
Yes, my lord. On that, my lord, I would submit that there is, as per the law, it's well settled. There is no requirement to give a prior intimation before declaring NPA. I am supported with the judgment of the Honorable Apex Court, my lord. And since the petitioner is operating the account, regularly receiving the statement of account, it's their obligation to see that the entire interest is paid regularly, because it's a cascaded cascaded account, and the interest has to be paid monthly basis. Otherwise, it will come under default, my lord. And if my lord wishes, I can place the judgment of Supreme Court, my lord, where it says that no notice for prior to 13.2 is required.
Now you will confuse. You take note, I will take your reply. Whatever the submission, you take note of. Yes.
My lord, kindly come to, it's para 20 onwards, my lord. Here also, I'm just, yes. Kindly come to paragraph 14 onwards, my lord. At page, it's the page number. Page 9. I'll give you a copy. I have got a copy. You can take. I'm para 14 onwards. That's it. Neelam beverages. I'll give the review one more time. Just give me one second.
Yes.
So no prior notice is required, my lord. It's their account. They are operating, utilizing the amount. So they are well aware what is their default. And may I just place the sanction letter, my lord, so that it would be clear that the interest was required to be paid monthly without default.
What was the sanction amount?
Yes, my lord. Whatever the
5.
my lord.
What was the sanction amount?
1 crore 50, my lord. The sanction letter starts from page 26 of the writ petition. The relevant interest clause is at page 27, my lord.
26.
Yes.
Yes.
And the interest clause is at page 27, my lord.
Yes.
So at the point of time of sanction, the interest was 10%, my lord.
Where? Interest?
Yes. T-bill, TM, that I cannot.
10% current TABL.
The current rate was, at that point of time, it was 10% on the utilized amount, my lord. And from a statement, my lord would find that they utilized the amount. It was regularly increasing, but the interest which were required to be paid, that were not paid, my lord. So this is all on merits, my lord. This is
Okay. Yes.
We are debating from the statement and the affidavit.
No, that's not only they have taken the plea. They have taken the
I've
plea.
stated in my affidavit that the last opportunity.
Your account.
Kindly see page 50. Possibly I need not.
1.5.
Yes, page 50 of the affidavit in opposition. They did not take into account my payment.
When you made the payment?
In January, in October, I made these payments of 7,90,000. That is not even reflected here.
No, that's why they have.
So their credit is zero. Kindly see page 15. Credit is zero. I have paid 7,19,000.
Where it is 7,19,000?
No, I shown from the.
No, when you are paid.
On 30th October, 31st October.
That is October 24 or 25?
24. October 24.
Just
Page, kindly see that one.
34. Page 34.
Yes. Page 40.
Page 40.
Page 40 kindly marks the dates below. In fact, total credits for October is 10,49,000.
Just a minute. Yes. It is 1st October to 31st of October.
Yes. Kindly see total credit at the bottom of that page. 10,49,000. Their own document. It's not my document. Yet in page 15 of their AO, they say total credit zero. It's a bank wallet. They are coming up with should be responsible in indicating the stand import. My benefit has not been properly instructed by the bank officials. And this is page 50. They say total credits is zero in October. So 10,49,000.
No,
vanished.
interest debited till 31st of October. Kindly come to page 15.
Page 15. Credit is zero.
1st November 2024. Page 15 of the your this affidavit in opposition.
Yes.
Page 15, serial number 1, transaction date, 1st November 2024. Correct?
Yes.
Interest debited till 31st of October 2024.
Yes. That
And
is debited is 1,26,585.
yes, amount is
1,26,585.
1,26,000.
Credits zero.
Yes.
Credits is zero.
Credited 0.
Zero. I paid 10,49,000 going by their statement. Your lordship need not believe my word for. I'm showing their statement. 10,49,000. That vanishes. So now they are saying, so your running balance is minus 126. It's plus. It's
Yes,
plus
ma'am.
9 lakh.
How it can? Kindly come to the page 15. Kindly come to the page 15, tally with the page 40 of the writ petition.
And also one thing, I should also satisfy your lordship conscience that we have made payments post January also.
Kindly come to the page 15, which you relied upon, and kindly come to the page 40 of the writ petition, where this amount you have calculated. 10,49,000.
My lord, till once again I am submitting, my lord, till 30th October, my lord, whatever payment was made.
So immediate 10th of, so how you can say the 90 days from
The
when?
default start from 31st October, my lord. The
Hmm.
day calculated is from 31st October, my lord.
Correct.
So from November, this
No,
default.
but here, why you are saying, kindly come to the page 15.
Yes, my lord.
1st November 2024.
Yes.
1st November 2024. The amount 1,26,585. Where you mentioned that this amount was where is your bank account of the prior? Where is the bank account of prior? Once the 31st October till he has paid the 10,49,000, how it be balance again? Within 1 day, 10 lakhs. Within 1 lakh, 1,26,000.
No, my lord. If 126 was adjusted interest for the last month, my lord.
So
Now
where
the
is
default
that?
start from
So where you adjusted? Because it is October 10 lakh 14. Where you adjusted? Show me the total. Then you have to come with the total balance sheet and total accounts.
But still 90-day window is not.
That's because your 90 days is to be as per the as per the RBI guidelines. 90 days is to be calculated.
Yes, ma'am.
90 days is to be calculated from which date he has defaulted.
Yes, my lord.
Not paying that.
Yes, my lord.
That from that day 90 days is to be taken into consideration. So you are telling that last payment was made on October 31st. November 1st November 2024. You are telling that 1,26,585. So how you came to know? Where is the previous balance? So how you adjusted this 10,49,000? In 1 month?
My lord, then I will file the previous statements also.
You have to disclose the total balance. That is the bank doing.
Yes, my lord. I'll disclose the previous balance also.
They've made 9,25 payment
No,
in
but
February also.
no, that was post declaration of NPA because from 31st.
That's why if I will go by your word, 1st November onwards he has not paid.
Yes.
You have taken as the 1st of January 2020, January 2028, declared 28th of January 2025, you have declared the NPA.
Yes.
So 1st November you have taken the exact date
Yes, ma'am.
for the not paying the amount.
Yes, ma'am.
Correct.
Yes.
So how you have calculated the 10,49,000 which was paid up till 31st October?
Well, that was for the previous month. That was for the previous month.
You have to
which were adjusted.
when the loan was sanctioned.
It is sanctioned in.
When the loan was
Yes, my lord. It has been sanctioned. It was renewed lastly on 29 December 2023.
2020?
2023, my lord.
So when it was renewed, what was the due was pending? There was.
My lord, it was renewed for 1 crore 50 lakhs.
1 crore 50 lakhs.
Yes.
So you have to come with that only.
Yes.
1 crore 50 lakhs on December 2023.
Yes.
So you have to come. Then you have to calculate it from which date he has defaulted.
Yes. Then I will file a supplementary with disclosing all the statements, my lord.
You also will kindly not permit them to use a supplementary affidavit for only 1 week. The look back period is 90 days preceding the date of declaration of income. I may be a very bad person beyond that 90. But if I am not that bad, as per RBI circular, my account can't be treated as income.
No, that's
So it's satisfied with lordship that I have paid in excess of 10 lakhs.
You have that's something.
From 31st October.
No, that's it. No,
it is the 90
Mr.
days.
Gupta.
Pay 7 lakhs that your account otherwise will be treated as income. I
No,
have paid 9 lakh 25.
That's correct. That's correct. But their contention is raised that from 1st November 2025 you are in default. Their contention is the first. Kindly see page 15.
But they should have then declared me as NP on 1st February.
1st February.
28 January has to. And 1st February also has to go because I've paid 9 lakh 25 in February also.
From 31st till 28, it will come to 90 days. Lord, may I file a supplementary disclosing the statement?
Give the total details.
Yes, sir. I will.
Give the total details. How you calculated this amount?
Yes, sir.
How you calculated this amount?
Yes, my lord, I will file.
Because bank given you the 1st November, prior to the 1st November, the 10 lakh, where did the 10 lakh has gone? 1 month? 1 month 10 lakh interest. So prior to that, that means he was.
It is not paid in the month of October, my lord. It was from the previous.
October.
Then I will come with the exact calculation.
Kindly come to the page 40. 1st October, 31st October.
Yes, my lord.
1st October, 31st October.
Then I will come with exact calculation that what was the amount payable towards
See,
interest.
since the renewal till this date,
Yes, ma'am.
what was, how you have calculated this?
My lord, it has to be on the basis of.
That will be neither here nor there, because unless they satisfy that 90-day period, then my lord, they cannot.
That's why the 90 days period has to see when you have defaulted, from which date you have defaulted.
Yes, but if I have paid 10 lakhs in October.
That's why I wanted this. That's why I want this 10 lakh. They are telling that the 10 lakh is prior to that. That's why they have adjusted.
May I just make one
They have not made the case.
That is not their opposition case also.
So may I just make one submission, my lord? Since the monthly interest is to be paid on the utilized amount, my lord, so the monthly interest would vary, my lord. If they have utilized 1 crore 40 lakh, then the 10% interest would be charged on that amount. My lord. So it can be even more than 10 lakhs or less than 10 lakhs, whatever, it depending on the amount of utilization, my lord.
1 lakh, 1 month.
My lord, depending on the amount.
I paid 10 lakh 40.
Correct. So October, what was the due? If the October 1 lakh 26 was due and you have received the 10 lakhs, so where was the default?
My lord, I will come with
Where
that
was the default?
with the calculation.
So we are telling that the 1st November, 31st you had received the 10 lakhs. How the 1 lakh 26 on 1st November? Got it?
Yes, ma'am.
So the counsel for the parties have argued the matter at length, but for the clarification, the learned counsel for the bank prays for time to file supplementary disclosing the statement, disclosing the statement of the amount paid by the petitioners since the date of renewal till the month of January 2020. Till what the last date you have paid the amount? Last
30th October.
No, I paid till January.
Till January 2025, no?
Yes, yes. Give your lordship the exact.
No, February also paid.
But till 30th January, I'm
31st, no, April also paid. May also paid. Till the 28th of January 2025. Okay. And let the supplementary affidavit filed by
a week, my lord.
Within a week after serving the copy to the London consul for the petitioner. Please the matter on 22nd December. In the meantime, this court hope and trust the bank will not initiate an insurface proceeding against the petition.
My learned friend is present already for the petitioner.
Who is for the petition? Yes. So next month, January.
No, Lordship. Fix the matter for urgent.
So what can be done? If urgent fix,
No,
if
no.
other properties
Lordship.
having personal difficulty.
No, Lordship, if your Lordship takes it, then I will.
Consider adjourn, it will go to the next month.
Now I
It is choice is yours. Yes, call the matter.
Item number 17.
Lordship, I am appearing on behalf of SEBI, Lordship.
May I please your Lordship, my lord, I am appearing for the petitioner.
Yes.
My lord, the writ petition before my lords is basically against the continuous inaction of the SEBI authorities, specifically the recovery officer, in defreezing my accounts. I'm a senior citizen. My lord, in 2011 to 2012, during that period of time, my lord will recall that there were certain scams regarding the financial and money laundering cases. One of such company was Greater Calcutta Infracon Private Limited, my lord. This company, my lord, I was a director there for 85 days. I was illegally inducted as a director therein, but I am not on that point, my lord. Thereafter, my lord, applications were filed before the SEBI by the aggrieved investors, and SEBI accordingly took decision through the whole time member under section 11 and other sections of the SEBI Act. My lord, kindly comes to that final order of the SEBI once, where from my case starts, my lord. It is annexed at page 45, but the relevant portions I'll first indicate, my lord. Paragraph 47 and 52 is the ordering portion, my lord. Paragraph 52J, page 71 first, and then, my lord, page 75 of the writ petition.
71.
71, my lord.
Yes.
My lord, page 71, paragraph number 47. Kindly sees the observations drawn up by the whole time member SEBI. Mr. Shubir Datta is the authorized signatory of the company for banking transactions and payments to the parties, etc. Therefore, Mr. Shubir Datta has active role and key person in the dealings with and transfer of the proceeds received by the company from the debenture holders. In view of this, though Mr. Shubir Datta is jointly and severally liable for the refund, and if there is a failure to refund, it would be appropriate that the recovery may be considered against the assets of the company first. My lord, kindly takes this part. Recovery may be considered against the assets of the company first, comma, if there are sufficient assets are available, and thereafter against the assets in the name of Mr. Shubir Datta, and at last the recovery officer may consider proceeding against the other notices. My lord, I being the petitioner, Amitava Sarkar, comes within the other notices, who were never a director at that point of time when SEBI initiated the proceeding against the company. Yes. Thereafter, my lord, kindly comes to page 75, which is, my lord, the ordering portion. Page 75. It is the subparagraph J within the paragraph 52, which is, my lord, the ordering portion. In case of failure of GKIL, that is the company, my lord, Mr. Amitava Sarkar, which is me, Mr. Himangshu Mukherjee, Mr. Shutonu Sarkar, and blah blah. These are, my lord, that point of time they were the directors. To comply with the aforesaid applicable directions, SEBI, on the expiry of 3 months period from the date of this order, may recover such amount from the company and the directors liable to refund as specified in paragraph number 52A of this order in accordance with 28A of the SEBI Act, including such other provisions contained therein. The recovery officer, again, my lord, this portion is important. The recovery officer may consider proceeding against the assets of the company first, if there are details of sufficient assets of the company, and thereafter against the assets of, in the name of Mr. Shubir Datta. And at last, my lord kindly notes, at last recovery officer may consider proceeding against the other notices. Therefore, my lord, the whole time member of SEBI has placed a
a waterfall rule through which the recovery should go. Thereafter, my lord, several notices, my lord, I have placed before the SEBI authority, which are, my lord, annexed at page 78 to 86. I'll not travel, my lord, to go in every one of this. The crux of these, my lord, letters are, I asked the SEBI and the other officers of the company at that point of time within the key managerial personals that what is my proportional share for that 85 days of directorship, my lord. And my lord kindly notes that I was there for 85 days. That has also been found by the SEBI whole-time member at paragraph number 39, 3 and 40 in the same order. I am not going into it. Thereafter, my lord, I have not received any reply regarding what is my proportionate liability. Thereafter, my lord, a notice of attachment has been issued, which is, my lord, annexed at page 87 to 90. It was issued in 2021. Recovery officer initiates an attachment proceeding and all of my bank accounts are attached. Thereafter, my lord.
What you paid for here now?
My lord, that is, my lord, the point, my lord, I could have went to the securities tribunal.
Correct.
But my lord, to be very honest, my client is basically a layman and I have received this matter the last year only. And at this point of time, the appeal before the appellate tribunal is time barred, my lord. That is why the only remedy which is lying before me is before this court, my lord. And my lord, during...
If the appeal time is barred, then the writ petition can entertain.
My lord, the writ petition can be entertained on the point of fundamental right violation, my lord, because I am a senior citizen and my lord, there is a basic violation by the recovery officer in attaching my properties when already there is a report. I will go into that, my lord. Report says that only the assets of the company is amounting around 4.65 crores. The amount recoverable from the market, the amount aggrieved, my lord, through the investors is, my lord, 1.25 crores, something like that. That means, my lord, the company's assets are sufficient enough.
The appellate authority condonation is not applicable.
Lordship, if I may, Lordship, I'm appearing on behalf of SEBI, Lordship, in this matter. Lordship, I'm challenging the maintainability of this writ petition, Lordship. Because, Lordship, as per the provision mentioned in the SEBI's Act under section 15T, my lord, they should have first filed an appeal before the SAT, that is SEBI Appellate Tribunal, and if they would have failed over there, very well they could have come and invoked the writ jurisdiction. But their point that the condonation of delay, they can very well file an application for condonation of delay. But what they are saying is since they do not have any time and they have been barred by time because the appeal needs to be filed within a period of 45 days, they cannot file an application before appeal over there and they have invoked the writ jurisdiction.
2018.
With regard to, my lord, there was a previous writ petition filed which was, my lord, wrongly drafted and that's why I withdrew it. Thereafter, I got the brief, I withdrew it and filed the new writ petition, my lord. And so far as the point of alternative statutory remedy is concerned, my lord knows is very well that alternative remedy is upon the discretion of the writ court. It does not mean that mere there is an alternative remedy available, does not mean that writ jurisdiction is completely barred. That is, my lord, upon the discretion of the court. Now, my lord, if there is, I am able to point out a basic violation of fundamental rights, then, my lord, these are the exceptions of the doctrine of alternative remedy. My lord knows that natural justice violation and fundamental right violation, specifically right to life violation, is, my lord, these are the, my lord, the exceptions to the basic principle of the alternative remedy. Now, my lord, I am a senior citizen and my accounts are freezed since last 5 years without any further proceeding. Thereafter, my lord, I will not trouble to enter into all these judgments, my lord.
What the SEBI has passed an order.
My lord, the SEBI's inaction is very clear. Thereafter, my lord, there are several representations, my lord, which I have preferred. Not a single representation has been answered. I have also filed a defreezement application before the recovery officer. That was considered and that was rejected. That order is also annexed. Now, my lord, defreezement is necessary because I am a senior citizen and I am only living on my pension, which is, my lord, the pension account, that is also freezed. Now, my lord, Supreme Court in, my lord, series of judgments have said that blanket freezing is not applicable. It cannot be done. Entire amount, entire property of a particular person cannot be considered to be the product of a fraud. That's why, my lord, my point is this, that what is my proportionate liability for that 85 days? That is, my lord, the first point.
Correct. What the SEBI has passed an order, which order you have been agreed upon? Which order you are telling?
My lord,
76, 77.
my lord, I am challenging the entire proceeding, not a particular order, my lord. And so far as the particular order is concerned, this attachment order, it is annexed at page 87 to 90 of the writ petition. This attachment order is itself void. Why, my lord? Because the recovery officer should have considered the waterfall mechanism provided by the whole time member. Recovery officer cannot go beyond the directions already settled by the whole time member SEBI. My lord, the attachment order, my lord, kindly sees from page number 87 to 90. My lord, the entire assets, kindly see, full freeze has been directed. Entire assets.
Where is that?
My lord, page 87, my lord. Recovery certificate number RC 4064. My lord, kindly sees.
Yes.
Of 2021, dated August 3, 2021, has been drawn up by the recovery officer in the above proceedings for.
So non-compliance of the direction. Where is that direction?
My lord,
Where is that direction? I am asking the one question. Where is that direction dated 21st of March 2018? Where is
My
that
lord,
direction?
my lord, that is the direction which I have first placed before my lords.
77.
My lord,
Correct.
there are, my lord,
Not challenge that. You have not
my lord,
challenged this order.
my lord, I could have.
Challenge this order. So naturally, the recovery officer will issue the notice to you for recovery.
Recovery officer.
Has not been stayed.
Milord, on that point, Milord, I have a partial point, Milord. That is, Milord, this order is not itself invalid. That's why I have not challenged this order. But, Milord, the procedure which has been adhered to by the recovery officer to recover the money is itself wrong, because recovery officer has not considered the assets of the company first, thereafter the assets of the Shubir Datta, then if anything remains, then it is, Milord, kindly sees the attachment notice, Milord, which I am challenging. It is also a blanket attachment order, Milord. Everything has been attached. The company's proceedings, the company's properties, Shubir Datta's properties, and all the other notices. This was not the direction by the whole time member.
Go challenge before the appropriate authority. Why the
My lord, during this point of time, my lord, I was not sitting tight over the issue, my lord. I just want to point out these things. I was not sitting tight. I placed several representations, and thereafter I challenged this attachment proceeding before the recovery officer. I intimated that kindly defreeze my account, because it also contains my provident fund, my pension accounts also. Because, my lord, I was not sitting tight. Thereafter also a writ petition pending before this honorable court. What I am trying to say is, maybe there is this particular person, petitioner, is, my lord, perhaps wrongly guided by someone. But that does not take away the right which he has already incurred due to the wrong done by the authority to him. Writ court, my lord knows under 226, once a wrong is always a wrong. And, my lord, if there is a latch on the part of delay by the petitioner, that cannot take away my right before the writ court, my lord.
But in open court, I am telling, I am not satisfied. You take the decision. You want to continue, then you have to face the consequences, or otherwise you want to take action.
My lord, I entirely bow down to lordship's discretion. If my lord,
in order 2021 of the attachment, you filed the 2019 the writ application. 2025 you are moving this.
My lord, if I entirely bow down to my lord's discretion. If my lord directs me,
Discretion, I am giving
my lord,
to you. If you want to continue the argue, you argue. I will hear you. Then, not to say that the court has not given a hearing, then but I will not pass any order which you want.
Then my lord kindly grants me liberty to proceed appropriate forum. But, my lord, I am on the point of violation of fundamental rights, because this person is a senior citizen.
After 8 years, 7 years.
My lord, I completely bow down. But there's this delay, my lord.
18 authority passed an order. 2021 attachment passed. 2019 you filed the writ petition. Now 2025 you filed the petition as a urgent motion, mentioning the matter for urgent motion. Can it be a fundamental right?
My lord, in that case, kindly grants me liberty to proceed appropriate forum, my lord.
So what you want to withdraw?
My lord, kindly passes an order, my lord. Recording my lord's observations, passes an order.
The petitioner has filed present application. Then I will not grant liberty. Once you want the order, then I will not grant any liberty. I will pass an order on facts. CAB. It's your choice. You want the court has to pass the order on merit, then you want the liberty. Then you want the liberty, it is your choice. You want liberty, you take I will grant liberty. If you want the court has to pass an order on fact, then I have to dispose of on fact the totally. Now ball is in your hand.
My lord, what I request to my lord is, it's my personal request, my lord. I am withdrawing this withdrawing this application, but my lord kindly records the facts. Even the latches on my part, kindly records it.
This court find that impugn order asked
লিবার্টি তো আমার এমনিই আছে, লিবার্টি তো আমার চলে যাচ্ছে না।
impugn order is dated
না, না,
21st of March 2020.
লিবার্টি তো প্রয়োজন নেই।
And on the basis 28, on the basis
But
of
the point is continuous delay.
comma,
That is
the
not-
recovery officer
that
has
is-
issued the notice by
It is not in
issued
my
the
hand,
notice
because the
of
client has come in
an order of
2024 only. Yes, yes, sir.
attachment.
That
on
is the point.
3rd of August 2021. 3rd of August 2021. The petitioner has filed the present date application in the year 2009. The petitioner has not, in the meantime, the petitioner has not paid any interim relief either with regard to the parent order or the order of attachment. Now the petitioner intend to move this present application as urgent motion. Learned counsel appearing for the respondents raised the objection with regard to the maintainability of the present application and submitted the order passed by the authority dated 21st of March 2018 is appealable order. It's an appealable order, but the petitioner failed to file any appeal and filed the present date. And Learned counsel for the petitioner has argued the matter at length and subsequently argued the matter at length. Now he prays for withdrawal of the present date application, praying with the liberty to take appropriate step before the appropriate court. In view of the submission made by the counsel for the petition WPA 23314, is this of 2025 is 2025. The number at 25 present 25 is dismissed as withdrawn with the liberty to the petitioner to take appropriate step before the appropriate hearing.
My lord, I am appearing for the state respondent.
Yes. I beg to appear on behalf of the petitioner.
But I appear for the private respondent.
As if kindly recall, this is a matter, my lord, setting up a sawmill in front of my house. My lord, we have raised objection and my lord, representation before the appropriate authority, no action taken. Thereafter, we filed this particular case, my lord. Lordship was kind enough to direct my lord to exchange affidavit. Private respondent have submitted their affidavit. We have intend to, my lord, submit our reply. So far, the government and its instrumentalities are concerned, they are yet to come, my lord, with their affidavit. Lordship was kind enough to observe they are reluctant to file their affidavit. Now, Lordship, kindly see the application which we have filed, my lord, raised all this question. Now, my lord, I am coming, my lord, as far as their affidavit in opposition is concerned, directly, my lord, page 25. Lordship knows for sawmill, my lord, the forest department, appropriate authority, authorized officer, permission is needed. And that permission is not here. My lord, Lordship, kindly see page 24 of their affidavit in opposition.
My lord, to cut short the matter, my lord, I have got the instruction That has been, my lord, closed down. The notice has been issued for closing. My lord, that sawmill is running unauthorizedly and without license. My lord, we have already served the notice. and has been
My lord, may I say this?
copy diben.
But I appear for the private respondent. Now, my lord, kindly comes to page
Just a
24.
minute, just a minute.
We have taken
This is absolutely a high-handedness action on the part of the state respondents. Why I say this? My lord, they are trying to cover up their own wrongs by this.
My lord, fresh cause of action will arise if learned friend intends to. Definitely.
Sir.
Yes, adjudication, my lord, no problem.
Lordship would kindly hear me for 2 minutes.
Just a minute.
And let my learned friend.
Just a minute.
Let my learned friend.
To whom you issued this notice?
My lord, to me.
To you, private respondent.
Yes.
Okay.
The kindly takes up my opposition annexure O2.
See, this is not your writ petition.
Deeply
If
obliged.
you agreed with this notice, you take appropriate step. That I
Deeply obliged.
Yes.
My lord, only thing, my lord, what we intend to submit, my lord, they have enclosed certain document, including Ministry of Micro and Small and Medium Enterprise. Nothing, page 24. Nothing to do with this particular permission and all this. Then Lordship, drawing Lordship attention directly page 25. This is, my lord, West Bengal Pollution Control Board. Lordship notes the regulatory authority. Consent to establish has been granted in their favor. But consent to operate? No. Lordship, kindly see at the middle of this page 25.
Yes.
My lord, general condition, the quality of sewage and industrial effluent to be discharged from the factory. Then, my lord, the unit shall apply to the state board for consent to operate. That particular paper is, my lord, the conspicuously absent in this writ application, in this affidavit in opposition. Then, my lord, the unit shall comply with the following environmental acts.
See, what is your contention? You want your sawmill is to
Next to my building, as a result of which air and, my lord, noise pollution makes my life miserable.
So now they have already issued the notice.
True.
Notice of closure.
Only, my lord, we are making this submission keeping in the mind, my lord, the whole process is required to be complied in an appropriate manner. And, my lord, consent to operate is not here. No permission from the factory, from the, my lord, the forest authority, which is mandatory. My lord, in absence of all this, my lord, permission and regulatory authority, my lord, certificate, one cannot run sawmill, my lord, in a residential area and all this. This is my humble submission. Judgments are also there, may not be required at this stage.
Kindly takes up one document, but how does my learned friend for the state takes up annexure O3 at page 31 once?
Page 31 of your affidavit.
Yes, my lord. My opposition. Now, my lord, this is the way, my lord, in which the state government functions.
Yes.
My learned friend is correct for the petitioner that I would require a permission from the forest department.
Correct.
Now, my lord, the entire forest department, this is an online mode. My lord, they have completely closed it down. Now, my lord, what is the fault on my part? My lord, lordship would come to the earlier documents. I have a Uddam registration. My lord, I have a
Page 31.
31.
Yes, 31. New
My lord,
license is temporarily
yes,
disabled.
completely shut down by the state government itself. My lord, where does a person go?
Correct.
Now, my lord, kindly comes to the other licenses which I have. Now, my lord, my Uddam registration is there. Annexure O2.
Whatever the registration, but at present they have already issued the notice and you are not having the license.
Deeply obliged.
You are having the license.
But that is a fault on their part.
Correct. They have closed.
My lord, let them open their portal.
If suppose the authority have closed for issuance of the license, can you run your factory without the license?
My lord, they say it is temporarily disabled.
Disabled. That's why.
My lord,
so disabled means you
if
continue.
there is no online application, my lord, let them accept my application offline.
Yes.
But asking,
kindly, my lord, kindly grants me at least this liberty to make an application offline, because the forest department authorities, they say that it can only be made online. You cannot apply for an offline application. But may I be permitted to do that?
but asking relief in my writ application, he is, my lord, not vetted to do all this thing or to undertake all these things.
My opposition is a part of the pleadings of his writ petition.
So cannot be, my lord. So far, this matter is
contention is this, that I do not have a permission from the forest department. I am helpless. Because my lord, the forest department have temporarily disabled their online application system.
Correct.
But where will a person my lord go? But I am not conducting any illegal business.
Okay. In that case, I am passing an order. You comply with the notice issued by you to close your
But I have
business,
already
and you are
shut
at liberty to take appropriate step for granting a
That is
license before the
implied, my lord.
authority.
My
And
lord,
if you file an application,
my lord, that is implied, my lord, need not be liberty, need not be given, my lord. At the same time, my lord,
oppose everything.
I am not opposing, my lord.
His intention is something else.
Yes, I intention is to digest, digest the sound,
my land.
to digest sound
To grab my land.
the
and
sawmill,
pollutant, air pollutant.
sawmill by the due to running of illegal sawmill by the private respondent, the petitioner is facing great difficulties. He submitted that the petitioner is he submitted the petitioner has made several representation to the authority of closure of the sawmill, which is sawmill of the private respondent, which been run by the private respondent without any license. But in spite of the same, the authorities have not taken any steps. And a council appearing for the estate has handed over in closure notice issued by the range officer to the private respondent on 7th of December 2025, wherein the private respondent is directed to close the sawmill and to take away the machinery within 7 days from the date of issuance of the notice. Full stop. The counsel for the private respondent submits that the private respondent is having all the documents and all the documents for obtaining license for running sawmill, but unfortunately, the website of the authority for registration for granting license of sawmill is temporarily closed, due to which the private respondent could not obtain the license. But the learned counsel for the respective parties peruse the materials on record. This court found that the grievance of the petitioner is that due to the private respondent is running the sawmill illegally, and due to which the petitioner is facing great difficulties. Now the respondents have already issued the closure notice to the private respondent, directing the private respondent to close the sawmill and to take away the machinery. In view of the above, this court finds that nothing remains no purpose will be served by keeping the present writ application pending. Accordingly, the petition is disposed of by directing the who is the authority? Range officer. Directing the concern of directing the respondent number. Range officer is not a party. The divisional forest officer, Hubli division, is directed to take up to see that the private respondent shall comply with the closure notice issued by the ranger on 7 December 2025. It is made clear that if the private respondent is made any application for grant of license, the same may be considered in accordance. I directed this divisional forest officer. Yes. Yes. Have you brought that notice? Brought the case file? Yes. Notice out. What? See the photograph showing that it has been pasted in your gate by the concerned person of your office of the respondent. Twenty-seventh. Give the. See that. Page 8. Yes. Correct. Yeah. Where is the order? 1410 has issue notice. See, 1410 issue notice fixing the date on 29th of October and 27th this notice was pasted in your gate. 9th, yes. 20? Page 26 of writ petition. Yes. And 1410. Correct. 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 But Hmm. 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 Correct. Page 8, yes. Correct. Hearing notice. Huh? Hmm. Correct. Who is the vehicle owner? Then who is the Mama Hato? Then see, once the authority has initiated a case, authority will not go to what is the representation pending. Authority has initiated the case on 14th October and the authorities found that you are not there. Authority has issued the notice to you. Just I'm telling. 29th the matter was fixed. Then the notice was issued. 27th the notice was sent to you, but you are not accepted, refused. Then it was pasted in your premises, in the main gate. Correct. Then 29th the matter was taken up for hearing. Where is the question of taking into consideration of your representation? So you are not residing in the house. So who are residing in that house? So they know that there is a notice in your gate. Correct. 27, 28, 29. What is the distance between you and the order, your house and the office of the ADM? So correct. So 27, 28, 29. Correct. Representation, you know the authorities. Correct.
just to frustrate my cause of action. Because if OP minor they have repeat and OP itself gets started to create the problem. And they deny the fact that they are
We can't say when, which time you submitted this representation. Yes, endorsement, there is no receipt number. Correct, there is no, correct, there is no receipt number. Whether it is a evening, it is a night or morning, because the case has been taken in, might be in the official hour. So, okay, you file an appeal. I will grant an liberty to file an appeal, because there is a report. There is no justification for quashing of the order. Whatever the challan, I will record. Yeah. Though you are not appeared before the authority, whatever the document you relied upon, you relied before the appellate authority, and appellate authority will consider and dispose of. Correct. If you are a challan, so if it is overload, then you have to face the consequences. Correct. That's what I'm telling. Okay. The petitioner has filed the present writ application challenging the order. What is the prayer? Filed an application and filed the present writ application praying for a direction upon the respondent number 7, 8, and 10 to release the vehicle of the petitioner being WB 33 capital E dash 1994 1994 police, as well as for consideration of the representation submitted by the petitioner on 14th of October 2025 before whom? ADM. Who is the ADM? Respondent number? Respondent number 8, the additional district magistrate, Paschim Medinipur. Okay. Police. This court has called for the report from the state authority. And the state authority has filed a report wherein it reveals that on 14th October 2025, a case being MM/84/2025 is initiated by the additional district magistrate and district land and land reform officer, Paschim Medinipur, and passed an order for issuance of by fixing the date of hearing on 29th of October 2025 and directed to issue notice upon the petitioner. After issuance of the notice, the petitioner has not appeared before the concerned authority and before the additional district magistrate, and on 29th of October 2025, the additional district magistrate passed an order directing the petitioner to pay the penalty amount of rupees 1 lakh. 1 lakh. Only penalty of 1 lakh, no? Any further penalty? No. Only 1 lakh. 1 lakh. Police. The petitioner contended that no notice has been issued to the petitioner, and without any giving an opportunity of hearing to the petitioner, the additional district magistrate has passed the order imposing penalty of rupees 1 lakh upon the petitioner. He further submitted the additional district magistrate has initiated the proceeding on 14th of October 2025, but failed to consider the representation submitted by the petitioner on the same day. As the learned counsel, as the petitioner denied with regard to the receipt of the notice, accordingly, this court has called for the original record from the office of the additional district magistrate And after going through and the learned advocate appearing for the estate has produced the original record. And after going through the record, it is found that the notice was dispatched for serving upon the petitioner, and the person had been to the house of the petitioner on 27th of October 2025 for service of notice, but the notice was refused by the petitioner, and accordingly the notice was pasted in the front gate of the house of the petitioner. Front gate of the Accordingly, after considering the record, this court find that the contention made by the petitioner that the no notice was given and no opportunity of hearing was given to the petitioner is baseless. In contrary, there is a record on it, and there is a record that the notice was served, but the petitioner refused to accept the notice, though the notice was also pasted in the gate of the house of the petitioner. Considering the above, this court did not find any. This court find that already the authority has passed the order after issuance of the notice to the petitioner. Accordingly, this court did not find any illegality in the order passed by the Additional District Magistrate dated 29th of October 2025. In such view of the matter, WPA number so and so is dismissed. However, it is made clear the dismissal of the present writ application will not prevent the petitioner to file an appeal before the appropriate authority. And if the petitioner has filed the appeal before the appropriate authority within a period of 1 week from date, the appellate authority shall consider the appeal in its own merit without being influenced of any observation made in the in this order. You prepared within a week, you prepared an appeal, and appellate authority will consider in accordance with law. It is further made clear that if any appeal is filed by the petitioner, the same shall be considered within a. It is further made clear that if the petitioner is preferred any appeal, as stated above, the appellate authority shall dispose of the said appeal within a period of 3 weeks from the date of receipt of the appeal.
The Lordship, I am for respondent of one for Union of India, this matter.
Who is the appellate authority? See, ADM is not appellate authority, he is the appellate authority. So, who is the appellate authority? How the give fine. How the appellate authority will pass an order? Where is the act? Give the act. Who is the appellate authority? Then if this has been filed by the appellate authority, I will caution herein now. How the appellate authority can invoke the jurisdiction? Where is the act? Who is the authority? Who is the authority under the Mines and Minerals? Is the Additional District Magistrate. Might be a district magistrate, may be appellate authority, I don't know. So they have yes, next. Yes.
Your Lordship, I am for respondent of one in this matter
Bhattacharya,
for Union of India in this matter.
appearing on behalf of the petitioner, my lord. He is on his leg in court number 13. Kindly, I am paying for short pass over.
Record an order. Though the matter is fixed as urgent motion, but when the matter is called and counsel for the petitioner prays for time, let the matter go. And let the matter be listed in the combined monthly list of
My lord, I am paying for short
Yes,
pass over,
next.
my lord. My lord,
Next.
kindly.
May please the lordship, I am for the petition.
My lord, I am for the petitioner, my lord. Petitioner is a consumer of electricity and he is paying electric bill regularly. More than 10 years he has been using that. Now all of a sudden, the CSC authority disconnected the said line, that is domestic line, on the allegation that I am supplying electricity to a disconnected consumer. To a disconnected consumer. That is page 11, P2.
Oh, tapping connection.
My lord, kindly see, this is the allegation. Electricity, third paragraph. Electricity has been provided from the aforesaid installation being catered through the aforesaid meter to Pakija Begum, who is a different. Pakija Begum is another premises. So from this premises, that premises I cannot. We do against that provisional order, we made a grievance, that is the page 13 annexure P3 last paragraph. That my said client has never supplied electricity from his meter to a different premises. So, Malak, this is two premises. One is my premises, other is Pakija Begum premises. Why I will supply the electricity to her is a different.
If you will say that why you are supplied, so why the authority will disconnect? That is also one kind of question. If you cannot supply, why the authority will disconnect without any cause?
Yes, that is our allegation. And my lord, we have annexed all the bill in time. My lord, kindly see.
What is your instruction?
First of all, with due respect to my friend, but this is under the Electricity Act. It is a complete code by itself, your lordship knows. Like now, this application has been, this writ petition has been made to circumvent the limitation period. Kindly see when this final order of assessment has been passed. This final order of assessment has been passed, page 11.
24.
30/11/2024, and they have taken out this writ petition almost
1 year.
after 1 year. Now the Supreme Court as well as this court, I am searching that, but there is a judgment that one cannot meddle with the statute under Article 226. Once the limitation period is over, he cannot file any, one cannot invoke any writ jurisdictions. But this division bench of this High Court as well as the Supreme Court has specifically stated. I will cite, subject to your lordship kind approval, may I place one? But this is one decision. Another judgment decided over by Justice Bhattacharya. Division main judgment has been made, where, your lordship, this is the part in the page 2, if your lordship kindly see. It is well settled, lordship got that in page 2. It is well settled while exercising, but in the present in all such concession exercised by single jet could have been extended to the respondent provided he had preferred writ petition within 1 month from 11/7/2015. That is, the assessment order has been passed within the period 30 days. If he has made the writ petition, and if the writ petition is pending for 1 year, then he is entitled to that. The admittedly writ petition was filed on 3/8/2015 beyond the period of limitation. As prescribed under section 127(1) of the said act, it is well settled while exercising extraordinary jurisdiction under Article 226 of the Constitution of India. This court, I am asserting on that, lordship, cannot meddle with the statutory period of limitation provided under statute by extending period of limitation which would amount to rewriting the word of statute. Yes. Lordship, kindly see 127.1. Very good.
What is the session of the matter? What is the session of the matter?
একটা থাকার কথা।
Guidelines frame করতে বলেছে।
Yes. My another decisions I'm relying upon, presided over by Justice Bhaskar Bhattacharya, as his lordship then was. This division means specifically stated. I'm sorry, I have a one copy. Kindly allow me to read. I am handing over this subject. I am tendering apology. I am searching. It appears that after hearing the learned counsel for the parties and after going through the aforesaid material, we are of the view that apart from the aforesaid illegalities committed by the writ petition in obtaining the interim order by giving wrong information.
Yes. Question is this, my lord, we made a reply of that. Well, kindly see page 30.
Yes.
Now limitation they are coming, they could have answered that. Well, kindly see page 30.
Okay.
It's a different payments, it's a different owner. I am supplying and they have disconnected. And there is the assessment 1 lakh and not.
That's all.
That is my submission. I am without it.
But this is the another decision, if your lordship, and it has been affirmed by the Supreme Court also. This
In my lord, it will be tomorrow. I'll some judgment. I don't know, but
What judgment? Limitation.
Limitation. What 120?
The petitioner has filed the present application, praying for a direction upon the respondents for reconnection of the supply of electric connection. The counsel for the petitioner submit that by an order dated 30th November 2024, the final assessment order has been passed. And subsequently, and when the disconnection was made,
I'll tell you, lordship, in 2024.
When?
My 14/11/2024.
And on
14/11/2024.
So 13/11, the disconnection was made.
14th November 2024. And final order of passed on 30/11/2024.
No provisional order was served.
Reconnection of the electric connection, reconnection of the electric connection, full stop. The full stop. He submit that. He submit that on 14th of November 2024, the electricity connection of the petitioner was disconnected. And on 30 November 2024, a final assessment order is directing the petitioner to pay for payment of rupees 1,13,59 towards the unauthorized use of electricity. Counsel for the petitioner that in the said assessment order, it is falsely stated that the petitioner has supplied the electric connection through user from the electric meter of the petitioner. He submitted the respondent operator not query as part the He further submitted since the month of November 2024, the petitioner is without the electricity, and as such, he prays for reconnection of the restoration of the electric connection. Per contrast, an advocate appearing for the respondents, appearing for the CSC.
I'm appearing for CSC, lordship.
Limited submits that the writ petition filed by the petitioner is not maintainable and is barred by limitation. He submit that the petition on 14th November 2024, the electric connection of the petitioner was disconnected, and on 30 November 2024, the authorities have passed the final assessment order. Final assessment. On receipt of the final assessment order, petitioner has made representation only on 11th of December 2020. But the petitioner has filed the present writ application on the 3rd of November 2025. That is after the period of 1 year. After the period of 1 year. He submitted as per section 127(1) of the Electricity Act 2003. The order passed by the assessing office is an appealable order, and the petitioner has to prepare an appeal within a period of 30 days. He further submitted that instead of preparing an appeal before the appellate authority, the petitioner has filed the present writ application after the order. He relied upon the judgment, unreported judgment in the case of West Bengal State Electricity Distribution Company Limited and others versus Pranab Kumar Sarkar, passed in MAT number 1875 of 2015, dated 22nd December 2015, wherein the Honorable Division Bench of this court has categorically held that it is well settled while exercising extraordinary jurisdiction under Article 226 of the Constitution of India, the court cannot meddle immediately with the statutory period of limitation provided under the statute by extending the period of limitation, which would amount to rewriting the words of the statute. He further relied upon the judgment in the case of Calcutta Electricity Supply Corporation Limited and others versus Kalavanti Doshi Trust and others, reported in 2011 within bracket 1 CHN Calcutta 182. Which paragraph?
Paragraph 8 and last penultimate probably. Kindly see.
The Honorable Court, wherein the coordinate bench of this court has held that
We talked about the people.
Held that writ court should not, by invoking the writ jurisdiction under Article 226 of the Constitution of India, revive a barred remedy. BARR, any barred remedy. Had the learned counsel for the respective parties peruse the materials on record and the judgment denied by the respondent. This court find that
it has been affirmed by the Supreme Court that
electricity connection and the electricity connection of the petition was disconnected on 14th of November 2024. Subsequently, on 13th November 2024, the assessment order was passed. On receipt of the assessment order, the petitioner has made a representation on 11th of December. Thereafter, the petitioner was silent till the month of September 2020. Now, only after a period of 1 year, the petitioner has filed the present writ application. Considering the above, this court find that the writ application filed by the petitioner is barred by limitation. According, same is dismissed.
I am deeply obliged.
My lord. Next.
My lord. My lord, 22 is a short matter, my lord.
My lord, in this matter,
Tomorrow.
No, my lord, they are going to defreeze. They are going.
my lord
Yes.
passed an order day before yesterday regarding defreezing. My lord, I'm giving that order, but this is a bank is separate, but here we have that separation or distinction is only one, that here we had freezed the account upon the order received from the special judicial magistrate first class for the
Order received.
order received, but thereafter also some development has come. So some development, so we were directed to means after withholding the amount, disputed amount of 2,400, we will be, if the my lord gives an order,
What is the order? Where is the magistrate order?
my lord, we don't have the proper magistrate.
My lord, I
order.
got that with judgment, my lord. Lordship was pleased to ask. There was a clear direction of
Correct. That's what, no, he's telling that there is an order of magistrate. If there is an order of magistrate, then it's compliance of 106, 107 of the
Yes,
BNS.
no, definitely, definitely.
So subsequently, any modification of the order of the magistrate.
Modification, and there was subsequently some compliances to be made.
Bring when you tomorrow?
Yeah, man.
Dada, oita.
In compliance of those order, we had given this, marked this lien and freeze the account. So, my lord, now we, as per, actually, my lord, we don't have permission to defreeze without the court's order.
Correct.
Because of our operating.
No, that's why I am worrying this. If there is an order of magistrate, you got the order of magistrate. Where is the order of magistrate? This is the order of
No,
your
this is not the-
authority. Application under section 4 is amount of 2,400.
This was what was communicated. That's the reason, my lord, that we have had been communicated from the Special Judiciate Magistrate First Class Telangana.
How much amount is stated?
2,400.
That much they can.
Let
That much
be
they can.
withhold and we will release it.
That much they can.
And there is also shall ensure compliance of the order and all these things are there. So that part we are still ignorant whether this compliance has been made or not. So bank is at
After filing and moving this application, they have come to know everything. Whatever the steps has been taken by the petitioner in initial stage.
So what is the amount pending?
2,400.
That is the disputed amount.
That's the disputed amount.
The petitioner has filed the present writ application praying for direction upon the respondent bank, namely which bank? Canara Bank. Canara Bank having its office at 21, 4th floor, Bell's House, near Pantaloon, Kamak Street, Kolkata.
and branch is, my lord, Agra branch.
Agra. The district of Paschim Medinipur, Purva Medinipur.
Which?
Branch, my lord, it's a small rural branch.
Canara Bank.
Well, page 2 I have stated. Page 2, paragraph 3.
Canara Bank, Agra branch.
Respondent number 3 of the requisition.
Kasba ward number 1. Okay. To defreeze the account of the petitioner by withholding the alleged disputed amount of rupees 2,400. Counsel for the petitioner submit that the petitioner is having 3 gold loan accounts with the respondent bank. Respondent full stop. All of a sudden, all accounts have been freezed.
3 accounts has been freezed, my lord.
All the loan accounts of the petitioner was freezed. In spite of several representation made by the petitioner, the bank failed to defreeze the loan. Full stop. Now the respondent authorities have submitted that as per the order passed by the London magistrate, the account of the petitioner was freezed. Now there is only 2,400, and now there is a dispute with regard to only 2,400 rupees. Accordingly, she submit that if this court passes an order allowing the petitioner to operate the bank account except the disputed amount of rupees 2,400, the bank will allow the petitioner to operate. In view of the above, the bank is directed to defreeze the account of the petitioner and to allow the petitioner to operate the 3 bank loan accounts.
Yes, your lordship.
3 gold
Loan
loan
accounts.
accounts. Except
Withholding, my lord, withholding of this amount.
by withholding an amount of his 2,400 in the said account,
Till what the orders
which is the disputed amount, till the final decision is taken by the investigating officer.
But this is a savings account, my lord. No. Defreeze a loan account.
2,004 till the final decision taken by the concerned authority with regard to the said.
And my lord, defreeze should be done within a specific period of time, my lord. Or else I have to suffer. I have to suffer, my lord.
My lord, upon
Directed to
communicating the
decrease
order,
the account
defreeze
of
has
the
to be done
petitioner
from head office,
to allow
not
the
by the
petitioner
branch.
to
It's a small rural
operate
branch.
the bank account
Definitely will
within a
communicate
period of
the
1 week from date.
And my lord, there is also savings account also. Savings and loan account both. Savings and both account loan.
You have stated in paragraph
My
3.
paragraph 2, my lord.
Paragraph, yes, you have stated that loan account.
Loan account as well as this is a savings account. In connected with the savings account, this is a loan account, my lord, where it has been disbursed the loan amount.
Defreeze the loan account as well as the saving account. And to allow the petitioner to operate the said accounts by keeping aside the amount of rupees 2,400, which is the disputed amount, till the final decision taken by the concerned authority. Within a 1 week.
I'm grateful, your lordship.
Can you explain 23 is intimate till
No
today?
further, no further. Yes,
So,
yes,
but
yes.
intimate till today. The wetland matters, my lord. Can take it tomorrow. But this
Today it will come tomorrow.
well, criminal matters. Tomorrow is a criminal matters. But tomorrow is a criminal matters.
Call.
Well, today intimate is till today, my lord. The 23, the wetland matter. Intimate is till today.
Yes.
Intimate till today, my lord.
Which matter?
Item 23.
So you intimate, why you not mentioned the morning?
My lord, this is I saw the matter.
All the intimate.
Can you take it tomorrow, my lord?
If it is still today or tomorrow, then again you will say, if it is intimate.
There's a wetland matters, the manual.
Who is for the other side?
The Advocate General and all Solicitor Generals, many others. That wetland matter.
23. No other matter. Other matter release of the appellate side. Appellate side, other matter release for the day.
Your lordship, all other matters will retain its position on your lordship's list. All other matters which are not called today, the urgent tomorrow, retain its position. I bow down.
Regarding the
Item number
23. The intimate till today regarding electricity.
Record an order item 23. As per the prayer made by the counsel for the petitioner, the interim order is extended till 23rd of December 2025 or until further order, whichever is earlier. Let the matter remain in the list. Yes, call the order.
Item number 127, my lord.
Who is the authority?
DM is the appellate authority.
Then tomorrow it will come. I will not sign the order. It will come tomorrow.
According to my understanding of the law. Because it says that like DLR pass an order, I can for appeal DLR, then LRTT, but here DM pass an order, equivalent to ADM.
Which section?
36 subsection 2, my lord. Kindly see, 2 mode is there.
Okay, I am keeping it.
Great.
Yes.
May I have your lordship kindly, my lord, item number 127 on the original side. The interim order is expiring today, my lord. Last time, my lord, it was extended on the 20th of November. It's expiring on 11th of December, my lord.
127.
Item number 127, my lord.
Yes, recorded 127. So the matter is listed as item number 127 of today's list. But the Learned Counsel for the petition submitted the interim order is subsisting till today. Accordingly, prays for extension of the interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 22nd of December till 6th of January 2026 or until further order, whichever is earlier. Let the matter remain in the list.
I'm extremely grateful to your lordship.
Yeah, call that.
May I have your lordship kind leave to mention, my lord, I'm seeking upgradation of a matter which is appearing in today's list, my lord. My lord, it pertains to termination of a contract by the railways, my lord. My lord, I am only challenging on the ground of limited ground of arbitrariness because initially there is a termination which has been stayed by this honorable court subject to certain conditions, my lord. Despite that termination being stayed, my lord, there is a fresh termination now. And without following the process under the contract, my lord, I'm humbly beseeching your lordship, the matter can be up.
Saturday 10:30.
Saturday 10:30. My lord, if your lordship, my lord, if your lordship is so pleased to accommodate, I don't mind because there's certain urgency, my lord, in the matter.
Bring the other party Saturday 10:30, 11.
My lord, any other day, my lord, has not, my lord.
January 28.
My lord, kindly, my lord.
Before that, there is no date.
My lord, kindly, my lord, concerning because it's.
What can be done? Either you xerox my part. Persons are not understanding what can be done. Every matter is urgent before this court.
My lord, the only thing
Yes,
is,
call
my,
the matter.
My lord,
May I permit?
Nothing. Yes, call the matter.
My lord.
Acha, defendant or defendants. Defendants are unequally admitted on the venue, nothing immediately. The plaintiff is entitled to the matter is listed as to be mentioned for correction in the judgment dated
17th September.
17th September 2025. It is submitted that in paragraph 20, it is submitted that the defendant number 1 is the main defendant and the defendant number 2 to 4 are the performer defendants.
Well, defendant number 1, but only there is one defendant, and the others 2, 3, and 4 they are the pro forma respondents.
What I said? What I said? I dictated.
I beg to be apologize, my lord.
Defendant number 2 to 4 are the performer defendants. But in paragraph 26 of the judgment, this court has passed a note and this court has recorded that the defendants has recorded as defendants instead of defendant. Accordingly, in paragraph 26, line number 1 and line number.
And not only in paragraph 26, my lord, all the paragraphs.
Paragraph 26, the words defendants shall be read as word defendant. The order may be incorporated with the judgment dated 17 September 20.
And my lord, the other paragraphs, my lord, there are defendants, my lord.
That is no problem.
My lord, I'm grateful.
Correction is there.
I'm grateful, my lord.
My lord, I appear for the petitioner. The interim order expires tomorrow, my lord. Both in item numbers 2 and 3, my lord. This is the last order.
My lord, not standing in the way, my lord. The only thing was that I couldn't serve them the copy of the affidavit in opposition as the same was misplaced by my office, your lordship. So I have retrieved the certified copy. My lord, I'm serving the copy of the oppositions in both the matter, item number 2 and 3, my lord. I'm serving it here and now.
The matter is listed as to be mentioned for on the prayer made by the counsel for the petitioner for extension of interim order. Full stop. Counsel for the defendant has handed over the copy of the affidavit in opposition to the learned counsel for the petitioner. Counsel for the petitioner prays for time to file reply.
Yes, my lord, 2 weeks time.
Reply. Let affidavit reply be filed within 2 weeks after serving the copy to the learned counsel for the respondent. Full stop. Interim order is extended till 14th of January 2026 or until further order,
Lordship.
whichever is earlier. List the matter on 9th of January 2020.
Lordship.
Great.
I'm deeply obliged, your lordship.
2 and 3 both, huh? 2 and 3 both.
My lord, I'm appearing for the petitioner in this matter.
On behalf of state respondent,
My
led
lord,
by Mr. Arun Banerjee.
My lord, the interim order expires tomorrow, my lord. By the last order dated 25th of July 2025, the interim order that we are enjoying expires tomorrow.
Yes.
It is pending before the honorable division.
My lord, a
bench.
similar issue is there. The limited issue involved in this matter is what would be the stamp duty with regard to an amalgamation which involves no immovable property. There are 2 appeals pending before the honorable division bench and the appeals are being substantially heard, my lord. So in view of that, only last 2-3 occasions the extensions were given.
The matter is mentioned by the Land Council for the petitioner and submitted. The interim order is till 12th of December 2025 and she prays for extension of the interim order. It is submitted by the Land Council for the parties pertaining to the issue involved in the writ petition. Writ petition is pending before the honorable division bench. Accordingly, the interim order is extended till 20th January 2026 or until further order, whichever is earlier.
My lord is extending
20 January 2026.
Grateful, my lord.
Next. लिस्ट करने की जरूरत नहीं डिवीजन में जब मेंशन करेंगे एक्शन.
My lord, I appear for the petitioner.
Yes.
My lord, here we are concerned with, my lord, the declaration of my account as a fraud account by the bank. Now, my lord, the law has been clearly laid down, and this apart, my lord, what we had shown the court on the previous occasion was that, my lord, there was an attempt to declare us willful defaulters. The matter came to this court, reached the division bench. The division bench, in an order which is at page 31 of the petition, clearly records that all dues have been paid off. And, my lord, no due certificate was directed to be given. My lord, thereafter also, my lord, we find that our name is shown as, my lord, fraud in the civil. My lord, as a result, my lord, our business has really come to a standstill. We can't borrow any limits from the bank. We can't, my lord, do business. Now, my lord, when we approached them, my lord, they, my lord, came to this court and said that no, there are other dues owing in other accounts. The court directed them to file a report. Now, my lord, they have filed a report to which, my lord, we have prepared a response. I would request your lordship's leave to, my lord, file the response. But, my lord, with the greatest of respect, my lord, this is not the issue. My lord, the issue is very clearly settled. My lord, before declaring an account as a fraud account, my lord, in the matter of Rajesh Agarwal in 2023, the Supreme Court has clearly said that, my lord, the doctrine of audio alternum partem.
Guidelines.
Yes, my lord, all these guidelines. Thereafter, my lord, this honorable court in Madhumita Construction has followed the same thing. My lord, without following anything, how can you declare an account to be a fraud account and stop a person's business? And, my lord, even if there is an outstanding, my lord, the process of recovery is available. To declare an account as a fraud account, my lord, there has to be something more.
Any forensic report is there?
No, my lord, there is nothing like that. There's no forensic report, my lord, that has been at least made available to us.
So before the fraud, whether notice was issued?
No, nothing, no notice.
Appear for the Reserve Bank of India.
Lordship, I appear for the respondent number 1, Lordship, the bank. This is the report which is being filed. Lordship, what has been prayed in this writ petition is correction of records of civil reporting, which is completely different from what the order in the appeal before the division bench was, and the incident of classification of the account of fraud, Lordship, that was in 2012, much before these guidelines had come in, and that was within their knowledge. That is what has been indicated in that report. But today's date, what is outstanding against their loan accounts has been indicated in this report, Lordship. It is a civil reporting. There is a specific act to that effect, and there is a specific guidelines of the RBI now that what are the parameters, what exactly has to be reported by the bank.
There are 3 stages, I think so. There are 3 stages.
For the civil reporting, Lordship, yes, there is a format. There is a unified guideline that what are the details. The civil reporting is completely different from a willful defaulter classification, from the fraud guidelines. It has nothing to do with that. It is the status. There is a civil, possibly for me also, who is not a defaulter, or for anybody else for that matter. It is a regular updating to the credit information companies that what is the nature of the loan standing in their account, in which accounts they are borrowers, co-borrowers. Lordship, I'm carrying with me, Lordship, I will indicate that what are the parameters which are to be filled up by the bank and submitted to the credit information company as a matter which is an obligation on the bank. It is not discretionary on the part of the bank. Lordship, may I first indicate from the report, Lordship?
My lord, may I say this, my lord? May I, my lord, let my learned friend, my lord, give me, my lord, whatever report they are seeking to rely on, including. No,
Nice.
apart from the report.
Oh, that is the report.
Oh, very well. Very well.
Have you received this report?
Yes,
Yes,
they have
ma'am, this report we have.
they've served a rejoinder only yesterday.
Yes. Let Mr. Shah start.
Yes. No, my lord, my lord, let my learned friends, my lord, say what is there in the report, because, my lord, so far as this is concerned, if your lordship sees, my lord, this is what they say. My lord, before that, my lord, may I show your lordship just one order? My lord, please come to page 31 of the writ petition. My lord, this is an order of a division bench of our court. My lord, please see, my lord, here, my lord, the petitioner is Kejriwal Mining Private Limited. Well, this is the company with which we are now concerned. This is an appeal from a judgment and order made by a learned single judge on such and such. By the said order, the review committee was directed to review the order dated 3rd July 2019 of the Willful Defaulter Identification Committee, declaring the appellants as willful defaulters. By its order dated 28 July 2020, the bench admitting the appeal inter alia directed the appellants would have the option of depositing 64 lakhs with the respondent bank. The bank was to rectify its record by inserting against the words willful defaulter sub judice before the High Court. Upon rupees 64 lakhs being deposited, the respondent bank would take further steps towards declaration, would not take any further steps to declaration of the appellants as willful defaulters. We are told that this amount has been duly deposited. The declaration of the account as non-performing is serious enough for a borrower. More drastic and damaging is the declaration that he is a willful defaulter. This declaration by the lending institution immediately affects the business of the borrower, disqualifies him from availing of loan from other financial institutions, etc. Well, then I shall not trouble your lordship. Please see the next paragraph. On 16th March 2015, the bank by a letter approved a compromise offer by the appellants. They accepted the amount of 4 crores 11 lakhs 2,726, which has been described as a one-time settlement. This settled amount was to be liquidated by a down payment of 5% amounting to rupees 20 lakhs 55,136 and the balance by equated monthly installments. On 27th March 2019, WDIC decided to issue a show cause to the appellants for declaring them as willful defaulters. On 6th April 2019, show cause was issued. Then your lordship will kindly ignore the next few paragraphs. Come to the last paragraph at page 33. In this situation, prima facie, it is not possible for the court to accept the appellants should be declared as willful defaulters, etc. Then, my lord, your lordship will please also now come to page 34, third paragraph. In view of a finding, the decision of the respondent bank dated 18 January declaring appellants as willful defaulters set aside. Declaration of the appellants as willful defaulters or proposed willful defaulters has to be set aside. Then, my lord, your lordship will see. This was the direction. Now, my lord, page 33, my lord, your lordship will find records with regard to the first ground taken by Mr. Shah, which is considered by us to the most important. It does appear from a supplementary affidavit prepared and filed by the appellants that from 19 January 2015 till 11th August 2020, substantial payments aggregating to rupees 4 crores 11 lakhs 2,726 were made, and only the interest amount of 1 crore 46 lakhs 98,630 was outstanding. Furthermore, Mr. Shah submitted his clients were willing to repay whatever outstanding the respondents were on such terms, etc. Then, my lord, your lordship will see the next paragraph says, last line, the principal sum appears to have been repaid. In the situation, prima facie not possible to hold them as willful defaulters. And, my lord, page 34, the third line, second line, on the contrary, we have shown that the bona fides by depositing 64 lakhs with the bank further to our interim order in the appeal. My lord, payments were made. Now, my lord, after this, my lord, this is in the year 2022. My lord, if today, my lord, there is no default that continues in 2022, my lord, then the question is, why should I continue to be, my lord, branded as a fraud account? Now, my lord, apart from this, please have a look at the report that they have filed. Well, at paragraph 6, I say that there is another loan account in the name of Siddharth Kejriwal, Mahesh Kejriwal, Alka Kejriwal, wherein the directors of Kejriwal Mining Private Limited, Pioneer Barter Private Limited, and Vedika Suppliers are borrowers. Said loan account has also been declared a fraud account under the RBI Master Director's fraud classification reporting. Now, there was no opportunity given to me. Well, I would have appreciated them, my lord, coming on record to say that we had given you opportunity, given you a right of hearing, sought representations, given you a show cause notice, nothing. Then, my lord, please see the next paragraph. I say that the account of Kejriwal Mining Private Limited, that is the petitioner number 1, earlier known as Parijat, was classified fraud by the Allahabad Bank on 19th April 2012. Same was reported.
How many cases are pending between these Kejriwals?
My lord, there is a loan account, they say. But Kejriwal Mining is only one. And the petitioner is Kejriwal Mining. Now they say that there were directors who were also involved with other companies, but there is no report of, my lord, what was the notice issued, what was the opportunity given. Now, my lord, even without these directions, my lord, coming into effect, or the guidelines being laid down by the Supreme Court in Rajesh Agarwal, my lord, am I not, my lord, in law entitled to a notice, to a right of
Where is
reference?
the main order? Where is the principal order, original order?
Well, the order by which, my lord, I was declared.
This writ
My lord,
petition
please
is
see, my
filed.
lord, page 48. This is what the civil
So
records.
this is the writ petition.
Yes,
In the
page
writ petition,
48.
what you have paid for?
My lord, page 48 is, my lord, what is concerning us at the moment.
Page 48.
My lord, this is, my lord, the civil reporting. কোথায় দেখাচ্ছে এটা? Well, your lordship will find, my lord, current exposure at page 48.
Yes.
By credit type. My lord, please see here. My lord, there is Shrey Equipment, then Indian Overseas Bank, then ICICI Bank, then, my lord, Amcol, Texim, and others. Now, my lord, so far as the other loan accounts are concerned, the outstanding is shown as, my lord, only 5,711.
Where from you?
Then, my lord, your lordship will say, I'll tell your lordship
Page
what is.
48.
Page 48 is, my lord, the civil reporting.
Civil report.
And then kindly come to page 52. My lord, page 52, your lordship will find there's a heading in the middle of the page, delinquent credit facilities.
Yes.
My lord, kindly see here, my lord, under this loan details, my lord, cash credit, my lord, sanctioned amount is 4 crores 80 lakhs, asset classification is loss. And my lord, again, the next, my lord, entry, Indian Bank, my lord, sanctioned amount is 1 crore, asset classification is loss. Well, I do not know, my lord, on what basis this reporting is made after, my lord, the entire dues have been paid back. And, my lord, this classification at page 41 is in respect of Kejriwal mining.
No, that is with regard the amount which you have paid as 64.
Yes.
That is in connection with which account?
Well, this is Kejriwal mining. Same account.
Account number?
Well, account number, my lord, is not mentioned here, but, my lord, there is no other proceeding that is pending against me. There is no other account of Kejriwal mining with Indian Bank, and there is no proceeding for recovery pending. My lord, kindly see, my lord, in this regard at page 57. Well, at the top of the page, it is shown, well, under the against Indian Bank cash credit account shown as loss. But, my lord, so far as this is concerned, please see.
The outstanding figure is 5,000 only.
Well, the outstanding figure is,
You
outstanding balance is 5,710.
Where?
Well, at 57.
Yes, 5,710.
5,710.
So that is sanction date to August 2009. Sanction amount 4 crore 80 lakhs.
And, my lord, again, if your lordship comes to, my lord, the next, my lord, portion which is in black, the bold. Well, again, Indian Bank, my lord, this is account number, loss. But, my lord, if your lordship sees, my lord, first one is for 4 crores 80 lakhs, the next one is for 1 crore.
Correct.
My lord, 1 crore, my lord, the balance as on 27 November 2019, 9 is 1 rupee. Now, I do not understand, my lord, what is the purpose of, my lord, pursuing, my lord, matters with, my lord, the civil, to, my lord, show me as a fraud account, to show me as a loss account, after, my lord, everything has been paid.
Yes.
And, my lord, the report that has been filed by my learned friends, my lord, kindly see what the report proceeds. 2012, we have declared you to be a fraud account. Now, my lord, there was no notice, there was no opportunity, there was no hearing afforded. And, my lord, here, paragraph 11, your lordship will see.
No, if it is 2012, So you're not challenged that.
No, no, but I had no notice.
There was no order given to me.
There was no order given to me, no notice given to me. I now find from the civil records when I, my lord, approach the banks for borrowing limits, that, my lord, my account is shown as loss, and, my lord, it is shown as that is, my lord, it's a fake account.
Which one fake account?
My lord, this is what they have said. That, my lord, please see the report, and, my lord, that is what they have reported to civil apparently. My lord, if your lordship sees page 64 once of the writ petition, my lord, because we had no intimation as to what was happening, we, my lord, made a RTI representation. That your lordship will find at page 64. And please see what is the response.
Evading answers.
My lord, please see, my lord, this is their loss, my lord, by information sought was copy of internal note, order or classification sheet based on which Indian Bank declared or reported the account of Kejriwal Private Limited as loss in civil bank records. Well, the reply is the information sought is internal in nature, as such the same even if existing is exempted from disclosure. Then, my lord, next is copy of relevant RBI circulars or internal policies that authorize classification of a borrower's account as loss, even after full repayment of principal where interest dispute is pending. Because even against the interest dispute, we have deposited 64 lakhs. Information sought is internal in nature, as such the same even if existing is exempted from disclosure. Then, my lord, 3. Whether any notice or opportunity of hearing was provided to the borrower before such classification. If yes, kindly provide copies, dates. Query not specific, however, seeking explanation or expression of opinion, clarification, conclusion, or reasons of confirmation do not fall under the definition of information under Section 2F of the RTI Act. Then names and designations of officials who initiated, reviewed, and approved the classification of the account as loss. Information sought is internal in nature, exempted from purview of disclosure. Whether the clarification letter bearing number such and such issued by the Assistant General Manager, Indian Bank, International Branch, Kolkata, confirming the genuineness of the collateral title deeds, was ever escalated to the higher authorities or factored into your asset classification process and civil reporting. This clarification should be seen in the context of the earlier communication issued by another Assistant General Manager of the bank, wherein the account was reportedly labeled as fraud. My lord, it was labeled as fraud apparently because, my lord, fake property documents had been given. Then, my lord, there is a certification by an Assistant General Manager that all the documents are genuine. My lord, the report is query not clear and specific. However, seeking explanation, expression of opinion, etc., do not constitute information under 2F. Well, I don't know what does one do.
Yes.
Lordship, this is neither a writ petition challenging the classification of fraud, nor a writ petition challenging the non-supply of information under the RTI Act. This writ petition says that the loss account, which has been mentioned as a loss, is required to be rectified and either set to be labeled as a settled or good account or whatever regular account. Now, this is what the prayers in the writ petition involves. Now, before I indicate to your lordship that what is the information I am required to supply under law, I will just indicate, since this point has been asserted, lordship, lordship will kindly take up my report at annexure A2 at page 25. Lordship, this is the settlement letter which the bank had issued to them way back in 2015, and lordship will kindly see that in clause 7, it is recorded that bank has declared fraud in this account and also initiated criminal action against erring borrower guarantor. Police public CBI has been complaint has been filed. Bank is compromising only civil liability and not the criminal liability. So, as per extant guidelines, the investigating agency CBI will be properly informed about the terms of compromise approved by the bank. Now, lordship will, the annexure A is the CBI investigation which is pending against them. There is a charge sheet. Lordship will find that there is a FIR at which starts at page 14.
Yes.
And this proceedings is also there against the concerned directors who and the petitioner number 2, who is also petitioner here. Mahesh Kejriwal, Lordship will find his name appearing, Lordship, at page 15. Siddharth Kejriwal, son of Mahesh Kejriwal, thereafter Mahesh Kejriwal, Alka Kejriwal, they are all directors of this Kejriwal mining. This proceeding is one that is pending. Now, thereafter, there was a compromise with respect to the civil liability. This compromise has failed. They had made part payments towards this compromise, and thereafter they did not continue with the compromise. Bank today, as it stands, the bank does not accede to this compromise.
What is the total amount of the compromise?
Lordship, this was the total amount, Lordship.
Page?
4 crore 11 lakh 2 at page 25. This was the amount. Now, in the order of the Honorable Division Bench, which is being, yes, placed, this is the figure, Lordship will see that this, yes.
So this amount is paid.
No, this amount now, the principal they have now paid of this compromised amount. Now, today's date, Lordship.
No, if the division bench order is taken into consideration.
Yes, Lordship, I will place that, Lordship. It is not on the adjudication of whether there are any dues or not. It is just an observation which says that, yes, I will come
Well,
to
the
that,
entire amount of 4 crores, 11 lakhs is paid. That's recorded.
of the settled amount that has been paid. I am coming to that, Lordship. Lordship will kindly see from page 33. With regard to the first ground taken by Mr. Shah, which is considered by us to be most important, and this Lordship will kindly, may I indicate that in the light of willful defaulter classification, not with respect to civil, I will come to the what are my duties under civil. It does appear from a supplementary affidavit prepared and filed by appellants that from January 15 till August 15, substantial payments aggregating to this and this were made, and only interest amount of this was outstanding. So even according to them, this was the interest outstanding as on that date, according to them. Furthermore, Mr. Shah submitted that his clients were willing to repay whatever outstanding of respondents on such terms as the court may set. Ms. Lahiri, appearing for bank, also handed up a statement showing outstanding dues, credits and adjustments in relation to the account of the appellant. She prays for further time to produce more accounts. That would not be necessary in view of a submission that what is due and payable by applicants to the bank is interest as stated by her client in the affidavit. Principal sum appears to have been paid, which is the principal of the settlement amount. Yes, and according to them, as on that date, Lordship, I have shown that their admitted interest portion is 1 crore 46 lakh and something.
Correct.
Then thereafter,
So
Lordship,
in this situation, prima facie, it is not possible for this court.
could be declared as willful defaulters.
Correct.
It is on respect of only willful defaulters. Prima facie intention to deprive bank to be lacking, factum of period of payments by appellant, this and this is Lordship there. What is the operating portion, Lordship? That in view of the findings, decision of the respondent bank dated this and this, declaring the appellants as willful defaulter is set aside.
Correct.
Declaration of appellants as willful defaulters or proposed willful defaulters has to be forthwith erased from the records.
Correct.
We direct re-adjudication of the show cause notice of the willful defaulter adjudication committee without such declaration upon considering reply filed by appellants upon hearing them. So, it is with respect to a specific order which was passed by the bank where the process of the order was also challenged. The Honorable Division Bench has held that no, since the principal of the settlement amount has been paid by them, therefore, this order it cannot be sustained, but a liberty is also given to them.
Correct. So
Yes.
now direct to re-adjudicate.
Re-adjudicate.
So what
Lordship, we have not proceeding under the willful defaulter. We have not, my instruction as that willful defaulter, the bank has not proceeded.
Yes.
Now, Lordship, today's date, Lordship, may I indicate there, and it was also informed to the borrower, and the borrower is also aware. I will indicate from their correspondence with the bank. Lordship will kindly take up the report. This is the reply which was furnished upon their application. That is at page 32. It starts from page 32 of my report, Lordship. On the prayer for correction of the civil report,
Yes.
this reply letter of 14/8/2015 was given to them.
14/8/25.
Yes, 14/8/25. And Lordship will kindly take internal page 30, the page 34 of
So this
where
is given by the Indian Bank.
by the
Right with
yes.
representation dated census.
So these is what the outstanding against the
Page,
account.
page.
Page 34.
Yes.
Lordship, these are the figures we say are outstanding against these several loan accounts of the petitioners and the other. Lordship, there is Kejriwal Mining, Pioneer Butter, Siddharth Kejriwal, Vedika. These are connected accounts because the directors are also directors and co-borrowers and guarantors there. So this is the outstanding as on date. And that was intimated, and Lordship will kindly take one document that is at page 38. Lordship, this is their email, 27/6/2025. Lordship will kindly sees that I am writing with reference to non-performing accounts under the following accounts numbers. They also acknowledge that these are the accounts which are all connected. Then say, since beginning, I have been consistently trying to settle the accounts amicably and in good faith. Despite my sincere efforts, certain formalities and procedural issues have remained unresolved. We had earlier interacted with Mr. The Assistant General Manager of Indian Bank in this matter, and based on this discussion, I now wish to take this forward to its logical conclusion. I sincerely propose to personally meet with you in Chennai to discuss and finalize closure of the said accounts. I firmly believe the support and constructive meeting this and this. Therefore, it is not a fact that they are not aware. They are very much aware. They are acknowledging that these are the connected loan accounts. And Lordship, now may I please that what is the information I, as a bank, have to furnish to the credit information company? Such that there is one, the act and the corresponding, Lordship, the rules. Now. Other RBI guidelines, Lordship, what is
copy
sir দিয়ে দিচ্ছি একটু দুটোই কপি আছে আমি দিয়ে দিচ্ছি Lordship will kindly take up আচ্ছা তোমার কাছে একটু দিয়ে দাও Lordship will kindly take up the act first, the credit information, the which is the thinner one.
Yes.
Lordship, this information is required to be furnished under this specific act, that is the Credit Information Companies Regulation Act. Now, Lordship will kindly take up definition clause 2D.
Yes.
Lordship, these are the informations which we have to furnish, that is the amounts and the nature of loans or advances, amounts outstanding under credit cards and other credit facilities granted or to be granted by a credit institution to any borrower, nature of security taken or proposed to be taken by credit institution from borrower for credit facilities granted or proposed to be granted to him, guarantee furnished or any other non-fund-based facility granted or proposed to be granted by a credit institution for any of its borrowers, the credit worthiness of any borrower of a credit institution, any other matter which Reserve Bank may consider necessary for inclusion in the credit information to be collected and maintained by the credit information companies and specify by notification. Lordship will kindly take up the notification now at page 11. This is the notification dated 6th of January, Lordship. It is the Master Direction, RBI Credit Information Reporting Directions, 2025. Lordship, this is the credit information report. Lordship has got 9 credit information dissemination by CICs. Lordship, may I directly place, I'm not placing all of them, but CIC shall capture details of co-borrowers and guarantors wherever applicable in the CIR. This will facilitate deciding on the extent of exposure of a CI can consider on an entity. CIR shall give details of the loans availed by the customers in their capacity as borrower, co-borrower, guarantor. In case of multiple borrowings by same customer involving both current and closed accounts, CIC shall provide information on various accounts in the order of live accounts, closed accounts, and overall position of NPA status, willful default, suit filed with limits and liabilities for each account. So it is not only the past, present, it has to also include the past, whatever is the closed account, which is the NPA status. And now, Lordship, may I place, it is a very voluminous guideline, only the relevant portion. Lordship will take page 60 of the guideline. That is guidelines for reporting credit information in the uniform credit reporting format. This is the format we are bound to follow.
My lord, may I suggest something? My lord, these guidelines, my lord, we do not have a copy of. My learned friend does not immediately have a copy to make over to me. My lord, let my learned friends give a copy of the guidelines and indicate to us what are the provisions they wish to rely on so that we can respond. Otherwise, my lord, my learned friend will make submissions. I will not be able to respond today. In any event, my lord, there is a, my lord, guidelines framed in 2016 for reporting fraud. And those guidelines are very specific.
No, Mr. Shah. In terms of earlier dispute, whatever it is, 4 crore some amount was there.
That's right.
You who paid the amount.
That's right.
Division bench has accepted that. No, interest was pending.
My interest, the court directed me to pay 64 lakhs.
That is not the...
No, my lord, that my lord amount is paid. My lord, whatever interest is paid, my lord, they have not even commenced proceedings for recovery of any interest amount.
No, subsequently now they have to inform. Now it has come that this is the thing.
Yes, Lordship.
In the
Also, Lordship.
August
My lord, the CIBIL.
you have acted upon their notice.
Yes.
So what?
No, my lord, I have acted upon what notice? My lord, the question is, my lord, they have said that amounts are due and owing. My lord, I have, my lord, made payment of that amount. Correct. My lord, the company is specific. My learned friend says I have to report, my lord, co-borrowers, guarantors, my lord, associated accounts. My lord, these are all individual company accounts. There may be, my lord, some common borrowers. And what has my learned friend shown to your lordship? That when an approach has been made that we want to settle these accounts. My lord, does it, my lord, demonstrate fraud? My lord, because, my lord, the reporting specifically is, my lord, that this is fraud. And, my lord, fraud guidelines are very specific. Now, my lord, so far as loss account is concerned, kindly see, my lord, the information is loss/fraud.
Yes, loss as fraud.
Now, my lord, today, if it is a fraud account, then, my lord, the guidelines will have to be fulfilled. Now, my learned friends have said that, my lord, these are fraud accounts because, my lord, I have furnished security of, my lord, fake banking documents. Their own manager has come on record to say that, my lord, these documents are genuine. Right. And, my lord, when I write to them, my lord, in RTI, saying that this is what your manager has said, what do you have to say about that? They say, we will not say anything.
Lordship, with respect to the fraud document.
My lord, your lordship has that matter fixed, my lord, at 3:45 today.
So you are...
Yes, my lord, I am addressing your lordship. So, my lord, let my learned friends just indicate, my lord, what they wish to rely on.
You put the note and
I will give the circulars. I will hand over.
I will just it's a very voluminous.
We are also not assisted by the bank. It is our things we have to go find out. It is available.
I appeal for civil, my lord. I have a very limited submission.
Now the government has cut down your hands. Yes. Now you cannot declare all the things.
Lord, we have to proceed on the basis of the information received from the banks or the finance institutions.
And Lordship, this writ petition involves questions of facts which can only be tried on evidence whether they owe also from their records they owe us money. So it is not that it can be classified as a settled account.
By the guidelines and by the Supreme Court judgment in Rajesh Agarwal, followed by this one.
This is not a matter where the fraud is
only the thing this Mrs. High is harping upon. As for the submission made, you have made a loss/fraud. If you are going by the fraud, then the procedure is to be followed. If you say that no, it is only the loss, then we have to see what is the loss.
Lordship, there are two things. I'll come back, but Lordship, I have shown that they were aware of the fraud classification. Now that there is a judgment, now that the process says that you have to go by this and this, now today in this proceedings, whether they can challenge that or not.
That's why yes. Has scrapped all the.
This is only to confuse.
Fraud classification, my lord, my learned friend says made in 2012.
Civil.
My lord, they have, my lord, given us a communication of, my lord, payment in 2015. We have made the payment.
They have received that.
Then, my lord, they pursue the matter with, my lord, civil authorities. The question is whether they can do so, and if they do so, whether they can do so without notice to me and without adhering to the guidelines.
Okay, you go through this. This is a very big headache to all.
Well, I'll request my learned friend to indicate what are the provisions they wish to rely on. I will otherwise have to, my lord, go through the entire guidelines and figure out for myself what
the parties have argued the matter at length, but due to paucity of time, hearing could not be completed. According case is adjourned. So this requires some
Yes, yes.
consideration.
Yes, ma'am. Well, if your lordship finds any time, well, before the vacations, we'll be very happy to come back because, well, this is affecting our business. Well.
Keeps it post verification. Only yes.
দেখতেই পাচ্ছি তুমি কি আর্জেন্সি নিয়ে ম্যাটার প্রসিড করছো
जनवरी में रखो कब रखो
একবার বসবে না কিছু না
2 डेट रखो
हमारे टाइम ना
14th and 20 जनवरी 19 नहीं है 14th is Wednesday ना 15 16 भी नहीं है
জানুয়ারি যাবি
14 and 15 na 14 and 16 14th and 16th Jan at 2 p.m. at 3 p.m.
14th and 16th 14th and 16th at 2 p.m. Very well.
Yes.
I'm deeply obliged. Grateful. Hands up. I mean,
Milord, I was addressing your lordship in this matter.
The release with regard to the original site.
Well, I was showing your lordship the statement of claim in this matter. Well, paragraph 35, your lordship will kindly come back to.
Page
318.
18. One.
Yes. 318. My lord, I was trying to show to your lordship what is their case. Is there a case of a contractual breach or a breach of a promise on which they, my lord, say they have altered their position? Paragraph 35. On a meaningful reading of the terms of the WBS 1999 read with subsequent documents and letters of the Government of West Bengal WBTC extending the incentives and the SPA, it will be unambiguously clear that there was a positive obligation and promise undertaken by the government to continue providing incentives to HPL under the scheme. Such promise was in keeping with the spirit and objectives of the scheme, WBS 1919. And well, then, please see paragraph 37. It is important to note that the entitlement of the claimant to the incentives under the WBS 1999 arises from the provisions of the WBS 1999 itself, read with various approvals, promises made in connection thereto. However, SPA contains a categorical representation and warranty that the incentives would continue to be disbursed. Now, my lord, it is a representation. Now, my lord, what is clinching here is, my lord, paragraph 44. And, my lord, this is the positive case with which they come to, my lord, the tribunal. The continued non-extension of such benefits arising out of the WBS 1999, read with the representations and warranties made in the SPA, my lord, kindly mark these words, is in violation of the principles of promissory estoppel on the part of the respondents. Now, my lord, when a party, my lord, positively in its pleadings makes out a case that, my lord, what is, my lord, alleged is a violation of promissory estoppel, my lord, three questions immediately arise. My lord, is this promise which is made to HPL, my lord, which is sought to be enforced, my lord, on the doctrine of promissory estoppel, a part of the contract? Two, is it a part of the arbitration agreement, because the arbitration agreement, your lordships have seen, excludes HPL? Three, who then can enforce this promise, if at all? Four also, my lord, the adjunct to three is, my lord, in which proceeding can this be enforced? My lord, these were all questions raised before the tribunal. I shall show your lordship the tribunal has, my lord, sought to make out a new case for the parties. My lord, two things that are, my lord, very well entrenched in the arbitration laws is, my lord, number one, that, my lord, a party is shackled to his pleadings. He cannot escape his pleadings. You cannot prove a case which you have not pleaded.
That's always.
That's now, my lord, if this is the case that they have pleaded, breach of, my lord, promise, my lord, violation of doctrine of promissory estoppel, which is not a part of the contract, because otherwise question of promissory estoppel would not have arisen. Then, my lord, how can the tribunal find a case, my lord, of enforcement of a contract? Number one. Number two is, my lord, the tribunal, my lord, cannot make out a new contract for the parties. My lord, which is also what your lordship will find is exactly what the tribunal has done. And these are both covered by, my lord, a catena of judgments on the subject. Now, my lord, I will not trouble your lordships with, my lord, much more, except that, my lord, if your lordship sees paragraph 47, my lord, the representation is of the arbitration clause. The SPA also contains an arbitration clause, and, my lord, here, my lord, the arbitration clause is, my lord, clearly, my lord, talks about disputing parties.
Correct.
Now, my lord, there is no attempt also to, my lord, show as to how, my lord, today, in view of, my lord, what is the disputing party and who are the parties to the arbitration agreement, my lord, Chatterjee or, my lord, Chatterjee entities can enforce this, my lord, clause. Now, my lord, please see paragraph 48. My lord, extracted, my lord, 47 extracts the arbitration agreement.
Yes.
Then 48. Upon there being no response from the government of West Bengal and WBITC to the letter of demand on such and such, in terms of clause 19.1 of the SPA set out above, well, this is the arbitration agreement. Claimant wrote to the WBITC stating that a sum of such and such had become due and payable by the said respondents to HPL. Now, my lord, the question is, my lord, can HPL's dues, my lord, really be pursued by the claimants? And, my lord, in view of this arbitration agreement, now, my lord, the representation is, in view of clause 19, which identifies, my lord, the dispute and the disputing parties.
Correct.
My lord, how can they, my lord, today come forward? They have not even tried to explain as to how, my lord, this arbitration agreement would then embrace within its fold, my lord, this dispute. Now, my lord, the respondents have not fulfilled the covenants. My lord, kindly see, let me just read this paragraph. Upon there being no response from the government of West Bengal and WBITC to the said letter of demand on 5th February, in terms of clause 19.1 of the SPA set out here and above, the claimant wrote to government of West Bengal and WBITC stating that on 31st January 2020, a sum of rupees such and such had become due and payable by the respondents to HPL in terms of 11.1D and Schedule 5 of the SPA. Respondents had not fulfilled their covenants, undertakings, assurances, representations made by them in SPA. Well, kindly mark the work language. Not fulfilled covenants, undertakings, assurances, representations made in the SPA, although a period of 195 days had elapsed since the receipt of the said letter of demand. Such continued non-payment on the part of the respondents had resulted in breach of SPA, in particularly clause 11.1D read with Schedule 5. The claimant called upon the respondents to immediately, but not later than 15 days from receipt of the letter, to negotiate and settle the matter amicably. Then, my lord, dispute notice, my lord, etc., etc. Then paragraph 50. In such circumstances, on March 11, 2020, the claimant was constrained to invoke arbitration agreement contained in 19.2. Who invokes it? Well, Chatterjee invokes it, not HPA.
Constraint to invoke arbitration contained 19.2 in the SPA.
Well, Chatterjee invokes the arbitration agreement. Well, with respectfully, well, they could not have, because now, well, the third limb of my argument is, well, the arbitration agreement is specific. Well, it must be confined to the parties who are parties to the arbitration agreement. Chatterjee is not a, well, HPL is not a party to the Chatterjee arbitration agreement. Chatterjee is invoking the clause on behalf of HPL.
And HPL is not even made a party to arbitration proceeding.
And well, interestingly, HPL was not even made a party to the arbitration proceeding.
Have you taken that ground before the arbitrator?
Yes.
Have you taken the ground before?
Yes, 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 yes.
What is the
Yes, yes, very clearly, elaborately. Now, my lord, please see the prayers. We had taken this point at section 16 stage. We had taken this point at the main argument stage, everywhere. My lord, it was, my lord, touching upon the jurisdiction of the tribunal. The tribunal initially, my lord, did not, my lord, countenance this, then said we'll decide it finally.
That's what.
And, my lord, I should show you, lordship, how it has been, my lord, dealt with. My lord, with the greatest respect, my lord, the members of the tribunal, my lord, all were still exercising jurisdiction under 142.
But they were.
Yes. But, my lord, notwithstanding the fact that, my lord, their jurisdiction was substantially curtailed, my lord, after, my lord, their demitting office. Now, my lord, please see, my lord, the prayers now. My lord, please see the prayers. Award declaring that HPL is entitled to receive a sum of such and such towards unpaid incentives. Alternatively, an inquiry.
That happens when I was in the defense side, private side. So I was doing. When I came to the government side, prayer coming to the defense side. Then I have to very careful by making the prayer because it was the habit.
Yes, yes, yes. And my lord, unfortunately, my lord. Anyway, I think it's better not to make any comment here. Then we'll see award of mandatory injunction directing respondents to make payment to HPL. Now, my lord, again pausing for a moment, who then will be able to enforce the award? HPL. Is HPL a party to the arbitration? No. Then, my lord, C, D. Direct specific performance of SPA, directing respondent number 1 to make payment to HPL of the sum specified. And with some other similar prayers, mandatory injunction, etc., all in, my lord, the same line.
We can show the amended SOC.
Now, my lord, this SOC, my lord, once we, my lord, took these initial objections, my lord, this SOC was sought to be amended. Now, my lord, I shall show you, lordship, only, my lord, the amended portion of the SOC, because rest of it is, my lord, same. My lord, the amended SOC, your lordship will find is at, my lord, volume 8. My lord, it starts at, my lord, page
1026.
1026. But, my lord, I shall not show you, lordship, the entire SOC, only, my lord, the amended portion.
Page number?
It starts at 1026, but your lordship may straight away, my lord, come to, my lord, at page 1051. My lord, please, my lord, see the amended SOC also. My lord, the amendments are from paragraph 44A onwards, but my lord, paragraph 44 is retained.
Yes.
And paragraph 44 says, the continued non-extension of such benefits arising out of the WBS 1999 read with the representations warranties in the SPA is in violation of the principles of promissory estoppel. My lord, this is, my lord, not done away. This is retained. And, my lord, what is the insertion made? 44A, as per the SPA read with letter 15th March, and promises made thereby, and thereunder to the claimant by the respondents, HPL is entitled to receive the aforesaid benefits till the quantum of such tax reaches a sum of rupees such and such, 3,285 crores, on and from 1st January 2016 till the implementation of the GST regime, and from July 1, 2017 by the Constitution First Amendment and Acts rules, etc., etc. Then, well, at 44B, on and from July 1, 2017, as per representations and warranties. Well, again, kindly see, representations and warranties made by the respondent to the claimant, HPL is entitled to receive further incentives. 44C, prior to the coming into force of the GST regime, HPL was entitled to remission of VAT, which meant that HPL could charge VAT from its customers without having to deposit VAT with the state. HPL was also entitled to exemption from CST. Then 44D. Upon the coming into force of the GST regime, HPL has not been given remission or exemption from payment of GST. Hence, HPL has been making payment of GST to the state of West Bengal since the inception of the GST regime and till date in order to get the entitled incentives. The only mode of disbursal, now, my lord, this is very, very important because this is, my lord, directly covered, my lord, by... Yes, my lord. My lord, the only mode of disbursal of the same is through refund to HPL of the amount of GST paid by HPL and accruing to the government. My lord, this is what, my lord, the Supreme Court has specifically stated cannot be done. There can be no question of refund of tax, my lord, particularly through this mode. And my lord, now, my lord, so far as this is concerned, my lord, now please see, this is their pleaded case. That they have to be given refund of the tax that they have paid. Now, my lord, so far as, my lord, Amrit Banaspati is concerned, Amrit Banaspati has clearly said that you cannot, my lord, do this. Now, my lord, the law is also very clearly well settled in, my lord, 34 jurisprudence. That, my lord, today, if an award is passed, my lord, contrary to the judgment of a superior court, and the Supreme Court would be superior to the tribunal, although, my lord, by ex-judges of the Supreme Court. My lord, in that case, the award is liable to be set aside. There are three components of GST, my lord. Then it says central GST, state GST, etc., etc. Paragraph 44E. Now, my lord, paragraph 44F. Therefore, the claim of the claimant in the statement of claim is a money award for the amount of SGST accruing to the government of West Bengal, the refund of which HPL is entitled to. And my lord, till then, the sum is 2,963 crores. Now, my lord, there perilously, my lord, no pleading, my lord, as to why, my lord, this refund can be, my lord, had, notwithstanding the, my lord, law on the land at its stands crystallized. But, my lord, at the end of the day, what is the representation? The representation is there's a promise. We have acted on the promise. Please apply the doctrine of promise irresistible. The tribunal is not entitled to do so. And, my lord, they cannot escape, my lord, paragraph 44 and the previous paragraphs, which is their pleaded case. Now, my lord, I'll not trouble your lordship with, my lord, the rest of it, which is same. My lord, please come to the, my lord, prayers. The prayers were amended. My lord, that your lordship will find at page 1057. Well, your lordship will find, my lord, that prayer A was the same. AA was added and AB was added. Award for a sum of 6048529 such and such on account of SGST from July 1, 2017 to 31st May 2020. And then, my lord, a second amount of 47989000544 on account of GST, my lord, from 1st June 2020 to, my lord, 2022. Then prayers C and D were deleted, my lord, which are not really of much consequence. E is retained. Now, my lord, F is modified. My lord, 2F your lordship will find. My lord, this portion was already there. An award of mandatory injunction directing respondent number 1 to make payment to HPL of all incentives as per the SPA for the period commencing from 1st June 2020 in accordance with the SPA by refunding year on year SGST paid by HPL. My lord, this is added. So, my lord, what they're asking is for refund of tax, which is barred.
Yes.
And, my lord, prayer G, my lord, if this is, of course, my lord, originally this was there. Kindly see award of specific performance of SPA directing respondent number 1 to make payment of to HPL of all incentives as per SPA. But, my lord, they say that this is only a promise, only a representation, not contractual. Promissory estoppel applies. My lord, this is, my lord, the pleaded case, and, my lord, the real purpose of showing your lordship the pleaded case was to show that, my lord, it is not their case that, my lord, this was the consideration for the contract for sale of shares. They say this was an additional promise that was made for which the doctrines of promissory estoppel should be applied. Now, my lord, so far as the defense case is concerned, kindly see your lordship wanted to know what is my lord, that the point that we urged, my lord, in defense. I shall just show your lordship a few paragraphs, not all of them. Well, at first page 601. Volume 5, page 601. Paragraph 4.5. Yes, my lord. Just a few select paragraphs, my lord. I don't want to show you lordship more than 5 or 6 paragraphs of the SOD. 4.5. Instead, Essex has alleged that under 11.1D of the SPA, the answering respondents had to pay certain tax incentives to HPL. And since those incentives have not been paid, the tribunal should direct the answering respondents to pay those incentives to HPL. Then, my lord, your lordship will see. So, my lord, we have highlighted the factum that it is tax incentive to be paid to HPL. Then, my lord, 5.12 at page 607. The real dispute, as per Essex, therefore, is about the alleged failure of the answering respondents to disburse incentives in the form of remission or refund of excess GST allegedly paid by HPL after coming into effect of the GST regime. Then paragraph 5.13, it is submitted that it is not possible to disburse incentives under the WBIS 1919 as was available to eligible industries under the value-added tax regime to eligible industries without suitable statutory recognition or without making suitable amendments to the West Bengal Goods and Services Tax Act, this Honorable Tribunal, being a private forum with limited jurisdiction to deal with matters covered by the arbitration agreement, cannot direct amendments to the WBGST Act, nor can it direct the executive to formulate a policy framework or issue notifications to implement the WBS 1990 under the GST regime. The relief claimed in effect and in essence, however, seeks a direction from this tribunal on these very lines which cannot be granted in law. As such, the issue being raised by Essex is not justiciable and certainly not arbitrable. Without prejudice to the above, Essex is seeking to enforce an alleged undertaking of the government or a government agency made in a contract. Enforcement of such undertaking can be made by a command of court and not by an award in a quasi-judicial proceeding. So, my lord clearly said that, my lord, this can't be done without amendment of legislation. My lord, this cannot be done by an arbitral tribunal, and it, my lord, cannot certainly be done within, my lord, the confines of the arbitrator's jurisdiction. Then your lordship will please have a look at paragraph 5.30. The answering respondents further submit that if the interpretation as provided by Essex to Schedule 5 were to be accepted, then the agreement in Schedule 5 and the remission being claimed by Essex for HPL would clearly be in the nature of a refund of tax. Such an agreement in any event cannot be enforced, being void under Section 23 of the Indian Contract Act 1872. But even if this were an agreement, my lord, an agreement for refund of tax is barred by law. I shall show you, lordship, my lord, why it is barred. Because the GST Act prohibits this. And if today there's a prohibition in law, it would be, my lord, a void contract under 723. Of course, they're not saying that it is a contract. They're saying it's a promise. But they're saying it's an enforceable promise because we have altered our position to a detriment. We are saying that no, you have not altered your position. You would have bought the shares nonetheless. My lord, that is the only point of difference here. Then please see 6.16.
So what would happen to the incentive which they were getting prior to the GST?
Well, prior to GST, whatever they were getting, well, we have given them.
That's right. So what will happen after that? What will happen?
No, well, here it is the now the law prohibits the refund. Well, there are two things. One thing is, maybe, for the sake of argument, I have given them an undertaking. Maybe, even for the sake of argument, I would be required to continue that undertaking. Now, if I do not, what happens? Can you go to the arbitral tribunal? Well, if I do not, then you can come to the court. You can say this was a promise made to me. Enforce that promise.
What has happened after the 2017 GST? Have you communicated anything to the?
Well, we have said that this is not payable to you under the present statute, under the present list. And that is what we've also stated very specifically in
when you informed the
they constituted the
tribunal. Well, as soon as they constituted the tribunal, in our response.
No, prior to this proceeding, have you informed?
No, but they wrote to us. They knew. So 16th October letter from them.
Well, there's a letter. Well, I'll just.
Before the proceedings.
Yes, my lord.
When you 1st July 2017, the GST has come into effect.
Yes, my lord. That was done.
When you informed that now the.
Yes, my lord. Kindly give me a moment.
634.
My lord, page 634, your lordship will find.
HPL only writes to us that please amend.
My lord, please see 634. My lord, being conscious of, my lord, the position, HPL calls upon us to amend.
Same volume.
My lord, same volume 634.
Yes, I got it.
My lord, please see, my lord, this is a letter that HPL had written to us. Yes.
Very important letter, sir.
My lord, please, my lord, allow me to read this. My lord, this is being written to, my lord, the managing director of WBIDC. You are kindly aware that HPL has been enjoying benefits sanctioned under the scheme, under VAT regime. You are also aware that the extension of the committed incentives under the GST scheme from July 1, 2017 is under active consideration of the government. However, this letter of mine is to make a special request for your attention on the pending issue of issuance of NOC as mentioned in the subject of the letter to the Directorate of Commercial Taxes. To explain the context, while sanctioning incentives under the WBIS 1999, WBIDC had stipulated that before issuing eligibility certificate every year, the Directorate of Commercial Taxes would have to obtain a no overdue on loan or interest certificate from WBIDC. Consequently, every year, while renewing the eligibility certificate, EC for the incentives, the Commercial Tax Department obtains the NOC from the WBIDC in this regard, and WBIDC has been issuing such certificates every year, based on which the Commercial Tax Department was renewing the EC to HPL. For renewing the EC for the years 2017-18, Commercial Tax Department has, like in earlier years, sought the NOC from WBIDC. However, in spite of repeated follow-up, NOC has not been received by the Commercial Tax Department till date, as a result of which they have not been able to renew the EC for 2017-18. The effect of is that in the absence of the EC, the VAT and CST assessment to HPL for 2017-18, a tax liability of 44 crores plus interest will devolve. Issue has become acute since the assessment of 2017-18 will become time-barred by 19 September 2019, and so the Commercial Tax Department cannot wait any longer period for the time for NOC from WIDC and will have to issue the assessment order. Therefore, I would request the NOC, as required by the Commercial Tax Department, is issued immediately within the next 2 days. I understand from my finance department that there is no overdue loan or interest to WBIC, etc., etc. Now, my lord, please see, now, my lord, the next letter.
That was the 2019 letter. This is
My lord, now, my lord, this letter, my lord, is 2019, September 12, 2019. Now, my lord, see.
3 months after the GST regime by HPL.
My lord, this is 2019. My lord, immediately after the introduction of the GST regime, my lord, the letter that is relevant is at page, my lord, 634.
Yes, that is 16 October.
Yes, my lord. And my lord, that says
That they have requested for sanction of the incentive,
my lord,
which has been enjoyed
my
by
lord,
the
second
HCC.
paragraph. I am writing to you to now bring to your notice that in the process of migration to GST, incentives under the scheme, which had been given legal force through various provisions in the West Bengal VAT Act and CST Act, have unfortunately not been given statutory effect under the state GST law.
So they acknowledge.
So, my lord, they know about it.
They know
That
about
the state GST law does not permit this.
And then
That's why
last
the
paragraph.
635 last paragraph.
Yes, madam.
They have requested to kindly move the
Yes, madam. I am grateful.
department to for proposal of the sanction continuation.
Now, my lord, the only question is, my lord, whether, my lord, this, my lord, they are manifesting as a right under the contract, or they're saying that you had made a promise to us, please keep up the promise. And, my lord, I repeat myself at the cost of repetition. My lord, if it was, my lord, a part of the contractual obligation for buying and selling of shares for which consideration is determined, then of course the tribunal could have exercised jurisdiction. But, my lord, when it is a matter of tax incentives, a matter of refund of tax, which is barred by law, and, my lord, it's a matter of, my lord, making a policy decision available, my lord, to amend the state GST Act, my lord, can the, my lord, tribunal direct it? And, my lord, can the tribunal overlook the pleadings which says that I am invoking the doctrine of promissory estoppel?
And
My lord, cannot be done with the greatest respect.
And when HPL wrote this letter to us in 2000, they don't refer to the SPA.
Okay.
Yes.
And my lord, HPL's letter also does not say that it's a contractual obligation. Please perform. They only say that this is a scheme. We were enjoying under a scheme, not under a contract. We are entitled under a scheme, not under a contract. My lord, paragraph 5.30, your lordship was seeing at page 611. Answering respondents further submit that if the interpretation as provided by Essex to Schedule 5 were to be accepted, then the agreement in Schedule 5 and the remission being claimed by Essex would clearly be in the nature of a refund of tax. My lord, this is not permissible. This is void under Section 23. Clear case made out. Now, my lord, then, my lord, your lordship will see 6.16 at page 619. In this regard, it is also submitted that the GST regime provides for a comprehensive statutory mechanism for dealing with disputes. Both the Central GST Act and the State GST law provide inter alia the power to levy and collection of GST, power to grant exemption, eligibility and conditions, adjudication of disputes.
Yes.
And, my lord, we say here very clearly, my lord, then, my lord, it is dealt.
162. So this one, 162.
Please see, my lord, please see paragraph 6.17 also. Furthermore, I'm sorry, this is very important. I should have shown it to your lordship. Furthermore, section 162 of the WBGST Act and the Central GST Act expressly bars the jurisdiction of civil courts and by extension an arbitral tribunal to deal with any matter under the WGST Act. Section 162 provides, save as under as provided in section 117(18), no civil court shall have jurisdiction to deal with or decide any question arising from or relating to anything done or purported done under the Act.
Tax matter.
Animal 6.18, in these premises, in the garb of enforcement of alleged contractual obligation, Essex is inviting the tribunal to pass an award, impermissible in law. But, my lord, it is not even their case that they are enforcing a contractual obligation.
Yes.
Now, my lord, it is in this background that, my lord, your lordship will now have a look at the award. My lord, these are the pleadings of the parties. Now, my lord, if your lordship will now see the award, well, this is at volume 2 at page 107. It's a very, very voluminous award, but my lord, I shall start with, my lord, the paragraph 1. My lord, please see, my lord, page 110. My lord, please see parties to the dispute. My lord, this is very, very important. The claimant Essex Development Investment is a Mauritius-based company, etc., commonly known as the Chatterjee Group. Another important company associated with TCG is Chatterjee Petrochem. Essex is an investment holding company which presently holds 15.40% shares in Haldia Petrochemicals. Then, my lord, respondent number 1 is the government of West Bengal. And, my lord, throughout this arbitration, claimant Essex has been represented by such and such. Haldia Petrochemicals 4 has not been impleaded as a party to the present arbitral proceedings.
Yes.
Now, my lord, then, my lord, there's a bit of a background that is, my lord, reproduced here about Haldia and who were the shareholders, how it, my lord, faced a crunch. And, my lord, then the claimant's case is, my lord, represented here. I'll not trouble your lordship with the claimant's case because, my lord, what is represented in the award, my lord, cannot ultimately, my lord, overwhelm the case pleaded. My lord, I shall just show your lordship, my lord, a bit of, my lord, this pleaded case. My lord, these are, my lord, historical facts, my lord, which I'll not trouble your lordship with, except that, my lord, your lordship will please see paragraph 11 once. Well, towards the middle of the paragraph, your lordship will find that, my lord, a broad understanding about 10 lines from, my lord, the top of the paragraph, paragraph 11, it was also highlighted. Yes. It was also highlighted by the learned counsel for the claimant Essex that a broad understanding was reached between the parties before the SPA of 11 September 2004 was executed that TCG would purchase 520 million shares. Now, my lord, please mark this, for purely commercial reasons. These shares were to be purchased by TCG at a price of 25.10 per equity share. Price has been discovered through a transparent and competitive bidding process. Total consideration for purchase of 520 million shares was settled at 1,300 crores, 60 lakhs. In continuation of the offer of 520 million shares HPL to TCG, it was understood TCG would bring an end-to-end legal proceedings, etc. And, my lord, please see the next line also. The understanding narrated above reveals, according to the counsel for the claimant, Essex, that it was clear to the parties that after execution of the share purchase agreement, CPMC would be in effective management and control of the company. So, my lord, here there is an admission to the effect that the purchase of shares was purely for commercial reasons and it was at a discovered price. End of the contract for purchase and sale of shares. Contract specific, consideration specific. Now, well, so far as this is concerned, I'll not trouble your lordship again with the later part of it. Well, that is, well, again, narration of facts. Well, now your lordship will find, well, the shareholding position is represented. It is largely, well, set out from the statement of claim. Now, my lordship will see Schedule 5 is, well, referred to. Now, Schedule 5 is represented to be a part of the contract. Now, with the greatest respect. Well, the contract is a contract for purchase of sale of shares, that's admitted. Consideration is admitted. Schedule 5, my lord, has been stated in the pleadings to be a part of representation and warranty. Representation has been understood, my lord, not to be a part of the consideration for the sale of shares. It has been clearly understood as a promise. For whatever reason, an independent promise under a scheme. And my lord, that scheme is not, my lord, made a part of the contract by the own pleaded case. It is said that, my lord, it is, my lord, a promise which we are entitled to enforce, not qua contract, my lord, but on the basis of the doctrine of promissory estoppel.
So as per your submission, the Schedule 5
Yes.
is not the part of the contract.
No, well, and very clearly not. My lord, contract, my lord, transaction is defined. Consideration for the transaction is defined. This is admitted, my lord, in paragraph 15, which I have just, paragraph, my lord, of this, yes, paragraph 11 of the, my lord, award. Schedule 5, consideration. No, not a part of the contract. Well, Schedule 5 is not a part of the contract at all. It may be a part of the contract document. But, my lord, what is the contract for? The transaction is what is the contract. Transaction does not include, my lord, incentives. Incentives, my lord, cannot be a part of a contract. It is a part of a government policy. And, my lord, what have they said? That this is a representation. They said, yes, yes, you buy the shares, we'll also give you the incentive. But, my lord, they say that they have bought the shares at the discovered price for purely commercial reasons. My lord, these are very important words. So, my lord, if they have bought the shares, my lord, at a discovered consideration for purely commercial reasons, then they have to show as to how, my lord, this became a part of, my lord, the contract. My lord, that is why they have said that, my lord, the pleaded cases, that but for this promise on which we acted to our detriment, we would not have purchased the shares. And that is why we are entitled to enforce this promise through the doctrine of promissory estoppel. Now, my lord, when they say that, my lord, they are, my lord, now shackled to their pleading. And, my lord, when they say that this is a promise, and, my lord, they said, but for the, my lord, promise, I would not have purchased the shares, my lord, that is undone by their own admission. And the recording in, my lord, the statement of claim and in the, my lord, as recorded in the board, that this was bought only for commercial reasons. My lord, this is, my lord, clearly the case. Now, my lord, today, your lordship will see how, my lord, this case has been, my lord, ultimately, what would I say, my lord, for want of better expression, my lord, mutilated in the course of the reference. My lord, because a completely new case is made out, my lord, dehorsed the pleadings of the parties. A completely new case is made out, my lord, dehorsed the admission that this is not a part of the contract. This is a promise, my lord, which they are estopped from resiling from.
Okay.
Well, your lordship will have to, my lord, fix a few more dates. I don't know, my lord, whether your lordship will find time before the vacations.
For vacation, I don't think. Counsel for the petitioner has but due to paucity of time, hearing could not be completed. Fix on.
Okay. Earliest possible, my lord.
Before
Earliest, my lord, whenever, my lord, I know, my lord, but perhaps.
Yeah.
Sir, Wednesday, Thursday, Monday. So that's my thing.
9th January at 3 p.m. 7th January 3 p.m.
Well, can we just avoid the 9th? Well, 9th I'm in Bombay. Only when the 7th, 8th, 9th,
January.
10th January, yes.
7th January 3 p.m.
10th is a Saturday.
7th,
yes.
7th
No,
January 3 p.m.
7th, 8th and 9th, well, these 3 days I'm in Bombay.
Yes.
Our anxiety, my lord, is obviously not much more than Mr. Shah, but not anyway.
12th January 3:45.
Well, sure.
Yes.
12th
Then
would be a
it will
holiday,
be
my lord.
holiday. It will be holiday.
12th can?
Swami Vivekananda's.
Oh.
You're choosing either the holidays or the days when you're not there.
No, I have not chosen it. The court has chosen.
Tell Mr. Banerjee the date then.
But I 13, 14, 15. How many? 21st.
27th Supreme Court लग जाएगा Wednesday,
20th,
Matlab,
21st.
can we, matlab, is it possible to do it on matlab, the 19th? I mean,
20th.
20th.
20th, 21st, Dr. 21st,
Wednesday
20th,
avoid
21st.
21st, 20th, ले लो, उसका Friday ले लो. Just avoiding Wednesday and Thursday.
20th.
20.
Matlab, may I request, matlab, it's only a request, matlab, 20th and 23rd, is it possible?
23rd is a holiday. I mean, you want to always work on
23rd holiday.
Oh,
do 20th, 21st.
21st, it's Wednesday and Thursday is Supreme Court.
What's everything? We'll avoid
Ek din
when
dekh
will
lo.
he come
Ek
here?
din dekh lo. Yes, matlab, 20th, 21st, very well.
21st.
21st?
No, 21st and 22.
Yes, very good.
20 and 22.
20 and 22.
At 3:45.
Very good.
May I permitted
May I
to mention?
minus kindly very well, Mila, the physical mention.
May I permitted to mention one appellate side matter item number 20. At that time of I was as well as my senior engaged in another court. Posted that matter in the monthly list of journal. Instead of that, kindly make it not today, because he prayed that because the urgency is that that matter relating to MG and Rega, the contractor not getting the their dues long back, and for that reason day to day 4 to 5 suicidal incident happened. It will be kind enough for this reason. Mr. Bhattacharya came from Delhi. It will be kind enough. Posted it tomorrow. It will be kind enough. Item number in appellate side list. Item number 20. It will be kind enough. Just make it not today.
Minus kind leaves Mila to mention item number 146. Mala, the interim order is expiring today. Malad can extend the interim on 18th of November. Malad had extended. Malad, this is that matter which was released at 4:30 p.m. by the another coordinate bench. Malad, the matter was assigned before your lordships. Malad.
Who is for the other side?
Lordship,
I have given notice. Malad.
It's point number 4, your
I have
lordship.
given notice. Upon mentioning upon notice. Malad.
So the matter is listed as
Number 2.
item number
146.
146, your lordship.
But the land counsel for the petition submitted the interim order is only till today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, till 15th of January 2026 or until further order, let the matter remain in the list.
Pilot has been changed to
50.
Matter remain in the list. I think interim order.
Very well. Till 15th. Very good. Very good. Obliged.